Good morning. Good morning. It is trial day 29 of the Commonwealth versus Karen Read. We are mobile streaming today. It's Friday. It's June 21st. I can't imagine that this is anything but the Commonwealth's last witness. It seems that they've saved the medical examiner for last. Yesterday, we saw the beginning of the ME's testimony. Then they were going to get into the autopsy photos. Those should not be shown to the public, but those will be shown to the jury. I don't know why the judge decided it was better to do that first thing in the morning instead of at the end of the day, but I don't understand many of the things this judge has chosen to do. Today was supposed to be a half day, but it's going to be a full day, but I bet it's probably not going to be a full day. So we're going to just have to see what happens in court today as we get rolling. So thank you for your patience with the mobile setup. It's good to see you. And look, you can see me. You can probably see court. You can hear me. We're just going to do the best that we can because that's really all that we can do. So law nerds, are you ready to go to court? I'm ready to go to court. It's just, are we at the end of the state's case today? Does the state rest today? And if so, I think we only have 4 or 5 witnesses from the defense. And if that's the case, this jury may get the case on like Wednesday. Well, fingers crossed, y'all. Let's roll to court and I don't know, just see what unfolds today, because it's not predictable. And if I'm a little slower pulling up chats, it is just the nature of mobile streaming. So let's roll.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
You know how much I love the hear ye's in Massachusetts. So you know what it's time for?
Bring the jury.
And we've got a little bit different setup on how we see court.
Hear
but
ye, hear ye, hear ye.
We can hear the hear ye's.
Anything due before the Honorable Beverly Cannoni, the Justice of the Superior Court.
I just want to move the closed captioning.
Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Just trying to move the captions. The judge is going to ask all those things that the judge asks.
Jim?
We're going to speed you up,
22117, the Commonwealth versus Karen Read.
Good morning, lawyers.
All right. Good morning, counsel. Good morning, Ms. Reed.
Good morning, jurors.
I have to ask you
those same 3 questions.
Are you all able to follow the instructions and refrain from discussing this case with everyone since we left yesterday? Everyone said yes.
Why won't my...
Were you also able to follow the instructions and refrain from...
Now we're good. You guys let me know what you're coming in from, what you're drinking. Let's gain this audio up a little.
Anything about this case since we left here yesterday? Everyone said no.
The second she steps away from the mic, you can't hear her at all. There we go. All right, so we are resuming with the medical examiner, and that's, you know, we love a spinning wheel first thing in the morning, but that's fine because we're zooming until she resumes testimony. Let's see if they ask her again about signs of a fight. We heard that yesterday, and she said no obvious signs of a major altercation. So there was a little bit of couching in.
Whenever you're ready, Mr. Lally. Good morning, doctor.
So
Good morning.
Morning, Doctor.
Good morning.
Kim, I'm in Wisconsin too.
Questions, just turning back a little bit from what you were testifying to about yesterday. You had mentioned in your testimony yesterday,
or at least I'm fairly confident I'm in Wisconsin.
Received some, in addition to the internal and external examination that you conducted, Mr. O'Keefe.
What, if any?
You received some other material that you had reviewed, correct?
Correct.
Now, included within that material was some material from the state police as far as the investigative agency investigating.
I wonder,
correct,
if he's going to ask her
is that typical? Is that
about
normal,
text messages with Trooper Proctor, or
sort of
pressure from Trooper Proctor.
In general terms, as far as what, if any, communication would you typically have with the investigating?
Lally, that question is 100 words long. He's just asking what information do you normally get from law enforcement?
In Massachusetts, under Massachusetts law, the medical examiner's office is responsible, and our role is to determine the cause and manner of death by doing an autopsy. The scene, or the scene of death, or the place where the decedent is found, is controlled by the district attorney's office, and state police will do an investigation. When we accept a case into our office, we request reports, police reports, to explain and describe the circumstances of the death. It could be a house. It could be
I don't.
somewhere
William,
else.
I
It
don't
could be
think there
outside.
should be any other testimony.
Every
but we'll
case
see.
comes with a police report, and we
You
review
never
that
know.
police report. And if we feel that we need more information, then we contact the investigating body and ask for more information. Again, depending on the case.
That's
And
not
specifically in
uncommon.
this case, in regard to Mr. O'Keefe, did you
Happens
reach out to get
In
some
every
more information?
case.
I did reach out, yes.
Was that in part in relation to what you were talking about in your testimony yesterday, as far as the diagnosis of hypothermia and trying to sort of better understand the circumstances?
Sustained.
Why did you reach out?
I reached out because
Who's leading?
when the case was presented to us, and after I did the autopsy, I did not have all the information that I needed in order to certify the manner. The cause of death to me
Does anyone feel like we have all the information
was
we need?
I was able to determine
Anyone?
the cause of death from the autopsy.
What, if any,
When an
information
event
that
is
we need do we have?
unwitnessed, we usually reach out to the investigating agency and ask them whether they have any more information than they did on the day that the autopsy was done, because investigations sometimes take some time. So in the days and the weeks following the autopsy, I reached out and asked if there was any more information than what I was originally presented with. Was there any video from the surrounding areas? Did anybody come forward to say that they actually witnessed whatever happened? Again, by the time I was ready to finalize the case, and we have approximately 3 months or 90 days from the day of the autopsy until we issue a report, I was not provided with enough information for me to be able to determine the manner.
Now, Doctor, do you
I don't
recall
know if
specifically
anybody
who
has
it was that
been.
you spoke with from the state police?
Yes, I documented that I spoke with Trooper Proctor, I believe, twice.
And with reference, not asking you anything as far as what that conversation consisted of, but as far as the tone of that conversation,
Good to see
did
you,
you feel
Tinsley.
pressured or coerced to come up with a certain determination?
He did ask.
No, I did not.
And
He did ask.
even if you had been, what would your response have been in reference to that?
Lol.
My response was that I am responsible for what goes on the death certificate, and
Respectfully,
unless I
fuck
have
off.
enough information, clear and convincing evidence, I cannot determine a manner.
Did you?
Yeah.
Clear and convincing is not the same standard as beyond a reasonable doubt, but this ME saying, with everything I had, I still don't have clear and convincing evidence of what happened here, can't be what they're anticipating from the ME. But she's like, look, this is my job. And if I don't have enough information, I don't have enough information. If I don't have clear information, then that's what it is. So, yeah, it's interesting that she feels that she did not have clear and convincing information.
Yes.
So, wow. But it's her job. I mean, I'm not surprised she stood up to law enforcement. It's her job. She's not gonna listen to what they say. She's gonna ask them what information they have, and then the body makes its determination. She's not gonna risk her career
5 photographs that I
for,
gave
you know,
you recognize those?
somebody else. And she is witness 68. So
Yes, I do.
chat,
And
for
what do you
those of you
recognize those?
hoping
I recognize these as
that the
photographs of
state would
Mr.
hit
O'Keefe's body.
69 witnesses,
I
don't
believe
think
these
we're
were
gonna-
taken at the hospital.
I don't think we're
One
gonna
of them
make it.
is a photograph taken at the time of autopsy.
I bet the
Can I approach
defense
you
is
now?
going to use her as their own witness, right?
Ms. Little? No objection, thank you.
If they even ask her any questions, which I imagine that they will. But if I'm the defense, given what she has said, I'm saying, so it wasn't clear to you what happened. It's not clear to you this, it's not clear to you that, it's not clear to you this. Oh no, it's too early to not be zooming.
Thank you very much.
Yes.
Can you Lally, can you not? Thank you. Did you see how quickly the cameraman caught that Lally's just flipping through autopsy photos up at the podium? Well done to the cameraman in court. This cameraman has been particularly on it with keeping things off screen,
Your Honor,
Photographs, okay.
and that includes the defense's table.
Ms. Gilman, if I could have photograph 2853. Doctor, do you recognize what's up on the screen?
Yes, this is a picture taken of Mr. O'Keefe's body.
And Doctor, if you could.
These will not be shown.
That you have there direct jury's attention to what, if anything, you observe of significance in this photograph related to the injuries that you were testifying about this.
Yes, so first thing you notice is the medical intervention, which I talked about yesterday. There's defibrillator, adhesive pads on the chest. There is what's known as a C-collar, a cervical stabilization collar for the neck, and he has been intubated prior to going to the hospital. The injuries that are obvious in this picture include the abrasions on his right forearm and arm. And you can see here, there is discoloration of the upper eyelid of the right eye with some blood that's dripping. That's the orbital or supraorbital ecchymosis that I described before with, we're too far to see the very, very small laceration that is present there, but that's what's causing the bleeding.
And it's going to like that photograph 2857.
Some of these photos are in filings and what have you. We've seen the photos of the arm.
Yes, this is a picture of the abrasions that I described in my report, posterior upper arm and forearm. You can see that they have some sort of pattern to it. Anytime we see a pattern, we try to document it as best as we possibly can.
And that, when she's talking about the upper arm abrasions, she is talking about those scratches on the arm.
That play as far as your determination as far as cause of death.
We did this yesterday, Lally.
These are superficial abrasions to the skin. They are not lethal. They're not contributory to the cause of death. The trauma that I observed on the head along with the hypothermia
if the
are
like
the two
then they're
factors contributing to his death. These are present, they're noted, they're described, they're photographed, but I do not know how they came to be, and I did not contribute them to the cause of death.
So I saw a couple of you asking why I think John's brother sits there. I think he wants to look at Karen Reed, and if he sits at the other end, he can't see her.
Yes, this is a photograph of Mr. O'Keefe's right hand. This is the dorsum or the dorsal aspect of the hand as opposed to the palm. And you can see that there are some contusions or bruises. There's a larger one here and two very small ones here. This particular contusion has two pinpoint
like they were trying to start an IV.
Defects associated with it. I believe this could be due to attempts at gaining IV access during the many attempts of resuscitation, but I cannot be absolutely sure.
Ms. Gilman, if I could have a photograph from 865. And Dr. Scordi-Bello, if you could, again, using the way to point direct jury's attention to what, if anything, of significance you note in this photograph.
Again, this is a slightly closer view of Mr. O'Keefe's face. You can see the discoloration, the ecchymosis on the right eye with a slight amount of bleeding. You can see here that there's also some discoloration of his left eyelid.
And doctor, with reference to the other injuries that you were testifying about yesterday, as far as the small cuts or abrasions or lacerations.
So part of the reason that might have bruised is because they were doing a lot of CPR.
I can't hear your question. If you could just repeat it and a little louder.
That's going to keep blood moving.
With reference to this photograph, as far as your testimony yesterday in regard to the other smaller injuries around the nose and eyes area of Mr. O'Keefe, are those visible in this photograph as well?
You can see some discoloration of the nose, but this is not a very good picture of it. I think there's a linear abrasion on the left side of the nose that I described, and it's probably this.
Ms. Gilman, could I have photograph 2877? And doctor, if you could, again, using the laser pointer direct jury's attention to what anything significance you observe in this photograph?
Yes, this is a view of the left side of Mr. O'Keefe's face. You can see the discoloration of the left eyelid, and now you can see this linear abrasion on his nose and a small abrasion more towards the middle of his nose.
Ms. Gilman, lastly, from this set, if I could have photograph 9488.
Miss Mandy, thank you so much for the super chat. Don't worry, we're not giving up Dave time. Concerts tonight. We're all good. We're all here together.
This is the laceration to the back of Mr. O'Keefe's head. You can see this defect here. It's ragged. It's a typical classic blunt impact injury, and you can see the abrasion, the scrape that is adjacent to it.
Thank you, Doctor. Ms. Gilman, you can take it.
For hot beverages, Kyle, the travel mugs
Thanks.
are, the tumblers are truly made for
Now,
cold beverages with the straw.
Doctor, with reference to
The travel tumblers.
what you were testifying yesterday as far as the subscapular bleeding, the bleeding under the scalp, was that more or less prominent on one side versus the other side of Mr. O'Keefe's scalp?
Yes, it was more prominent under that laceration that we just looked at.
And so would that be more prominent on the right side? Is that correct?
Yes.
Now, you testified yesterday about
Crazy
blunt,
70, I'm sorry, I
objects,
don't understand the
injury
question.
In relation to the injury to the back of the head, then leading to the fractures and the bleeding in the brain, correct?
Correct.
And then further leading to the ecchymosis, is that correct?
In the eyes, yes.
Now, that blunt object, what, if anything, can you say about what that blunt object would be?
Anything?
Any blunt
that's
object.
blunt?
Now, from your training experience with reference to
gonna make
number of
anything that's
autopsies
blunt,
and
Lally, like
examinations
not
that you've
stabby.
done over the years, would that blunt object, the possibility, include the ground, especially if it was frozen ground?
Objection. Ask the question differently.
The injuries that you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
That's not the answer Lally was looking for.
The arm injuries that
She does not look. Listen to this answer one more time. I'm going to see if I can gain this up just a little bit more. That was not a very strong, it's possible. That was a, I mean, kinda, sorta, maybe. Oof.
you conducted over the years, would that blunt object, the possibility, include the ground, especially if it was frozen ground?
Objection. Ask the question differently.
The injuries that you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of
I don't
metal?
know if possible's going to get you there,
possible.
Lally.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
Oh.
They're not the classic pedestrian injuries that we observe. No.
And definitely as far
Wow.
as when you say classic,
When your Emmy's testimony is, this is not typically what we see with a vehicle pedestrian collision. How are you at trial? How are you at trial? Is this why the Emmys last? Because wow, Lally, just, did you know that this was what her findings were? How are we here for 8 weeks, 9 with jury selection, 29 days of trial, and the Emmys testimony is, these are not our classic signs of pedestrian vehicle collision. I'm backing it up just a little bit so I can take
arm injuries
notes.
that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe. No.
And to that point, as far as when you say classic, as far as a pedestrian collision is concerned, you've conducted autopsies on a number of different pedestrian collisions over the course of your career. Is that correct?
Yes, I have.
Do they all sort of mirror each other? Is there
That's what I would start with on cross.
Disparity depending on how the person interacted with the car.
Objection. Sustained. Watch the form, Mr. Lally.
Yeah, leading
What are they
AF,
doing?
Mr. Lally.
Are every injuries from a pedestrian collision the same?
No.
And why not?
It depends on many factors. It depends on the position of the body, of the pedestrian or the person being struck. It depends on whether they are moving or standing still. It depends on the speed of the car. It depends on whether brakes were applied or not. There's a lot of factors that come into play.
Would another factor be sort of the shape of the vehicle that strikes a pedestrian?
Really?
That's also possible. Yes, that's a factor.
And the speed.
Did you have occasion to see any photographs, or have you seen any photographs in relation to the defendant's vehicle in this case?
I have seen photographs, yes.
And the size or shape of that vehicle, what, if any, significance did that have to you as far as your examination?
Good morning, Octo.
I'll allow it.
When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs, because in the majority we see injuries to the legs from the
Right.
bumper of the car. Again, depending on the kind of car, the size of the car, and the height of the bumper. So in Mr. O'Keefe, I did not see any injuries in the lower extremities. And looking at the car, I did note that it was a much bigger car with much higher, I would say much higher tail light bumper. It was not a sedan or a car that's low to the ground where the bumper would be at the level of, let's say, the knee, or slightly above or slightly below.
Wow.
And again, I believe yesterday in your testimony you indicated that the skull is a pretty thick bone. Is that correct?
Yes.
Sustained.
With regards,
Millie P, have fun
to
at the
thickness
Celtics
of
parade.
The skull bone. What, if any, significance, or what if anything, you say as far as the type or amount of force that would be necessary to cause the fracture that you observed?
Objection. Overruled.
I would consider the amount of force to be significant, again, without being able to quantify it.
Right. You need a biomechanical engineer.
I have a
I
moment,
said that
John.
weird.
Yes.
May I have a moment, Your Honor? I don't know how to fix this. Your Honor, what are we going to do? Oh,
Now, doctor, from the internal and external examination.
and yes, this is still at
that you conducted in regards
1.25.
to Mr. O'Keefe, as well as the other materials that you reviewed, were you able to come to an opinion to a reasonable degree of medical certainty as to the cause of death of John O'Keefe?
We've heard it
Yes,
17
the cause of death
times.
was due to blunt impact injuries of the head and hypothermia.
Thank you, doctor.
He's done.
Your Honor, I have no further questions.
Wow.
Cross-examination?
Well, that didn't clear much up, did it?
Good morning, Dr. Scordi-Bello.
Good morning.
Ms. Little, keep your voice up.
Absolutely. You testified regarding a number of injuries that you referred to as blunt impact injuries, correct?
Yes,
And to be clear, blunt impact injuries are a very, very large category that includes contusions, lacerations, abrasions, and fractures.
correct.
And you testified similarly that a blunt object can also refer to a large range of objects. Is that right?
Yeah.
Correct.
Not
And I think
stabby
yesterday
and
you gave the
sharp.
example of a microphone being a blunt object.
Correct.
It could also include something like a baseball bat,
Correct.
a dumbbell,
Could be.
the ground,
Yes.
or a German Shepherd's claws.
Claws. Possibly, yes.
You'd agree that John O'Keefe had a number of blunt impact injuries on his face, on his head, and his right arm.
Yes.
Besides his right arm, which we'll discuss in a second, taking his body from the neck down, he did not have any significant injuries.
From the neck down. Not significant, no.
Let's take those one at a time. No injury whatsoever to his shoulders.
Correct.
No injuries whatsoever to his chest area, aside from sort of the CPR-related injuries that you discussed.
Yes, correct.
And that was in the sternum. Is that right?
It was in the ribs, just adjacent to the sternum, yes.
Okay. No injuries to
cold.
his torso, other than that.
No.
No injuries to his back.
No.
Right.
No injuries to his hips.
Correct.
No injuries to his pelvis.
Correct.
No injuries to his thighs.
To his,
Thighs.
no.
No injuries to his knees.
Correct.
No injuries to his shins.
Correct.
No injuries to his ankles.
Correct.
No injuries to his feet.
Right. This is
Correct.
their closing.
From the neck down, he did not have a single
They're going to
broken
make all
bone,
of these
again, aside from
arguments.
those CPR-related injuries you discussed, correct?
That's correct.
Not a single fracture.
Right.
Other than CPR, correct.
And you spoke earlier about how the bumper was a little higher than on, say, a regular sedan, correct?
Correct.
And so usually in a pedestrian collision, you would see injuries to the knees. Is that right?
Objection.
She said lower legs.
Depending on the kind of car, depending on the speed, depending on the height of the individual and the car, you might see injuries to their lower extremity. Yeah.
But in this case, you didn't see any injuries to his thighs, to his pelvis, anything even at the height of the bumper. Is that correct?
Correct. A very minor abrasion to the side of his right knee.
So surely you'd agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a 7,000-pound vehicle at 24 miles per hour and being projected 30 feet.
Objection.
Sustained. Break it down, ask it differently.
Whether you agree that John O'Keefe's injuries, are, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour.
I would say it's
Unlikely.
likely and unlikely at the same time, depending on the
What?
position of the body and the vehicle in question.
What does that even
Well,
mean?
Let me give you a hypothetical. Let's say the person were standing with their arm like this.
Like, what
and
does
they were
that
struck
mean?
by the rear taillight of a vehicle at 24 miles per hour.
Likely
Would you
and
agree that his
unlikely at the
injuries are
same time.
inconsistent with that scenario?
Objection.
Sustained.
Maybe approach, Your Honor.
Sure.
All right, we're going to zoom as they approach. Likely and unlikely at the same time. All right, we're zooming through
Would you agree
sidebar.
that John O'Keefe's injuries to his arm, let's start there, are inconsistent with
I think the court found it compound. Chad, I see you guys asking to slow it down to normal speed. This defense attorney is not easy to hear. I've got the audio gained up literally as high as it will go. So we're just going to keep rolling.
having been struck by a vehicle at 24 miles per hour and then causing him to spin around and be projected 30 feet.
Okay, so you need to break it down.
Yeah, that's the thing. She doesn't really have to, though.
Would you agree
It's a medical opinion.
that
She's
John
the
O'Keefe's
defense.
injury to his arm are inconsistent with having been struck by a vehicle at 24 miles per hour?
I don't know. I am not a reconstruction expert. I'm not a biomechanics expert. I
Boom.
never personally inspected.
Excuse me, Your Honor. Excuse me, Your Honor. A biomechanics expert would be the appropriate person to ask about that. So maybe you let the biomechanic experts testify, Your Honor. Maybe you just stop fighting. I think the judge now has credible evidence that that's who's needed. Even though the judge said she was letting those witnesses in, she said she wanted to limit some of that. I think the words of the state's witness just gave the defense a ton of room to argue that the court's restriction on the biomechanical engineers is dumb. So we will see the defense using these statements from the ME to argue this is why it's appropriate testimony, because the court was trying to limit that testimony. It's not I see a lot of you saying door open. It's not a door open issue. The court was trying to limit that testimony, and I think now they have room to argue that that testimony legally should not be limited because the ME agrees that it should not be limited. Let's continue.
The car, so I can't offer an opinion on that.
You did examine John O'Keefe's arm, correct?
Yes,
You observed no significant bruising,
correct,
no fractures,
correct,
and no broken bones.
correct.
I'd like to talk about the injuries to John O'Keefe's face. You testified that Mr. O'Keefe had a laceration on his right upper eyelid.
Correct.
You also described multiple abrasions on his nose.
2, yes.
Although these injuries may not have been the ultimate cause of his death, you'd agree that less severe injuries can still be very important in interpreting the manner or the context in which that person died, correct?
Correct.
And in furtherance of that, you've been taught that when doing an autopsy, details matter,
Correct.
no matter how small.
Correct.
And that's one of the reasons as a medical examiner, you have to notate every single injury you find on a person. Is that
Correct.
right? If I could show you.
Are they saying
Yeah,
there's
for
something they
China.
didn't
Yes.
document?
Show Mr. Lally.
We're gonna zoom. I'm trying to drink greens.
At the time of autopsy.
With your autopsy.
So these are the
Yes,
autopsy
it was
photos taken
taken,
at the time of autopsy.
At the time of autopsy, after the face was cleaned.
Move to admit.
I'm sorry, after what?
The face was cleaned up.
Okay.
I move to admit, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay.
Did he not put in all the autopsy photos then? I guess not.
Permission to publish?
Yes.
I'm
Are these the facial injuries?
I don't know why I'm still
testified to
waiting
earlier?
for things to become
Yes.
more clear, but I am.
And could you kind of describe in that photograph what injuries you observed to his face?
The orbital ecchymosis on both eyes, the small laceration to the right eyelid, the abrasions on the nose.
And you testified that the injuries to his face were also the result of a blunt force trauma.
Correct.
So that's the laceration to the eye and the 2 abrasions that we see there on his nose.
Correct.
And you agree that those injuries don't just manifest out of nowhere, right?
Absolutely.
They have to originate from something.
Yes.
Would you agree that his injuries to his face are consistent with having been punched?
That is a possibility.
The problem is there's too many possibilities, right? When too much is possible, that's just kind of
Your
the
internal
definition
examination
of
notes
doubt.
also cite a tongue laceration on the right front of the victim's tongue. Do you recall
Really?
that?
Yes.
And you'd agree that a tongue laceration can be also caused by blunt force trauma.
Correct.
Can be caused by a fall.
That could also
Can also be
include
caused by
something
getting
like
hit.
a punch to the victim's face or jaw.
That's a possibility.
In addition to the facial injuries, you described that Mr. O'Keefe had a significant laceration on the back of his head.
He had 1 laceration to the back of his head. Correct.
I believe we saw a photograph of that a
Yes.
little bit earlier. You testified that the skin around the laceration on the back of his head was also scratched. Do you recall
Yes.
that?
I do.
But you did not testify as to how you opined that might have happened.
No.
Would you agree that someone could certainly get scratched on the back of their head if they were, for instance, dragged on the ground?
It's possible.
You described the open wound to the back of his head as a laceration, which is sort of a blunt force injury that's not the result of sharp force trauma. Is that right?
Yes.
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that
Yeah.
right?
Yes.
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
It's possible.
It could also be the result of being struck with a large object such as a baseball bat or a barbell.
It's possible.
The
In
laceration's
other
possible,
words,
but I
it
think the
was an irregular
fractures would look a
laceration
little
that resulted
different.
from some blunt force trauma.
Correct.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. You testified that there were, again, no fractures, no broken bones, no significant contusions.
The thing is
Correct.
just possible,
But
possible,
you did describe
possible,
the wounds to
possible.
Mr. O'Keefe's arm as
Well, if
having
everything's possible,
discrete linear abrasions. which
then
were
it's
caused
possible
by
she
some
did it.
sort of
It's
blunt
possible she
object,
didn't do it.
correct?
Yes.
That kind of ends the inquiry for
What
the jury.
does discrete mean?
It means each one is an individual injury as opposed to confluent where it would be all meshed together.
Your Honor, if I could publish what's been previously marked as Exhibit 19.
Okay.
And these are sort of the linear wounds that you're referring to.
Yes.
And you testified that these also sort of appear in clusters or groups. You
Yes.
call them pattern abrasions. Is that right?
Yes, I did.
And you'd agree that, for example, road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
Well, typically road rash covers sort of a large area of the skin. It would be a large abrasion. I mean, you've seen numerous cases of road rash in your
Yes.
career. And
Right.
it doesn't look like that.
Correct.
That does not look like road rash.
Blunt force trauma.
I think
can
anyone
include
who's had road
injuries
rash
from
can look at that and
various
say it doesn't look
objects,
like road
As
rash.
you testified, including an animal claw, correct?
Correct.
Well, that's not helpful.
And you'd agree that these discrete linear abrasions are
That's not helpful
inconsistent
either.
with having been struck by a smooth rear tail light at 24 miles per hour.
Objection.
Can you answer that, doctor?
I can't. By a
Okay.
smooth, no.
All right, next question.
By a smooth rear tail light, you said that is not what you would see at 24 miles per hour, correct?
Objection.
Sustained.
That is not what she said.
As you testified earlier, you've indicated that based on the facts that were presented to you, you don't know what caused those significant scratches on Mr. O'Keefe's right arm.
I do not.
They've got a witness who would like to share.
May I approach, Your Honor?
Sure.
All right. I'm just messing with my layouts because StreamYard makes it easy. And I can.
If I could just see what was.
Oh, I'm sorry, Mr. Lally.
You have to approach and show opposing counsel whatever the thing is. So.
O'Keefe's right hand.
Photograph.
I do. It's a photograph of Mr. O'Keefe's right hand.
May I mark that as the next order?
Is there an objection?
May we approach?
Okay.
Okay, we're going to zoom because what we've gotten with the medical examiner is that we don't know what happened, which means it could be that Karen Reed hit him with a car. It could be that she backed up and he slipped and fell. It could be that something else happened. It could be. But when there's that many it could be's, then that is the definition of doubt. If you cannot say beyond a reasonable doubt, she did a thing, if it could be this or could be that or could be this, then that's just, why are we here? I saw you guys saying hi to Rob. Hello, Rob.
You are unmuted.
Greg said, question, if the ME says you need a biomechanical engineer to testify and Bev still doesn't let it in, is that possible reversible error? I mean, only if she's convicted is it reversible error, but we have to see how it plays out. I think that based on the ME's testimony, it will make the judge a little bit more nervous to stand by that decision in that way. And I think it's testimony that should come in. They're qualified witnesses. It's credible testimony.
Well, we need to mark it first. If it's appropriate, it will be transferred to being an exhibit, but.
Thank you.
They're marking for
yes, we can
identification.
Publish, is it all set to be published appropriately?
Yes, Your Honor.
The triple N for identification. Okay.
Dr. Scordi-Bello, you indicated on direct examination that at least that one of the bruises from Mr. O'Keefe's right hand could potentially be attributed to an attempt to get IV fluid into the hand. Is that correct?
Correct.
During the course of your conducting your autopsy, you reviewed records from the Canton Fire Department and EMS, as well as Good Samaritan Hospital. Is that correct?
I did.
And do you recall reviewing records indicating that the IV fluids in this particular case were administered through the tibia and then later through a catheter at the hospital?
Yeah, but it doesn't
Yes,
mean that
they were
the ambulance
administered through
drivers
intraosseous
didn't try.
lines in both legs, shins.
That was for the warming
and
fluids.
at the hospital, they were administered through a femoral central line. Yes.
Those are different.
And you'd agree that bruising to the back.
Christine, there was some limitations on that. That's what the chat was talking about.
Defensive wounds.
That doesn't look
That's-
like
yes,
a
that's
defensive
correct.
wound to me, but
And there are actually 4 separate distinct bruises.
she
outside
did
of the
say
one
they
that
were
we
consistent with
discussed
defensive
earlier on
wounds.
Mr. O'Keefe's
So
right hand.
that is
Correct?
the ME's opinion, which matters
Yes, I would
the
say
most.
3, but I can see how you would say 4. 1, 2, 3. That might be 1 together. But yes, I can see how you would say 4.
And you testified yesterday that there was also an injury to Mr. O'Keefe's left hand.
There was a vague contusion on his left hand, correct?
You were asked by Mr. Lowry.
Can we
on-
take this down now, Ms. Little?
Yes, Your Honor. You testified on direct examination that you didn't see any sort of obvious signs of a fight because Mr. O'Keefe's fingernails were intact and you didn't observe any fractures on his hands. Is that
It's
right?
not exactly what
Correct.
she said. She gave a
But
bunch
broken
of.
fingernails and
No.
fractured hands aren't the only.
She said she didn't see obvious signs of a fight. And then she started listing out what the classic signs of a fight would be and said that she didn't see those things, which made it more likely to her it was something else or that it was not a fight. But that's a different situation than the cause of injury. But anyway, that's me being picky.
observable signs of a fight. Isn't that correct?
That's correct.
In fact, you noted a laceration over his eye.
Yes.
You noticed multiple lacerations on his nose.
Abrasions on his nose. Yes.
I
Yes.
misspoke. Multiple abrasions on his nose.
Correct.
You noticed a laceration to his tongue.
Yes.
You noted the contusions on the back of his right hand.
Correct.
The injury, the contusion to his left hand as well.
Correct.
And as you just testified, bruising on the back of hands may be consistent with defensive wounds.
It could be.
It could be.
So in fact,
And that's the
if
thing.
you have a body
It could be.
that presents with
But
a
it
laceration to one
Could
of the
also be an
brows,
IV. It could
a
also be
laceration- or
a combo.
abrasions to the nose, an egg over an eye, contusions and abrasions on the hands, and a laceration to the tongue. These injuries are consistent with a physical altercation, correct?
Objection.
Sustained.
Are those injuries consistent
She
with
said
a
it's
physical
possible.
altercation?
Objection.
It's asked and answered.
Your Honor, may we approach?
No, it's asked and answered. The judge is mad because it's asked and answered. For a couple of you are asking, why is Miss Little doing this cross-examination with younger attorneys, with attorneys that are newer in the field, doing the work with witnesses who are medical experts? It's a much easier thing to prep. Those experts tend to be fairly consistent in the way that they talk about things. So it doesn't surprise me that that's where the newer attorney on the team would fit. So I think that that's appropriate for the team, and it takes some time for a team to let attorneys learn in court, but attorneys have to learn in court, and scientific and medical witnesses are really great
Shifting
places
gears for
to
a
do that,
second.
and she does a really
You
good job with
indicated on
it.
direct examination
She's
that
easy
you
to follow.
reviewed some photographs from law enforcement that showed no footprints in the snow. Do you recall that testimony?
I do.
Were those provided to you by Trooper Proctor?
And the court said move
Yes.
on the last thing.
Do you have those photographs with you?
No, I don't.
Do you recall what was depicted in those photographs?
Yes, if I remember correctly, it was the area of the fire hydrant and the area where Mr. O'Keefe's body was discovered. It's the front of the house, the area of the fire hydrant, and I believe the flagpole.
Thank you. You testified that Mr. O'Keefe had multiple fractures to his
If she's a
skull,
partner, it still doesn't
but they seem to
necessarily
be
indicate she has a
originating
ton of
from a
trial
single point of
experience,
impact on the
depending
back
on
of
what
the
her
head. Is that
normal work
correct?
is,
It
and
appeared
depending
so, yes.
on how often they go to trial.
Are you reasonably certain that
So it
all of his
just
injuries
depends.
were the result of a single impact to the back of the head?
Legal experience and trial experience are not synonymous.
It could be a single impact.
But it also could be multiple impacts, correct?
It could be, yes.
Because as you just testified, Mr. O'Keefe suffered multiple injuries to the front of his face as well.
Correct.
In other words, he could have suffered a trauma to the face and then fallen and sustained the injury to the back of the head, correct?
That is possible, yes.
And you testified before the state grand jury that the areas of bruising to the brain were likely due to a fall. Is that correct?
Yes.
In your expert medical opinion, is it possible for someone to get punched in the face hard enough to lose consciousness and fall backward?
Objection.
I'll allow it.
It's possible.
It's also possible for somebody to slip and fall backwards hard enough. But you know who would be able to tell us if that would be consistent with the injuries to the head? Say it with me, chat. The biomechanical engineers. Say it all together. We just want to hear from the voir dire witnesses at this point.
May I see the exhibits that were just marked, Your Honor?
AK said, cosplayer Lawnard here. I like Miss Little's natural surgical tone, pun intended. Very appropriate for
Your Honor,
medical
if I could have
discussions,
permission to
shows
publish
trust
this
in the
for
expert.
same minute as Exhibit 19.
I like her
Yes.
questioning style too. She picks up a little of Yanetti's style, but I do like the
Dr.
way she
Scordi-Bello,
questions.
It's kind of hard to see in this picture, but there's some redness that you observe on the body by the ribs that we observed in some of the other photographs that were presented by Mr. Lally.
Donna Lynn in the chat said, isn't that how Bob Saget died? He fell and hit his head. Yes, absolutely.
Just a moment, Your Honor.
Yes.
I covered a little bit of that lawsuit with the family because they were fighting to not have any of that information made public. All right, we're gonna zoom as they're approaching with more
I'd like to
photos.
show you what's been previously marked as People's Exhibit 648. Ms. Gilman, would it be, Mr. Bates, could you take that down? Yeah. Ms. Gilman, would it be possible to display Exhibit 648? 648.
She's asking the state's tech person to put up the state's
May I approach, Your
exhibit
Honor?
Yes.
again, which is appropriate.
Shown this photograph by Mr. Lally on direct examination.
Yes.
Do you see the redness sort of next to his rib cage on the bottom?
Beach
Correct.
said Natasha
Yes.
Richardson skiing also,
What is that?
as a number of people
That is
skiing
LIBOR.
also.
Lividity?
Lividity, yes.
Can you describe for the jury what lividity is?
Yes, lividity is the pooling of blood to the dependent areas of the body after someone is deceased.
So even though it sort of appears to look like a bruise, that's lividity, correct?
That is lividity, yes. It goes all the way down.
And it's not the result of an injury.
No.
No, it's the
Thank
result
you.
of
No further questions.
Okay, the lights, please. Thank you.
what?
Mr. Lally?
No further questions. All right, we're on redirect. And the question looms large. Is this the state's last witness? For those of you that are ahead of time on other feeds, please don't spoil it in the chat. I would just like to be pleasantly surprised by something. I've been waiting
Scordi-Bello, you
for
did observe a
answers
minor
for
abrasion
29
to
days,
the
and everything
right
is
knee,
still
that correct?
just
Correct.
And
possible.
what part of the knee was that on, if you recall?
It was on the side, on the lateral side of his right knee.
And by lateral, sort of the side that faces away from the body, is that correct?
Correct.
You were asked whether or not the small injuries on Mr. O'Keefe's face could possibly be from a punch. Is that correct?
Correct.
You said that's one of the possibilities. Is that correct?
Yes.
What are
Bro,
some of the other possibilities?
bro, excuse, Mr. Lally. I don't have my on my mobile soundboard. I'm not sure which sounds are which, but I'm optimistic that maybe one of these is the record scratch. Nope, not it. No, I withdraw that applause. That was inappropriate. Nope, not the crickets. No, where is my record scratch? Sir, possibility is not your job. The defense attorney's job is possibility. Your job is beyond a reasonable doubt. Sir. Ma'am, are all of these things possible? Sure. If everything's possible, Lally, then how do you expect a jury to be like, the only logical, the only reasonable possibility is that Karen Reed hit him with a car? That is what you have to show the jury, that the only reasonable possibility is that he got hit by a car. And then they have to believe that beyond a reasonable doubt, and in Massachusetts, to a moral certainty. That language is heavy. And you're saying it's possible he got punched. It's possible he slipped and fell. It's possible that he got hit by a car. If it's possible he got hit by a car, then what? That's just one of many.
Could be impact during a fall. It could be coming in contact with any blunt object in the snow.
Would glass be a possibility as far as a blunt object?
It could be.
Do not play. It is day 29. Do not play. Somebody didn't throw glass at the back of John O'Keefe's head and cause those injuries. Stop it.
Under certain circumstances.
Piece of plastic under certain circumstances as far as a blunt object, would that be also a possibility?
Stop
Correct.
it.
Yes.
Now, as far as the abrasion near the laceration on the back of Mr. O'Keefe's head, you were asked some questions about whether or not that could be from dragging, correct?
Correct.
Now, as far as injuries or abrasions concerning dragging, would it be typical to see just one isolated abrasion in the area of a laceration?
Not typical, but possible.
Could that also be a result
typically
of
be
the
other
blunt
signs.
impacts, or as one of the possibilities you've testified before, from hitting the ground?
Yes.
Now, you were asked about hitting the ground and specifically hitting concrete. Would that impact injuries to the back of Mr. O'Keefe's head also be consistent with striking his head on frozen ground?
I'm sorry.
No, I'll allow it.
Can you repeat the question?
You were asked a question on cross-examination about the laceration and abrasion to the back of Mr. O'Keefe's head being consistent with striking his head on concrete, correct?
Yes.
Would that also be consistent with striking his head on frozen ground?
Could be. Yes.
We don't have any evidence the ground was frozen, but okay.
You were asked about certain wounds as being a possibility of defensive wounds. What are some of the other types of defensive wounds that you would expect to see that you did not see in this case?
I would expect to see, or I have seen.
But his BAC had been over a 0.21 and she thought was falling, but that's not a low BAC, Lally. Like that, you can't just ignore that also exists when we're looking at everything here.
Multiple bruising to the, again, posterior aspects of the forearms.
Kath, because today is a Dave day, no, he's not digging himself a hole. He is digging a ditch. Yes, we will be speaking only in Dave Matthews Band song lyrics heretofore.
I have seen cuts, lacerations, depending on how a person might be defending themselves, the position of their arms.
And with that also includes breaks in the fingernails and fractures to the hands.
Objection.
Watch the form, Mr. Lally. Sustain.
Yeah, it's
What, if anything
leading.
else, would that include?
It might include bruising to the knuckles. It might include broken fingers.
Now, with reference to the injuries that you were asked about with respect to Mr. O'Keefe's right hand, would those also be consistent with impact from a blunt object as well?
They are blunt impact injuries. Yes.
When you're trying to prove
Now,
multiple
again, if I could,
possibilities as
just
the
with reference
prosecution,
to,
it's a
perhaps about
bad
different
day.
Possibilities with the skull fractures and bleeding in the brain. What is your opinion as to sort of how that
Asked
was
and answered.
caused and sort of,
Asked and answered.
if you could again just go through your opinion as to the head injury,
When your question says if you could again, it's asked and answered.
injuries, a skull fracture, and bleeding.
Objection.
Yep. Sustained.
Ask it
Sustain
again,
it.
Mr. Lally, in a different way.
No, it's
You asked
asked
about
and
some
answered.
possibilities.
The
What is
form's
your
not the
opinion
issue.
as to how those injuries were sustained or manifested in Mr. O'Keefe?
She's not
I
going to
don't
change
know
what she said.
how they came to be. I
Right.
described them, and I stated previously that they are consistent with a fall to the back of the head.
And so
Right.
I'm sorry, Doctor. My question is more geared towards as far as the single impact to the back of the skull and then sort of radiating fractures in the skull. If you could explain that in reference to the subdural hemorrhage, subarachnoid hemorrhage, and the ecchymosis.
Consistent with a fall.
Again, a single impact with a fall could cause all the injuries that we're seeing in the brain and the skull.
Thanks. I'm not.
Wow. No recross. No recross. Let's go. Let's be
All right,
done.
doctor, you are all set.
We done. We out. Hold on. Where'd that applause go? What next? Are you resting? Are you resting? Are we Are we going to get to argue motions? The state rests. The Commonwealth rests. What are you doing?
All right, Mr. Lally.
Thank you, Your Honor. Commonwealth REST.
All right. So I'm going to stop you right there. A short recess.
If the court needs one.
I don't need one, but
You
I
need
will
to
see you
excuse the
at sidebar.
jurors. You guys, we made it. You guys, we made it. 68 witnesses, 29 days. And the Commonwealth has rested their case. I don't know if it's answered questions for you, but now the defense is going to make their motions outside the presence of the jury to dismiss the case. I don't think at this point that the judge will grant that. They're going to argue that there is nothing but doubt in this case and no reasonable jury can come to a conclusion. But what the judge has to look at is all of the evidence in the light most favorable to the prosecution. And that means everything taken as, okay, but could it point to this? So the Karen Reed voicemails, could it point to motive? The testimony from the ME could be a fall to the back of the head. That could be caused by a car strike. So when you look at the evidence, the jury doesn't have to do it that way, but the judge does on that motion. So I think we're going to get to those motions next. And the jury is being let out of the room. So I'm optimistic we're going to hear those motions argued in open court and we're going to be ready to go. We're going to see what the defense really thinks of the case. And then we're going to get Lally going, Your Honor. And then maybe we'll hear why he thinks that we're all here. But it looks like they're going to take a brief recess before that. So we're going to zoom past the only fan That is not as brief of a recess as I would have liked. That's like a 15-minute recess. Guess what? It's not for us. We're going right to motions. Right to motions. Oh, you guys have been waiting for this. I've been waiting for it too. For those of you that are like, what is happening? At the end of the prosecution's case, unless someone is like representing themselves and does not know, there are motions to dismiss the case. And that's what we are going to do right here. Again, the standard that the judge has to adhere to is very clearly light most favorable. So let us do that together. Let the internet be strong. Miguelina, yeah, go ahead and let the app know that the Commonwealth has rested and they are moving to arguments for a directive verdict. No. I am not happy. Give me one moment. Let me try to refresh that stream. And as we get to the thing I want to see the most, can we not buffer? Maybe not. So let me get to that motion this way. All right. We can overcome, chat. We can do it. We've got this. Why, oh, why is the internet all of a sudden being awful? This was my issue this morning, was my internet, but if you guys can still see me, this might be the feed. Because things look good on my end. So I hope that is not a feed issue, but we're just going to let it roll and see what happens. There we go. Thanks for your patience, chat.
All right. So, Mr. Jackson, yesterday you told me you would like 10 minutes for your argument. I'll hear you now.
All right. 10 minutes.
Your Honor, I'll be brief. The court must consider, after viewing...
Is anyone disappointed that he didn't say, Your Honor, I'll be brief, but what the fuck? We know it's not going to happen. We know that this judge doesn't even like it when people have a normal outrage for things, so I'm not surprised. But, you know, we can hope.
It's in light most favorable to the Commonwealth, whether a rational jury could find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after resting is insufficient to meet such a finding. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth. I want to, if I can, focus my argument on count 1, 2, and 3 and a specific element of each count. Okay. In each one of those counts, there must be evidence that the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. There's been conjecture, there's been speculation, but no actual competent evidence. The Commonwealth's entire case relies on a theory built on the shoulders of a trooper named Joe Paul, who testified a couple of days ago. And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck, he was spun around in sort of a pirouette, he was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. Everything in the Commonwealth's case, everything relies on that theory of damage to the taillight at the scene. If a rational jury could not unanimously determine that Trooper Joe Paul's theory is true beyond a reasonable doubt, then we believe the motion has to be granted. There is no competent medical evidence to support that theory. There's no competent physical evidence that the taillight could break and shatter in the way that they've suggested, and that the arm would not have any breaks or shatters or any damage, any additional damage. There's no evidence how getting hit in the arm could actually launch a body 30 feet, as per the Commonwealth's theory. And there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning. The evidence before the court, the only evidence that is before the court, is that the Commonwealth's own medical examiner does not believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries, and they are, every single one of them, consistent with a physical altercation. Calling a witness to simply espouse an opinion like Trooper Paul did that belies science, common sensory, and logic, that's not enough to get the case to the jury. The light most favorable to the Commonwealth does not mean that the court must believe the Commonwealth's witnesses. What it means is that if there is a rational controversy in the evidence, the court must accept that evidence that favors the Commonwealth. But here, there is no rational controversy. As put or expressed in Commonwealth versus McCormick, it's a 2023 case found at 491 Mass 848, pinpoint site 860, quote, where the Commonwealth's evidence is entirely circumstantial, it cannot meet its burden if the evidence equally supports inconsistent propositions, as resolution of such a case necessarily requires conjecture or surmise. In our view, there is no question that there's no rational controversy related to the Commonwealth's theory. Trooper Paul's theory is by definition not rational. It's not reasonable. And it's basically based entirely on conjecture.
Just
and
a
that's
note
why,
on no spoilers,
in our
chat,
view, the court
and
is required to find
also
Ms. Reed not guilty.
These are very rarely granted.
Because each of the counts, as I said at the beginning,
No, the jury is not present for
element
this.
that John O'Keefe was struck by Karen Reed's vehicle.
This is motion argument.
Thus, if a rational jury cannot reasonably believe Trooper Paul's theory, it's the only evidence presented by the Commonwealth describing how Mr. O'Keefe possibly could have been struck, then Ms. Reed is entitled to an acquittal. Nothing else matters. Nothing else in the court's evaluation, nothing else in the jury's evaluation, nothing. Everything turns on whether or not the car hit John O'Keefe. And the Commonwealth's only theory of how that happened is from Trooper Paul's description. If the court were to deny this motion, then by doing so tacitly, the court is expressly endorsing Trooper Paul's theory of how John O'Keefe was struck, and we don't believe that that's rational. We don't believe that any rational jury would ever unanimously agree with Trooper Paul, and thus we ask the court to find Ms. Reed not guilty at this time.
So they are asking for a directed verdict. That was a brief and concise argument.
Your Honor, if I may just, we have a written motion for the court to act on pursuant to that argument. May I hand it to your clerk? May I copy for the comment?
All right, I will hear you, Mr. Lally.
Yes, Your Honor. Surprisingly, I would disagree with counsel's
So let's leave the comments out.
You're following Alan Jackson, and what you start with is sort of. Sir, you don't start with, Your Honor, it would be an injustice to grant a directed verdict. This jury gets to decide if Karen Reed killed John O'Keefe. And the evidence showing that she did is insert your theory of the case. We're just going to do that one more time because I'm so fucking stunned. I shouldn't be at this point. I shouldn't be stunned. Apparently, my optimism knows no bounds with this trial. Not super confident.
Surprisingly, I would disagree with counsel's
So let's leave the comments out.
Your Honor, as far as the comments, all I was going to say is that I would submit to the court that.
Is this surprisingly that I took issue?
And my apologies for that. What I would submit to the court, Your Honor, is that this case does not rest and fall with the testimony of Trooper Paul. Trooper Paul's testimony, while important when taken in conjunction with the remainder of all of the other witnesses and all of the other testimony that
the judge is so dumb.
I don't want to minimize it, but at the same time, that is not the only evidence that the vehicle struck Mr. O'Keefe or interacted with Mr. O'Keefe.
Please tell me more.
The court has, as far as the physical evidence, next to Mr. O'Keefe's body, the one sneaker in the location of the curb, the glass, the drinking glass that Mr. O'Keefe is seen walking out of the waterfall bar at approximately 12:11 a.m. with that is in the vicinity, the direct vicinity where the Canton police officers actually recover it early in the morning of January 29th. You have the microscopic pieces of the defendant's taillight, which was testified by Ms. Hanley to be consistent with the pieces of the taillight from the defendant's vehicle that are within or embedded within Mr. O'Keefe's clothing. You have the remainder of the pieces of taillight, and this part is important in relation to Trooper Paul's testimony as far as the linear momentum, and it's all in the same sort of direction and path of all of the roadway evidence that he observed that's discovered in and around the area where Mr. O'Keefe's body was. The testimony from Ms. Villiers, with reference to all of those taillight pieces and how they were able to reconstruct from the pieces that were found on the ground and then put back together, matching not only to that, but the taillight housing from the defendant's vehicle. The taillight housing from the defendant's vehicle, which has the victim's, Mr. O'Keefe's DNA contained on it, as well as the mitochondrial DNA testing of the hair that was on the rear right quarter panel of the defendant's vehicle, which also was
I don't think that
matched or consistent
I don't think that
with that of
shows
Mr.
what you think it
O'Keefe's,
does.
His mitochondrial DNA, as well as the court heard from Ms. Chart from Voting Technology. You have the plethora of testimony from the various civilian witnesses from that particular night. You have the evidence of motive from the text communications, as well as the testimony of the children in this case as to the state of their relationship from the defendant's own mouth in those text communications and in those voicemails as to the state of their relationship. You have the testimony in regard to Mr. O'Keefe and his recounting of the state
Somebody
of their
just walked out
relationship and
swiftly.
numerous attempts to break it off with Ms. Reed prior to that day. There are arguments that continued throughout the afternoon of the 28th and seemingly into the 29th. You have the defendant's own statements that I hit him, that come from multiple sources.
Do they, though?
Including firefighter Nuttall, firefighter Flamati, firefighter McLaughlin, and Ms. McCabe. You have her statements to the paramedics in the back of the ambulance that the last time that she saw Mr. O'Keefe, they had gotten into an argument. You have the testimony in regard to Ms. Roberts and Ms. McCabe as far as the altercation or the verbal argument stemming from Ms. McCabe's reference of Bella's mother being a landmark, being someone that Mr. O'Keefe used to date.
Back
prior
to
that
Bella's
argument
mother.
Occurring in front of the house at 34 Fairview Road. With each and every piece of evidence that was presented throughout the course of the Commonwealth's case, including the forensic evidence, including especially one thing I would stress for the court is taking not only Trooper Paul's testimony, but Trooper Paul's testimony in juxtaposition to Trooper Garino's testimony as far as the vehicle or the native GPS locations of Mr. O'Keefe's phone in reference to the timing and in particular the information or data from the Toyota text stream. Trooper Garino's GPS native location of Mr. O'Keefe's phone has that reversal, the same 3-point turn that Trooper Paul testified about, which occurs 8 minutes prior to the vehicle traveling 24.2 miles per hour for approximately 62 feet in a straight line in reverse. And as far as the testimony and the evidence that the court has before it, the court also has those backup testing videos that Trooper Paul conducted with the defendant's vehicle, so the court can see exactly what that vehicle looks like at approximately 25 miles per hour in reverse in a straight line. And what I would submit, Your Honor, is that there's more than sufficient evidence from a medical perspective, from a forensic perspective, from a civilian witness perspective, and from the investigation of this case as to all three indictments that the Commonwealth has met its burden, particularly under the standard before the court at this time. And for those reasons, I would request that the defendant's motion be denied.
Okay.
She gonna take a break?
Right. In the light most favorable to the
Nope,
Commonwealth
she's gonna
under the
deny it now.
prevailing Lattimore standard here in Massachusetts, I am satisfied the Commonwealth has met its burden. The defendant's motion is denied.
So, Mr. Yannetti, are you calling your first witness?
Yes, Your Honor.
Okay, so let's bring the jurors in, please.
All right,
Do-
we are moving into the defense's case in chief. I am not surprised that the court denied it. That is not uncommon. It is not, I think most judges would have probably denied that motion. So it's, again, the light most favorable to the Commonwealth is not an easy standard for the defense to overcome. The thing is, it is a much lower standard than what the jury is going to have to overcome, if that makes sense. So we're going to get into the defense's case in chief. And they are bringing the jury. So now we are in the defense case in chief.
Bring the jury.
And I wonder if we will get through all three of those voir dire witnesses today, if they're still in town, because and then the tech expert maybe Monday. I mean, we actually might get this case to the jury next week. Okay, fingers crossed, y'all, fingers crossed. I'm going to zoom. That's helpful. We love the spinny wheel. We don't love the spinny wheel. All right, mobile streaming is so fun. Let me just zoom to their first witness and the court giving her instructions.
Whatsoever.
It seems that let's see. There we go. Come on, stream. All right, give me 1 second. Sorry, chat. It's just going to be not quite as smooth when I am mobile, but I'm going to work on, that that's not helpful. We're going to refresh this stream real quick as the jury comes in and get into the defense case in chief. So that is better. Apologies for the restarts. I appreciate you guys rocking with me. You still make it the #1 place to watch trials, and I appreciate you. So again, it is very, very unusual that a court would ever grant a motion for directed verdict. Those cases shouldn't go to trial, right? I'm sure a lot of you have feelings about whether or not this should have gone to trial, because I hear you.
Thank you very much, Your Honor. The defense calls Brian Loughran.
The judge told the jury that the Commonwealth has rested, and the defense calls their first witness. And now you're going to get to see maybe a different side of Lally with him doing the cross-examination, not the direct. And we see the defense doing their direct examinations of the witnesses.
Can I proceed, Your Honor?
Yes.
Good morning, sir. In a good loud voice, would you state your name and spell your last name?
Sure. It's Brian Loughran. It's Loughran.
And where are you from, sir?
Mr. Loughran, I'm going to ask you to keep your voice up as loud as you can, sir.
Sorry.
That's okay.
Maybe put your mouth as close to the mic as you can. Where did you grow up, sir?
Canton, Mass.
Is that where you live?
Yes.
How long have you lived there?
Both 35, 36 years.
And did you go to Canton Public Schools?
Yes.
Now, in the course of living in Canton, were you familiar with the Albert family?
Yes.
Which members of the Albert family were you familiar with?
All of them.
And when you say all of them, can you name the ones that you were familiar with?
I was familiar with Brian.
Brian Albert?
Chris Albert. Brendan Albert. Kevin Albert. And I believe Kathy Albert is the sister, but I'm not 100% sure on her first name.
Okay, and those are the siblings that you had contact with and were
From
with?
other testimony, Brian is the tow truck driver.
Yes.
Whom did you know the best?
Chris Albert.
What is the age difference between you and Chris Albert?
Chad, I'll be right back.
I believe we're the same age.
Did you graduate high school with him?
He went to a different high school, but yes,
Graduated at the same time.
correct.
And with regard to your familiarity with Chris Albert, can you explain to the jury how you became familiar with him and what your relationship with him has been?
I went to school with him, elementary school. We went to middle school. Then he transferred to a Catholic school. Then later in years, I began to work for Chris for D&E Pizza, delivering pizzas.
Okay. And
I'm so sorry. That was me.
Approximately what ages were you when
Sorry,
you were delivering
Chad.
pizzas for D&E
That was
Pizza and Chris Albert?
I was
Absolutely
25,
unhinged.
26
I
years old.
apologize.
And how many years did you deliver pizzas for him?
Sorry.
Up until I got married, 35.
That was
So several years.
me. I bumped
8
into
years.
my soundboard.
And with regard to
so
your
sorry.
interactions or knowledge of Kevin Albert, can you describe that?
Kevin Albert would be through D&E Pizza if he came in. Through the police department, would see him on details.
All right. And were you friendly with him?
Yes.
With regard to Brian Albert, can you
Travel
describe
streams
your
are always a
interactions
little
or your
unhinged.
relationship with him?
Again, through D&E Pizzas, delivering pizzas to his house. Cordial, polite, would say hello.
All right. So you're friendly with the Albert family?
Correct.
Now, back in January of 2022, where were you working?
I was working for the town of Canton.
In what department?
I was working in the sewer department.
Is that also called the water department?
Yes, water and sewer are combined.
And under what heading is that? The
It's
water.
DPW.
It's under the DPW, the Department of Public Works.
Correct.
Now, back in January of 2022, were you one of the regular snow plowers for the town of Canton?
Yes.
And directing your attention to January 28th of 2022, do you remember that day?
Yes.
What do you remember about that day, the 28th?
It was a potential blizzard. We had been given a start time.
All right. And when you say you had been given a start time, what does that mean?
It means that we're expected to be in our trucks at a certain time on our route.
Okay. And who gives those instructions back in January of 2022?
The supervisor for the Canton DPW.
Deanna, we can
And
talk
who
about
was
this a
that
little
at the
bit more
time?
relevant. They
William
talked about
Walsh.
some of that
Also known as Billy Walsh?
much
Yes.
earlier in the trial when he testified.
Now, when were you called in to do plowing that evening or early morning?
We were told to be in by 2:30
And is that 2:30 a.m. or p.m.?
a.m.
Would that now be on January 29th?
Correct.
So what time did you arrive at the DPW that early morning?
About 2:15.
Oh yeah, I forget chat
When you
populates.
got there, what did you need to do in order to
depending
go
on what
out
device you're
plowing?
on. Yeah, I can move those.
I
Thank
needed
you.
to get into my
Ask and you
truck
shall receive.
and get that prepared to go out.
All right.
We don't want to block chat. Chat is bay.
Your truck, is there one that's specifically assigned to you when you plow?
Yes.
And does that truck have any particular nickname?
Yes, it's called the Franken truck.
And why is it called the Franken truck?
It is a truck that has a lot of different parts than what it's required. It's not parts that were made for that specific truck.
Because we frankened it
Another
together.
one?
Yes, it was a truck that was very uncomfortable at the beginning to use, so they try to make it as comfortable as possible.
All right. And that particular truck, is it used for anything else other than snow plowing?
Yes. It's used for everyday use.
Now,
Yeah, I
you
don't think
get
we're going to
the
hear much,
DPW at
what if any,
2:15,
from
you say
Yannetti.
You get your truck ready. What does that entail to get your truck ready? and
Clear,
how
simple
long does it take?
questions. Always
It takes
better.
about 5 minutes, but just basically you need to make sure that it's got enough gas in it so we're not going to the route and running out of diesel fuel, which is not good. It's just basically going over the truck, making sure you have everything you need for that night.
And do you plow alone or with someone?
By myself.
Now, with regard to the visibility in your snowplow Franken truck, can you describe that for the jury, what you can see, what you can't see?
So the Franken truck has an air ride suspensions, an air ride seat. So the seat is raised so I can see over
They're
the
so
hood.
cool.
And I can see about 5 feet on either side of the passenger side, driver's side.
And when you say 5 feet, are you talking
I've only done air ride
straight
once,
out
driving a
From
fairly
the
big
windshield
U-Haul.
straight out.
All right. And what, if any, lighting do you have on Franken truck?
We have marking lights. We have 2 plow lights that are situated at the corners of the trucks, and it's up high. It illuminates very well. It's very well seen.
Okay. And with the extra set of lighting that you just described, how far can you see off to the sides in front of you and directly in front of you?
Probably 5 feet on the sides.
Well, so you already testified to that, 5 feet straight out.
Yeah.
But what about the sides going forward?
It's it's hard to decide to put into words, but I can see a real long distance. The visibility is fine. It is extremely. If you gave me probably 5, 10 feet, 15 feet out, maybe even further.
Okay. And with regard to the lighting, how much light does that give off?
Enormous amounts. It's almost driving with the spotlight.
And with regard to the air ride seats, what action did you take with those that particular night?
I raised it so that the bottom of my knees would hit the steering wheel.
And what, if any, obstructions, I should say, were in front of you that would prevent you from seeing what's in front of you or to the side?
Nothing.
Nothing.
All right. Now, do you have a specific route assigned to you?
Yes, I do.
Could you describe that route? And by the way, that specific route, was that the one that you were assigned on January 29th?
Correct.
Could you describe that for the jury?
Yes, it's a route that consists of Cedar Crest from Kings Road to Chapman Street and everything in between. There are a lot of streets I could name if you would like, but Fairview is one, Spring Lane is one, Cedar Crest, Kings Road. Those are pretty important roads that I would consider major roads on my route.
All right. Now, that particular night, if you got there at 2:15, what time do you think you were on the road by in Franken truck?
I was on Cedar Crest about 2:30, 2:35.
Now, with regard to Cedar Crest,
his route encompasses Fairview, which is what we're going to
show
hear.
you a
what
map
he
if
saw,
I can. May I approach you?
either from Cedar Crest or what he saw on Fairview.
I've handed you a document. If you could just review that to yourself and then look up at me when you're done. Do you recognize what's depicted on that?
Yes.
What is it?
It is my plow route and consisting of streets that I plow.
All right. And to be fair, that's a portion of your plow route, right?
Correct.
There are other areas of the city that you plow?
That's
This actually depicts my actual physical route.
Oh, okay.
He's like, no, that's my entire route.
And that's a fair and accurate
He started
representation
questioning
of
himself when
the
Yanetti's like,
streets,
that's only a
as
part of
they
your route. He's
existed
like,
back in
actually,
January
no.
of 2022?
Yes.
I would offer that, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay.
Thank you.
And can I have permission to publish before the hearing?
Notice Yannetti has not said, let me back up once, and he hasn't started 7 questions and then asked a different one at the end. It's just easier to follow.
35 or so?
Correct.
All right, as we look at this exhibit on the screens, are you going from right to left or left to right on Cedar Crest when you first approach Fairview?
Right to left.
Okay, so you're going sort of from the upper right-hand corner of the diagram down Cedar Crest toward Fairview. Is that accurate?
Yes.
Could you take the laser pointer and just confirm that route for the jury? That's, okay.
I can't see that.
Road? Are you able
there
to
it
read
is.
that right?
I'm not, to be honest with you. I'm sorry.
Do you still have that map in front of you? Maybe that'll help you, Mr. Moore.
And actually, can I orient it so it's oriented just like that for him? Okay, that's how it's up on the screen.
Okay.
And by the way, I should have asked this, but is it in terms of is it you can't read the writing or you can't really see the outline of the streets?
Both.
Okay.
He's like, I
well,
can't
that's
see
not going to
shit.
help much. Okay. If we can have the lights back on. With the court's permission, can I leave that up on the screen while I ask a few more questions?
Sure, except you said you can't see it.
Right. No, I know, but the jury can. So I think it would be helpful for them.
You're assuming.
All right. So you're coming down Cedar Crest, and would Fairview be on your left or your right when you first approach it?
When I first approach, it's on my left.
All right. Now,
To your
do you
witnesses
take that
too,
left
if you
at that
can.
time?
No, I do not.
Why not?
At the time, I'm pushing snow, and we don't want to block any part of the road with snow, and taking a left would have left a row of snow. So I proceed to the end of Cedar Crest, do a cul-de-sac, and then head back up Cedar Crest.
All right. So there's a cul-de-sac at the end of Cedar Crest.
Correct.
Dead end.
Yes.
And you plow that?
Yes.
All right. So then when you come back up, is Fairview on your right or your left?
It is on my right.
What do you do?
I take that right and continue to
Simple
plow.
Questions.
Now, are you familiar with the Albert residence on Fairview Road?
Yes.
How did you become familiar with that?
Growing up in Canton, I knew where they lived.
Can I have Exhibit 66 displayed with the court's permission?
Yes.
From where you're seated now, Mr. Loughran, are you able to see what's on the screen?
Yes.
And do you recognize that?
Yes.
What do you recognize that to be?
That is the Albert house, Brian Albert's.
And when you were passing the Albert home on Fairview, the very first time you passed it, would it have been on your right or your left?
It would have been on my right.
What section of the road were you plowing at that point?
The middle of the road.
Why is that?
I start in the middle and I angle right with the plow.
Now, I want to direct your attention to when you were, your truck was essentially perpendicular to the driveway. You see the driveway?
I love his answers basically, like, because
Yes,
that's
I
how you
do.
plow, Unity,
When you were
obviously.
perpendicular to the driveway, where were your headlights pointed?
In front of me. In front of the truck.
I'm sorry?
Yep.
In front of the truck.
In front.
And what were you able to see of the front lawn of the Albert residence that very first time you passed?
I was able to see the entire front lawn.
And about what time was it that you first passed 34 Fairview Road?
About 2:45.
Now, as you continued along past the driveway, did you continue to have all of those headlights on in front of you?
Yes.
And as you continued along, what were you able to see of that front lawn? How much of it?
A very large portion, almost to the front steps.
And now, when you're plowing, where is your attention focused, sir?
My attention's focused in front of me and then to the sides.
Why would your attention be focused to the sides?
I am trying to be aware of any side traffic, any pedestrians, and God forbid, any animals.
And When you were passing the Albert residence,
He's trying to be
as
careful.
you pass every home, what attention do you pay to the sides of the road and the lawns that are adjacent to the road?
I'm, again, making sure that there are no animals, no pedestrians, and making sure no one's coming out of their driveways, not expecting to see me.
And with regard to Exhibit 66, do you see the flagpole there?
Yes,
Is that something you had seen previously?
yes.
And when you made that first pass by that residence at 2:45 in the morning, sir, with your headlights on, what, if anything, did you see on the front lawn in the area of the flagpole?
I saw nothing.
If there had been a 6'2", 200-pound man lying in the snow there, would you have seen it?
Objection.
Sustained.
Now, once you pass the residence, where do you go?
I go to the end of Fairview.
And what street does that intersect with?
That intersects with Chapman Street.
If we have the previous exhibit, put back up with the court's permission. Sure.
The question called for speculation. That's why it was sustained. The testimony is, what did you see? What did you
Do
hear?
you still have the exhibit oriented the same way,
I
sir?
think
Yes, I do.
Where's Chapman Street? on
if
the
you had seen
exhibit?
someone,
Down the
would you
bottom,
have done
top,
something?
or
Did
which-
you
Down
do
the
something?
bottom.
Might have fixed
And
that. But
when you come to
Yeah, they
the
moved
end
on.
of Fairview with Cedar Crest in your rear now, right?
Correct.
Do you take a left or a right on Chapman?
I take a left
All right.
onto
And
Chapman.
once you take that left, what do you do?
I back up and then take a left to go back down Fairview.
Okay, so you're essentially doing almost a three-point turn in the road?
Correct.
All right, so now, do you go back down Fairview at that time?
Yes, I do.
And how far do you go down Fairview?
To the end, to Cedar Crest.
Now, at this point in time, you would also pass the Albert residence, correct?
Correct.
Would it be on your right or your left?
On my left.
Were you looking to the right and the left as you were coming down?
Yes.
How much light did your headlights illuminate of the Albert?
while we are going through this delightful testimony, Tate Nelson, Amy might have told me. Tate said, yesterday I was just sitting here enjoying a fuckery fest 24 when EDB calls me out because I had texted Amy's husband to verify her Lawnard street cred. Not gonna lie, it was awesome. Yes, the real Amy Van Dyken, in fact, in the chat, and Tate Nelson, the real Tate Nelson, also in the chat. So thank you for that. Good to see you. I'm sure Amy will also have a giggle, but I love it when the law nerds connect through the chat and you find people in the chat you don't even know are in the chat. But yes, thank you for the super chat and the clarification as we get into, day 29, the defense case. How many witnesses are they going to have? Maybe 5, 6? So this will probably move pretty quickly. So thank you for the super chat, Tate, and thank you for
as you
saying
were
hi.
coming down from Chapman Street.
Coming down Chapman, just about the entire front lawn.
And again, with regard to that area around the flagpole, did you see anything on the lawn?
Nothing.
See a body?
No.
All right. Now, after you've done these 2 passes, sir, where do you go?
I then take a right on the Cedar Crest. I proceed up Spring Lane,
And stuff.
come down
His
Spring
first
Lane,
pass for
and then do
Fairview
the remaining of my
was
route.
at
How
2:45
long did
a.m.
it take you before you wound up back at Cedar Crest and Fairview?
About 40, 45 minutes.
And then back around.
So I think you had previously testified you made the first pass around 2:45.
Correct.
So would that put us at about 3:30 when you're about to make the second pass?
Objection.
Sustained, ask it, Tiffany.
Sure, I'm sorry.
What time did you make your second
What
pass?
time was it, your best estimate in terms of when you would have approached Fairview and Cedar Crest again?
3:15 to 3:30.
All right. Now, when you approach that intersection again, are you approaching it such that Fairview would be on your left or your right this time?
On my left.
Teresa
Same
said,
as
did he
last
see
time.
something?
Correct.
What do you do when you
What he didn't
approach
see is
Cedar
as
Crest?
important
I'm
as
sorry,
what he did
when you
see.
approach Fairview and it's on your left.
At that point, I have an option. I can go to the end of Cedar Crest, or I can turn around at a street, depending on how much snow I have on Fairview.
And with regard to the decision you made regarding that choice, what decision did you make on January 29th at 3:50?
Went all the way to the end.
Went all the way to the end of Cedar Crest.
Correct.
Same thing you did the first time.
Correct.
And then you come back up?
Correct.
Is Fairview on your right or your left at that time?
It would be on my right.
And did you take that right?
Yes, I did.
What, if anything, unusual did you see at that point?
At that point, I saw a Ford Edge on the side of the road
Where was it parked on the side of the road?
in front of the Albert's house,
Where in front of the Albert's house?
by the flagpole.
And why was that unusual?
The Alberts never had cars that were parked out front, and it just stuck out as weird.
Now, what were the snow conditions like at that point? This is now, I think you said about 3:15 to 3:30.
It's starting to accumulate a lot quicker than what it was previous.
And what policies does the DPW have regarding cars parked in the street during a blizzard?
Interesting. Are you not allowed to park in the street?
We are to notify the supervisor. At that point, he will make a phone call to the police, and depending on if they can have the resident move it, it gets moved. If not, it gets towed.
And with regard to that policy, did you comply with that policy in those early morning hours?
No, I did not,
Why?
because I was being courteous to the Albert family.
Now, once you saw the Ford Edge parked on the side of the road near that flagpole, what did you do?
I had to go around the vehicle and as to not hit the vehicle.
So it's
All right.
the
And,
Alberts.
Probably obvious, but as you're approaching the vehicle, was it faced in the same direction that you were traveling?
Yes,
And so you're going around to the left or the right of the vehicle?
left.
And once
Y'all, my only
as you were
experience with that is
approaching
street
that
sweeping
vehicle,
days.
were
Like,
you able to see on the right side of that
they don't
vehicle
plow
the lawn
where I
sign?
live.
Yes.
Did you see
The jury will know. I was just asking.
anything on the front lawn at that time?
Objection.
I'll allow it. Did you see anything?
No.
Lights were still on.
Correct.
All right. Now, once you pass the vehicle, did anything attract your attention at all?
No.
All right. Where do you go?
I go up to the end of Fairview and do the same process. Take a left on this Chapman and back down Chapman and take a left into Fairview again.
Once you come back down Fairview, do you pass the Albert residence again?
Correct.
Was there that car that you saw?
Correct.
It moved from when you passed it the first time.
No.
Were you able to see the front lawn of the Alberts in front of you as you were coming down Fairview toward Cedar Crest?
Not as much as the first time because the car blocked the view.
All right. Now, after that, how long did it take you before you came back to that area to plow again?
About 3 hours.
Do you recall about what time it was that you wound up back on Fairview?
Would have been after 6 a.m.
I don't honestly recall what specific time.
Sure.
Would have been after 6 a.m.
Approximately, if it was 3:15 to 3:30, that second time, what would be your best estimate of the time when you came back?
Was anybody there when he came back?
I would say
Were
if I
EMS
had
still
to
there?
say, it would have been 5:30 up Fairview. And came back down, and then at that point I wasn't able to go further than Carriage Lane.
Okay, and when you say that you went up Fairview and came back down, you initially went from which side of Fairview?
Right side.
But he didn't
what
see
would that
anything
be,
then
the right
either, and
side?
that
I'm
was
sorry.
right before the victim
Would
was
it be the
discovered.
Cedar Crest side or the
It would have been Cedar Crest side.
coming from Cedar Crest, and then you went up Fairview, came back down?
Came back down. As I'm going up, I am actually seeing first responders. And at that point, as I'm coming back down, the road's blocked at that point.
Okay. And when the road was blocked, what, if any, plowing were you able to do after that on Fairview?
I was able to go as far as Carriage Lane and then turn around.
So did he go by the house
And then I imagine it was several hours before you could plow again?
at
Before I could
5:30?
plow Fairview to the end of Cedar Crest, yes.
All right. Now, I'd like to direct your attention to February 15th of 2022. We were approached by an investigator who wanted to ask you questions about what you had seen and done on January 29th of 2022.
Yes.
Do you remember his name?
Yes.
What is it?
Paul?
And what was your understanding about whom Paul worked for?
Objection.
Ask it differently.
On February 15th of 2022, were you ever approached by anybody in law enforcement, sir?
No.
So what was your understanding of Paul's job?
Objection.
I'll see Councilor Taiba.
We already know it was a defense investigator. Like, I don't know why this is a secret. All right, we're gonna zoom just a little bit. A couple of you have asked in the chat, and Pat McGann, I see that again. Why does the judge say this is the snowplow guy? Why does the judge say I'll allow it? I have no idea. It is this judge's habit. It has been consistent the whole trial. I don't know. It's I'll allow it. I'll let him have it.
You are unmuted.
I've never seen a judge do that, but this judge has been consistently doing that.
Mr. Loughran.
Why?
Sure.
No idea.
At any point in 2022, were you ever approached by any police investigators, sir?
No.
When was the first time that you were approached by the state police in this case? Do you recall?
I don't recall the actual date, but I do know.
Year?
Yes.
What year was that?
2023.
Just let him finish. He was going to tell you the month and year.
And do you recall the name of the investigator that approached you?
Patience, Yannetti.
Mike Proctor and Sergeant, and I can't pronounce his name. I don't want to.
If I said Buchanan, would that ring a bell?
Yes, it is.
He's like, I don't want to say it wrong, which is fair.
I have nothing further. Thank you, sir.
Okay. Mr. Lally.
All right, Cross.
Thank you, Your Honor.
Lally on Cross. What if any? Well, what if any? Sort of any. Let's see.
Good morning.
May I approach?
Yes.
Sir, I'm showing you a document that's already been marked with Exhibit 109. Just ask you to look at that and look up whenever you're finished, okay?
Lally's kind of coming in hot. The pace of his speaking has picked up.
These are the plow routes for the town of Canton.
And there's different numbers that are associated with different routes and different drivers assigned to those routes. Is that right?
Yes.
And if you look down at number 11, is that your route that you were talking about as far as the sort of portion of Cedar Crest neighborhood that you plow?
Yes.
And that's the route that you were assigned to on January 28th and January 29th of 2022, correct?
Yes.
Now, if I could ask, just as far as there's a certain way that you plow a route.
Yeah.
Excuse me. There's a certain way that you plow a road, correct?
Correct.
And when you're first plowing the road, you're sort of plowing the middle of the road, correct?
Correct.
And you do it in sort of a fashion that's referred to as ring road right, is that correct?
What?
Yes.
Can you explain to the jury what that is and sort of why you're plowing a road in that particular
I've just never
fashion
heard
when
that
you're
before.
first starting to get out there with the plow?
So Ring Road to the right.
We've established that my experience living in an area where things are plowed is minimal. I don't even remember if they plowed at UMass Amherst when it snowed. I just remember walking through snow in inappropriate footwear. But anyway, I can't wait to hear him describe how he plows.
Refers to the snow coming off the plow. It actually leaves a row of snow. We Ring Road to the right to prevent cars from having to go through the Ring Road to the left. If you go to the left, you've now put the Ring Road in the middle of the left-hand lane. So everything's to the right.
So everything's to the right because if there was a vehicle coming the other way, you'd be plowing into that vehicle. Is that correct?
Correct.
And your goal sort of when you're first getting out there to plow the roads is to sort of clear the middle of the roadway first, correct?
Correct.
So that's where your truck is when you first go out and plow the road, is you're sort of in the middle of the road near the double yellow line if there is one on that road?
Correct.
Okay. Now, this truck that you were driving, on that day, how long have you been assigned to that truck for plowing purposes?
I was assigned to that truck for probably 2 years, maybe longer.
Not
Maybe
winter
longer.
shoes.
Were you driving that same truck
Warm
in 2015?
shoes. Not winter shoes.
No.
No? Okay, so you were driving a different truck at that point?
Correct.
Do you remember what kind of truck that was?
It was an F-550 utility truck, pickup truck.
Similar in size or shape to the truck that you were driving that day?
No.
Now, you were asked some questions about February 15th, 2022, when you spoke to some investigator on that day, correct?
He wasn't asked that.
February 15th?
Yes.
He wasn't asked that about that day. He was asked about Paul.
The Paul person you were talking
Yes.
He was right. He was asked
and
about Paul.
you met him at a skating rink, is that right?
Correct.
And you said in a statement to him at that time that you would have seen a body on the front lawn or the sidewalk, is that right?
Correct.
Now, are you aware that there is no sidewalk on the same side of the street as 34 Fairview Road?
Correct.
Now, you mentioned some familiarity with the Alberts and with the Albert resident. Are there other people on that route that you're familiar with as far as where they live and who they are and all that?
Yes.
And how are you equally familiar with them, more familiar with them, or less familiar with them?
I never thought I would be surprised at how quickly Lally is speaking. But look at that. He's just like zoom, zoom.
Equally.
Equally? Now, familiarity with 34 Fairview Road,
Also
does that
notice
extend to sort of the lighting around that
Brian's
area?
demeanor didn't change at all.
No.
He's just
So
answering
you know
questions
that there
the
is
exact
actually
same
no
way.
street lighting whatsoever in the area of the fire hydrant or the flagpole or anywhere there for several hundred feet.
Correct.
So you do know.
I believe so, yes.
And so when you're driving by, you're looking for
He's just answering your
cars coming out of the
questions, dude.
driveway, cars coming in the opposite
He's
direction,
just
people walking. Is that
Answering your
correct?
questions.
Correct.
And you're trying to look for those objects so that you make sure that you don't strike them or hit them or anything like that, correct?
Correct.
Oh, the judge is back to spinning her glasses. It's, Your Honor, I don't think it's good
And
for
on
the
February
arm of your
15th,
glasses.
2022, when you had this meeting with Paul, you told him about 3:30 or 4 a.m.
I'm very sensitive
is
about the
when
longevity
you,
of my glasses.
saw this Ford Edge on Cedar Cliffs, correct?
Correct.
Now, in fact, when you first spoke to this individual named Paul, you didn't tell him it was a Ford Edge, correct?
Nope. Told him it was a Ford Edge.
You didn't tell him first that it was a small SUV?
Nope. Told him it was a Ford Edge.
You remember at any time Paul taking you on the parking lot and showing you different vehicles and asking you if those vehicles matched what vehicle you saw?
No. He wanted to make sure that what I was telling him was accurate. So he showed me what was a Ford Edge, but I had already told him it was a Ford Edge.
So he brought you out to the parking lot.
A Ford
at the
Edge, yes,
skating
a
rink
Ford
that you were
Edge.
meeting at, specifically showed you a Ford Edge.
Which makes sense when he said it's a Ford Edge, and he went out into the parking lot and said a Ford Edge, like that Ford Edge. So we are both calling Ford Edge the same thing, which makes more sense than just pointing to a Ford Edge and being like, it's this car exactly. No, we need to make sure we're talking about the same vehicle. Because what if somebody calls it the wrong thing? Me, I am someone who calls things the wrong thing. So, okay.
And asked you if that was the vehicle.
Correct.
Now, do you know sort of the difference between if you were to see a
So
Ford
it's a
Edge at
confirmation.
nighttime in a snowstorm, the difference between a Ford Edge and a Jeep Cherokee?
Yes,
What's the difference?
the taillights in the back.
What about them?
Ford Edges are more round. The whole back facade is a little bit more round. A Jeep Cherokee are more square.
Lally,
Now, what
you're
color
going to
was this
get
SUV?
rolled by this dude.
I can't tell you that. I am colorblind.
Can you tell, I'm just curious, sir, as far as your color blindness, can you tell whether or not an object is dark or light just by looking at it, or you can't tell at all?
I can see things that are light. I can see things that are dark. I can see true colors. I can't see shades of true colors.
And so from what you saw, was this light or dark?
Light.
Interesting.
Now, you told this Paul individual on February 15th that the
Light
SUV
and
that
color
you saw was
Ford
exactly where Mr. O'Keefe's body was found, correct?
Correct.
How do you know where his body was found?
I told him specifically if he was looking at the door, the front door, it was about 3 feet to the left of the door. And with
To the left of the door?
looking at the front of the door to the left of the door, pushing it up Fairview.
So if he wrote in his report that you told him that the vehicle was exactly where the body was found, that would not be true?
Objection.
No, it's bad report writing because he said 3 feet to the left of the door up Fairview. And if the report writer did not write, the witness says 3 feet to the left of the door up Fairview, consistent with the location of where the victim was later discovered, and just writes, he said it's where the victim was. That can be confusion on the report writing, but I believe this dude.
I'll allow that.
Could you repeat that question, please?
If he wrote in his report that you told him that the SUV was exactly where the body was found, that would not be true, would it not?
That would be true. The car was to the left of the door, putting it in front
But how
of
do you know where the
the
victim was?
flagpole.
My question for you, sir, is how do you know
Where
where
the
Mr.
victim-
O'Keefe's
right.
body was found? At any point in time, did you see Mr. O'Keefe's body on the front lawn?
No.
So how do you know where Mr. O'Keefe's body was found?
Through police reports, police interviews, stuff that was posted on the media.
So you've seen police reports in the media?
Well, not the
correct?
police reports, I'm sorry, but what was said during on the news.
So what you've heard on the news, not necessarily what you saw or what you know yourself, correct?
Could you repeat that question, please?
You're recounting sort of what you've heard or saw on the news, and so this doesn't come from your personal knowledge or anything about where Mr. O'Keefe was.
He
correct?
believed what the
Correct.
news said.
Now, you also spoke with some other individuals in May of 2023, correct?
Correct.
Now, did you tell those individuals that you actually came in, and when you say came in, you come into sort of the main sort of hub or the shed on Boulevard Street, correct?
Correct. We punch in.
That's where you punch in and you pick up your truck and you sort of do your check going
Lally's
around the
loud
truck
now?
and then you go out and plow.
You have a voice
Correct.
now? Today
Now,
you're loud.
You were plowing on this street.
28
was
days of
there
not being able to hear
any
you,
other
sir.
sort of subcontractor
Fucking
or anything
joking
else
me?
that was working, plowing the roads as well?
Yes.
And who was that?
It was by the yard landscaping.
And so they assist as far as the plow route is concerned, and they go around and they plow things on the same route that you were describing, correct?
Correct.
Now, these other people that you talked to in May of 2023, did you tell them at that time that you actually came in around 11:30 p.m. to 12 a.m.?
I don't remember that.
You don't remember that, or you didn't tell them?
I don't remember that.
So that would be a significant difference, 11:30 p.m. to 12 a.m. from 2:15 a.m. and 2:30 a.m., correct?
Correct.
And he doesn't remember telling him that.
Now, you also indicated to them at that time that you went past Fairview at approximately 12 a.m. and 2 a.m., correct?
I never did 12, but it was definitely 2:30,
So if they wrote
2:40,
that in a report, that
2:35.
would be inaccurate as well, correct?
Sustained, and only one person can talk at a time.
I apologize. I'm sorry, sir. Please continue and finish your answer.
I didn't hear the question.
He's like, what the fuck are
Well,
you
let me
even
ask it
saying,
again.
Lally?
So as far as if that was contained within a report regarding that conversation in May of 2023, that you went past Fairview Road or went down Fairview Road at 12 a.m. and 2 a.m., that would not be accurate, correct?
Objection.
Sustained. Ask it differently.
Did you go down Fairview Road at 12 a.m. and 2 a.m.?
What's interesting is that the objections that are being sustained that we are seeing from the court are the same type of objections we were seeing sustained when it was the defense on cross-examination. So it'll be interesting to watch also how the judge rules and if those rulings are consistent. And so far, the way that the judge is ruling on objections during cross-examination has been consistent. So let's keep going.
If that were contained in a report of your conversation you had in May of 2023, would that be accurate?
Objection.
Sustained. Ask it differently, Mr. Allen.
Now, as far as that conversation that you had in May of 2023, did you tell those individuals that you saw the vehicle around 1:30 or 2 in the morning?
Again, I don't remember ever saying that.
Right.
Is
Move
that
on,
accurate
Lally.
as far as whether or not you told them that?
He's like, I
Again,
didn't tell him that.
don't remember saying that.
Did you see a vehicle around 1:30, 2 o'clock in the morning?
I wasn't on the road at 1:30 or 2 o'clock in the morning.
Correct. Now, do you also recall telling those individuals that Fairview Road was blocked off by cruisers at about 3 or 3:30 in the morning?
Again, that would have been incorrect.
That would have been after
Do you recall
5:36.
saying that in May of 2023?
I do not.
May I approach, Your Honor?
Yes.
So we don't have the report, so I don't know where the wires are crossed in the report, but there's clearly wires crossed. Because his timing was like, I go out on the road at this time, and then it's this amount of time past that. So there are wires crossed somewhere. I don't know if anyone's being intentionally obstructive.
So I'm going to ask you to read.
But there are wires crossed. The jury gets to rely on what they see on the stand. So that's why these reports are coming in. But this is a lot of witnesses have said that's not what I said in the report. So that's kind of been consistent in this trial where people have said that's not what I said. Documenting what people say, exactly what they say, is not as easy as it might seem. You can't filter. You can't speculate. You can't add in. You just put what they say.
Sir?
Yes.
Okay. May I approach this retrieval?
Yes.
Mr. Loughran, after having reviewed that as your memory refreshed as to that conversation you had in May of 2023,
No, it does not.
do you still, after reading that, don't recall telling anybody in May of 2023 that you came in around 11:30
Objection.
p.m.
He said his
12 a.m.
memory's not
on the
refreshed.
28th,
You don't
29th?
get to just read it
I
in.
never came in at 11:30, 12:30 at night. It was 2:30 calling.
You don't recall indicating to anyone in May of 2023 that you went past Fairview at 12 a.m. and 2 a.m.?
Correct. Never
That's
did.
an answer.
And you don't recall telling anyone that you saw the car around 1:30 or 2 a.m.? Is that correct?
Correct.
And you don't recall telling anybody that the part of Fairview containing 34 Fairview was blocked off at 3 or 3:30 a.m., correct?
Correct.
Now, if the part of Fairview that you were talking about, you didn't say that in May of 2023, because at 3 or 3:30,
He
the
was
roadway wasn't
plowing.
blocked off, correct?
Correct.
He was
It was
out
blocked
plowing.
off sometime around 6 a.m., correct?
Correct.
And so if you had said that the roadway was blocked off at 3 or 3:30 in the morning, and it was actually 6, then when you saw the vehicle would have been off a little bit as well, correct?
Objection.
Sustained.
I think this man knows when he goes to work. Like, I'm not confused that he's confused that he doesn't know when he goes to work. Uh-oh. They put
Seeing the car at 1:32
a
in the
sticker
morning,
on my Starbucks,
with the road being
which is
blocked
lovely,
off-
so it doesn't
blocked off,
spill,
excuse
but
me, at
my
3 or
nails are
3:30 in the
incompatible
morning.
with this
If the
sticker.
road's blocked off at 6 a.m., then that actually would have been, you saw a car sometime around 5 a.m., correct?
Objection.
Sustained.
Sure you didn't see a black Lexus SUV in front of the house at 34 Fairview Road around 5 a.m.?
What?
No.
Are we still trying to do that, Lally? You really...
Now, you also were asked some questions. You spoke
Okay.
to some troopers in August of 2020, correct?
Correct.
I meant to mute.
And County Canton, they have a parking ban in Canton, is that correct?
Correct.
That goes from November until April?
Correct.
Now, part of your plow route is a road called Tippy Cart, correct?
Correct.
Where is Tippy Cart in relation to Fairview?
It is on top of it's on the
What?
right side of Cedar Crest. It would put it
Is it a
2
community?
streets before Fairview.
And at some point, when you were plowing on Tippy Cart that night, you actually hit a basketball hoop, is that right?
Yes.
And did you call that in?
Yes.
Was the basketball hoop in the street?
And as a result of that, what happened with the basketball hoop after that?
Nothing. The point was to make sure I was covered, basically. That's why I notified my supervisor that I hit the basketball hoop.
And about what time was that you hit the basketball hoop?
I don't recall.
Is it closer to when you started, closer to when you ended?
I don't recall. I don't recall what time.
No Dr. B coffee this morning.
Specific about that time, correct?
No, just that I know I hit the basketball net.
And obviously, I'm not trying to put words in your mouth or anything, sir, but you didn't intentionally hit the basketball hoop, correct?
Correct.
So you hit it because you didn't see it, correct?
No, I was attempting to avoid the net by going around it, and the machine had a different size body than what it originally had.
What?
And I underestimated when I was going around that I need to be wider.
How does the size of the
Misjudged
car
distance,
change?
Is that fair to say?
Yes.
Yes, I think this is why the defense asked about Frankentruck so much.
Very approach.
That's exactly why.
Okay.
This is why Frankentruck was discussed so much. All right, we're going to zoom past them approaching on whatever they're approaching on. All right, we're going to just keep going. Yes. Frankentruck. I don't know if the plow size on the Frankentruck changes or not, but that's a quite long sidebar. Let's see if we need to. No. We're almost there.
You are unmuted.
I don't think Lally's trying to prove anything. For those asking in the chat, M3 asked, what's Lally trying to prove? I don't think Lally's trying to prove anything. I think he's just trying to disprove what this guy is saying, or prove, maybe that is trying to prove something, prove that this witness is not reliable and he's made separate statements. But what I really like is that the witness has just been consistent. You can see that he's concentrating on Lally's questions. Lally's questions are hard as fuck to follow.
Now, sir,
And
at
he's
some
just
point
answering
prior
to the best of his
coming in here
ability.
and
That's
testifying
what you want to
today,
see in a
you met with
witness.
Mr. Irini
Yes.
how many times?
Twice.
And when were those times?
Tuesday and Saturday.
Tuesday and Saturday. When, sir?
Tuesday of last week, Saturday of last week.
And this Paul person that you spoke of before, was that person present there as well?
Yes.
And did you make note of Paul writing anything down, or Mr. Irini writing anything down while you were talking to them?
No.
And as far as you're aware, there's no reports that were generated from any of those conversations or any of those meetings. Is that correct?
Correct.
Kind of like some of your meetings, Lally. Maybe. You done? Looks like you're done.
So, sir, I'm correct if I say that you're sure about every time that you went down Fairview Road and everything that you saw going down Fairview Road.
That start with this witness is going to backfire on
time
you.
that you ran into and struck a basketball hoop that night. Is that correct?
Objection.
Sustained, you can ask it differently.
You're sure about all the times that you went down Fairview Road?
Yes.
And you have no idea what time that you went on Tippy Cart and you struck the basketball hoop. Is that right?
If you ask me to guess, I can guess for you.
I'm not asking you to guess, sir. I'm asking you to know.
I don't recall exactly what time I hit that net.
Nothing further.
All right, anything, Ms.
Very
Giannetti?
briefly, there's just one question I wanted to make sure that we understand what's going on.
So no statements, right? Just ask a question.
I always do that. I apologize, Your
Okay.
Honor. You were asked a question by Mr. Lally. Are you sure you didn't see a black Lexus at around 5 a.m. in front of Fairview? And your answer was no. And my question to you is,
No, you didn't
does
see
that
it?
mean
No, you're not
that you're
sure.
not sure if you saw one or that you didn't see one?
Objection.
I'll allow that.
I did not see a Lexus at 5 a.m.
Right.
At any point that night while you were plowing,
No,
did you see a black Lexus in front of 34 Fairview?
no.
Thank you, sir.
Very briefly. Based on your timeline, were you on Fairview Road at 5 a.m.?
Yes.
How so, sir?
No, he wasn't.
It was about 3 hours after the last time I went on it.
Which puts you
So
at 6
it
a.m.
put me, I was last on it at about 3:45, about 5:30.
You were on the road about 2:45 and you said it took you about 45 minutes to sort of do the loop and come back, correct?
Correct.
And from the time that you were on there, including the time that it took you to plow and the time that it took you to do all of those things along the route, you're coming back to Fairview Road at 45 minutes later, or it took you 45 minutes to do the route?
It was about 45 minutes.
Well, then it would put you after
And
6
so-
a.m. Not 5:30.
From there, 45 minutes from what time are we talking that you were first there? Said about
He said
2:45
2:45,
or so.
and then he said 3:15 to 3:30.
About
And then he
3:30.
said 3 hours later.
So-
Right.
3:30. Okay,
Yeah.
so about 3 hours after that would then be about 6:30, correct?
It was about, I mean, I know
His
I
time
went
is
up
flexing
there
by like an
and saw
hour.
the first responders coming down. And when I,
What I'm asking is, you would testify that you may or you were on Fairview Road around 5 a.m. If you're not returning for 3 hours later, and that's about 6:30 from 3:30, correct?
correct,
So then you were not on Fairview Road at 5 a.m., correct?
I was. The time that it took me to do what I needed to do put me there about 5. So when I'm coming down Cedar Crest from doing my route, I am constantly looking at Fairview to make sure that it's considered a main road.
But
So
he's
we
not
need
on
to
Fairview.
take that as a priority.
He's by
So
Fairview.
if it's a lot of snow on that road, I am going to go turn around and do the road so that the road is available.
Interesting.
So first responders have access to that road.
So, sir, what I'm saying is you testified, your timeline, that you
Yep.
came down there around 6:30 in the morning, correct?
My timeline was 5:30.
That 3 hours
5:30?
after 3:30.
It was 45 minutes.
No, 45 minutes was from
No, his
2:45
timeline's
to get you to
moving
3:30.
quite a
Then
bit.
3 hours later, it's 6:30,
It was
correct?
It was about 45 minutes because I didn't get a lot of time. At that time, the snow was coming down at a significant rate, and I needed to make sure Fairview was kept clear. So I come down and I check. So I have the streets are all around Fairview. They're 5-10 minutes around Fairview. So the furthest street from Fairview is Kings Road.
So my question is, sir, are you talking about coming down Fairview, or are you talking about being on another road and looking at Fairview?
Coming down Cedar Crest, looking at Fairview.
That's where the confusion
Despite that
was.
timeline that you gave her.
I am always looking at that street.
Nothing.
All right, Mr.
That's where
Loughran,
the
you are
confusion
all
is.
set, sir.
Thank you.
I'm going to ask Dr. Marie Russell to join us.
Dr. Russell. Dr. Dogbite Russell. I'm very excited that we're getting to Dr. Russell. Is this the clap? Oh, look at that. So, Dr. Russell has testified on voir dire, but has not testified before the jury. So, this will probably take us. Oh, they're almost at the lunch hour. They're probably already on lunch. They're almost at the lunch hour in real time. So as Dr. Russell comes in, I think we're going to get through background training, and then the court is going to take a break. Or my, stream is going to take a break. That's not fun. We don't like the spinny wheel. There we go. The spinny wheel wasn't me. That was the stream. All right, defense witness 2. Oh, that's the mic.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Dr. Russell, could you please, in a loud, clear voice, state your name and spell your last name for us?
Hi,
Dr.
You're right, I'm an
Marie
hour
Russell.
Russell.
That's right.
RUSSELL.
That's right. I
Doctor,
forgot
what do you do
that
for a living?
court takes lunch at
I'm an emergency room
1,
forensic
not 12.
pathologist, just recently retired.
And prior to retirement, what
My
was
bad.
your position?
The immediate position before retirement was chief medical executive at for the state of California at the Corcoran State Prison.
And
So, Dr. Russell, I'm going to ask you to keep your voice up, okay?
Yes. Right.
Thank you.
Thank you.
The
there's a
mic
couple of air
doesn't
conditioners in
help.
here. Just keep your voice as loud as possible. What is, in fact, an emergency physician?
An emergency physician is a medical specialist
Also,
who has
for any of you that didn't watch the voir dire, the recently retired is because the judge was shading her. This woman has had, whether you agree with her testimony or don't, I don't think many can disagree that this woman has had a fascinating career with quite an extensive amount of career history and achievement. So the judge shading her was distasteful. And I love that this witness was like recently retired. Also, Your Honor, can we not just be like, yeah, Dr. Russell, you've had a cool career. It was distasteful to me as well.
a residency, internship residency in the field of emergency medicine, which is a field which involves taking care of patients that are sick or injured and go to the emergency room.
Can you tell us what your education, starting with your education, training, and background is that qualifies you as an emergency physician, starting with your education all the way back to college?
Okay. Well, I've completed at least 16 years of formal education beyond high school, which includes college, and then 4 years of medical school, then 4 years of emergency medicine residency and internship, and then 4 years of pathology residency, which includes 2 years of anatomic and 2 years of forensic pathology. And then I treated, I've taken a bunch of other courses and attended seminars.
Let's start with your college. Where'd you go to college? Where'd you start?
MIT.
MIT. I did my first year at MIT, where I took my pre-med courses.
And then what happened after that? By the way, about what year was that?
Oh, that was in 1972 to 73.
Where did you go?
I mean, it's
after...
not lost on me that she wouldn't have even been able to like have her own credit card in the early 70s. And she was just like, we're going into medicine, we're going into law enforcement, fuck it, we ride. I just love it.
So what happened? I was interested in becoming a doctor, and so I took the pre-med courses, and then subsequent to that first year, I learned that my mother had metastatic breast cancer,
and she took care of family.
And so I decided to go home to New York to be with her. After that, she subsequently passed away, and I returned to Massachusetts, and decided to take advantage of the time off from school to investigate my interest in law enforcement. And I subsequently became a police officer here in Massachusetts.
Right.
So following MIT, did you go to a police academy?
I did.
Which police academy did you go to?
I went to the Boston Police Academy.
And did you end up becoming a sworn officer?
Yes.
For
How much
long?
smoke do you have for
I
triple
did it for
proctor?
7 years full time.
And what department did you work for?
I worked for the City of Malden Police Department.
What years was that, if you could give me a range?
From 1977 to 1984.
During the time that you were a Malden police officer, did you also go to school and continue your formal education?
I did.
Describe that for us, please.
Well, I took specialized courses through the Massachusetts Criminal Justice Training Council.
Objection, move to strike.
All right, so I'm going to strike that. Jurors, disregard that.
Let me ask you this way.
She's allowed to
I don't want to get into the specifics.
illuminate her background.
While you were a police officer, did you also take formal education to further your medical training or your college?
That's what he meant.
Yes, I did.
That's what I'm interested in.
Okay.
Tell us about that.
Oh, yeah. So I attended Northeastern University part-time and received a Bachelor of Science degree in psychology.
After you got your degree in psychology from Northeastern, did you go on to continue your education in medicine?
I did. I attended medical school at the University of Massachusetts Medical School.
Go UMass.
From 1983 to 1987.
Also known as UMass?
Yes.
Did you ultimately end up with a medical degree?
Did.
Well,
Doctor.
After you became a doctor, did you engage in a residency?
I don't think the medical school has the UMass reputation, but other campuses may.
Yes.
What years were the residency, that first residency?
So the first residency was from 1987 to 1991, and that was in Los Angeles at the Los Angeles County University of Southern California Medical Center.
County
Is that
USC.
also known as LAUSC?
County USC.
It was at the time,
is
yes.
And that's associated with the University of Southern California
Massive
Medical Center,
level
is that
1
right?
trauma center.
Yes.
After your first residency, by the way, what was your first residency in? What was the subspecialty?
So it was in emergency medicine, and USC is a very large trauma center.
How would you
Very
describe
large trauma
the
center.
size and volume of the USC Trauma Center?
She did 2
Well,
residencies.
it's one of the busiest in the United States.
Yep.
After your first residency in emergency medicine, did you do a second residency?
Yes.
What was the subspecialty in that second residency?
So I did a 2 years in anatomic pathology and 2 years as a fellow in forensic pathology at the Los Angeles County Coroner's Office.
Right. Then became a coroner.
So you did 2 full residencies.
Right. No. Went into emergency room medicine and then also became a coroner. Like, just because time. The completing 2 full residencies is so bananas to me, but we're going to continue.
After you became a doctor, is that right?
That is correct.
What's the difference? I don't want to go into great detail, but what's the difference between an emergency physician and, for instance, the residency that you did in pathology, both anatomic
it's 2 sides of a coin.
and forensic pathology? What are the differences?
Well, generally,
In
the
emergency room,
emergency
you try to save 'em.
physician treats live patients, and the spectrum of injuries can
In
be
the ER, we
wide,
try to
or
save
illnesses can be wide,
In the coroner's
and the
office,
forensic pathologist
we take them apart.
treats or deals with deceased patients generally.
Generally.
Did you become a fellow at the LA Coroner's Office following
Yeah.
your second residency?
At the coroner's office.
No,
they're
that
all
was part
deceased?
of the second residency.
Understood. Describe that fellowship.
So that was 2 years of full-time work at the LA Coroner's Office under the supervision of very experienced medical examiners. And what I did was I did autopsies, every day, 1 or 2 autopsies every day, attended conferences, and
Why did they get rid of the
read
gift
journal
shop at the LA
articles,
County
etc.
Coroner's
It
Office?
was a very formalized education.
Did you also become, at some point, a professor or an assistant professor at LAUSC, the medical center side, the university side?
Yes. So while I was doing the forensic pathology and anatomic pathology residencies during the daytime, I worked as a full-time ER doc supervisor in the capacity of an assistant professor in the evenings.
The LA
And-
County
Become an
Coroner's
adjunct
Office used to
professor at
have
Cal State Los Angeles,
merch.
California State Los Angeles.
Yes.
that went to
Separate
some of their
university?
charitable
Yes.
And you had separate
um,
responsibilities as a professor
organizations.
in that role.
Yes,
Were you also teaching legal medicine and forensic medicine in that capacity?
that is correct. It was a master's level program.
How long were you an ER physician in total and an attending physician for Los Angeles County USC Medical Center?
No, there's
20
lots of questions about the LA County Coroner's Office having a gift shop. They did, and they used to have like beach towels that had yellow body outlines. It said LA County Coroner, hats, shot glasses. They donated it to their charitable giving. I don't know when they got rid of it, but apparently they have. So yes, the LA County Coroner's Office had a gift shop. Yes, people would go to the LA County Coroner's Office to buy, the beach towels and the LA County Coroner's hats and what have you. They had a gift shop. They have since, I think, gotten rid of it.
9 years in total. 4 of those were in training, and the rest were as a supervisor. And
Of your 29 years, 25 of your 29 years, you were supervising others,
correct.
meaning other doctors,
Other doctors, yes.
teaching other doctors,
Yes.
and teaching medical students.
Yes, and seeing their cases. Once they examined the patient, they would present their case or tell me about the case, and then I would go in and see those patients in addition to my patients.
That was my next question, doctor. In addition to teaching, were you also specifically assessing, diagnosing, and treating patients of your own?
Yes, not all the time. Some shifts I didn't have to do that, but much of the time, yes.
For the bulk of the 29 years that you were an ER doc, an emergency physician, in other words, were you also attending to patients as well?
Yes.
Once you left that fellowship with the LA Coroner's Office, did you remain active in any way or connected to the Los Angeles Coroner's Office?
Yes, so I would attend their weekly conferences when I could, when I was available and to do so. And I also consulted on some cases with them. So if they had something that was interesting and beyond their clinical expertise, they would sometimes consult me.
During your tenure at LAUSC, did you become the director of any of their sub-programs?
Yes.
Can you describe that for the jurors, please?
Yes, I was a director of the USC Center for Life Support Training. So, that involved teaching other doctors life support courses such as advanced cardiac life support, or we teach the surgeons advanced trauma life support.
I'm sorry.
Well, go ahead.
I need someone
Were
to
you also
just
a director for their quality
turn her
improvement
life into a book,
in the early 2000s?
movie,
Yes,
podcast,
for the emergency
whatever.
medicine department.
What was the reason for the quality improvement program, if you will, for LAUSC?
Well, for any program, it's ideal to have a quality improvement component, because what you want to do is look at cases that were treated and see if there were any errors, and if so, correct the errors, teach the doctors that involved, what went wrong, and try to make systemic improvements or teaching improvements to prevent those errors from occurring in the future.
Were you teaching basically best practices for emergency room physicians as well as trauma physicians and surgeons?
Yes, we tried.
And you were the director of that program, correct?
Yes.
Did you also become the director of LAUSC Jail Medical Services?
Yes.
What is the connection
Yes, we
or
tried.
the tether between the jail system in Los Angeles and LAUSC Medical Center?
Well, LAC Jail Ward was established about 70 years ago, and it was a place that the officers from various agencies, such as LA Sheriff's, LAPD, California Highway Patrol, or any of the municipalities around,
There's a lot
could
of them.
bring people that they arrested who were in need of medical care.
So
It also sends people out from the
system,
jail
very
because that's where all
large
the
jail
cavity
system, I'm
searches would
guessing,
happen.
in Los Angeles, correct?
Correct, yes.
There have to be medical attendants to that jail system, correct?
Yes.
And you became the director of the jail medical services for the entirety of that system?
For the hospital component of it.
Understood. In California, there is a.
You saw her face. She wanted to explain more, and
Yes.
and
There is
Jackson
a
was
state
like
medical board in California,
ready to move
correct?
on.
Yes.
And did you ever do any work with that state medical board?
Yes,
Just
I
like we
worked with
tried.
them for about 7 years part-time as a regular employee embedded in their enforcement unit. And what that involved was examining cases
tried
that were
is what that
referred to the
involved.
medical board because of substandard care or illegal activities of the practitioners, providers. It was for physicians
To be
and physician
disciplined.
assistants that we regulated.
What was your title,
Regulators. Sorry.
with the state medical board for those purposes?
The title was medical consultant. That was the official title.
I know it's hard to rewatch testimony we've
And then
seen,
before
but
your
the jury is
retirement-
here now, so the
By the way,
jury
what
has
years
to
were
see
you
this.
the medical consultant for, or a medical consultant for the state board in California?
But the fact that she's working with the state board
I think
builds into her expertise.
from 2009 to 2016. I think those were the years. I'm not positive. I did that. That was a job I was doing. One, I was doing the LA County USC Medical Center job too. It was an extra job.
So you
Of
didn't-
course it
you
was.
didn't,
Crafty Chris says, what's
stop
her
working
definition of
as a
part-time?
physician, an ER, an emergency
Having
physician
9
at
jobs,
USC to
apparently.
take that position.
No,
You just consulted with them.
I did it once a week, 1 day a week.
Got it. And then with regard to one of your last positions that you held, did you become the chief medical executive for the California State Prison, Corcoran?
Yes.
E-League in the chat said she's more clear now
Tell
than
me
before
about that
she is.
position and the years that you held that position.
So that was from 2018 to 2023. And as the chief medical executive, I was the supervisor of all the doctors and nurse practitioners that provided care to the inmates.
And obviously, the California prison system is a very large prison system.
Very.
Doctor, are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
The reason,
Yes, I'm actually fellow status, which is higher than member.
Are you a member
Which
of
is
the
actually a
American
big deal.
Academy of Forensic Science,
Yes, again, I'm a fellow there.
which also is an advancement above just being a member?
and
Correct.
generally member voted on in medicine, I
Have you
believe.
ever
Like
published in
it's
the area,
a
and now I'm going to
whole
get very specific,
thing to
have you
become a
ever
fellow.
published peer-reviewed articles and done research in the area of animal bites and scratches?
Yes.
So the reason the defense has gone so much into her background is to show that she is, again, the most expertiest expert that ever experted, because they are using her opinion to inform the jury of other possibilities, right? So that's what we're going to get with all the defense experts. You're going to get beat around the head. That is a terrible analogy. You are going to get to hear all of their expert qualifications, training. You are going to get overwhelmed with it to rebut what was there or not there with the experts from the Commonwealth. So that's what we're going to see over and over again.
Author or co-author a peer-reviewed article named Managing Law Enforcement Dog Bites in the ER.
Yes.
About what year was that?
It was in the 1990s.
Late 1990s, 1996? Does that
Yes.
sound right? Did you also author or co-author an article called Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes.
So given those articles, did you study specifically dog bites, dog wounds on the human body?
Yes, I have a very strong interest in wounds in general. and I have a strong interest in dog bites in
Well, that
particular.
explains the
During the
pathology
course of your
and the ER work.
career, your professional experience, how many patients would you say you've seen or treated with animal injuries, including bites and scratches?
Her
It's
study had
very
over
hard to estimate,
700.
but between my own practice and the residents that I supervised, it was, I'm sure, well over 500, and could possibly be double that.
Could be up as many as 1,000.
It could be, yes.
Her study had 700.
Have you qualified as an expert in emergency medicine in the past?
Yes,
You qualified as an expert in the area of forensic pathology and wounds in the past?
yes,
Is that both in federal and state courts?
yes.
Doctor, were you asked to review certain materials related to this case in furtherance of coming to some opinions and conclusions about injuries suffered by John O'Keefe specific to his right arm?
Yes.
What did you review in coming to your opinions and conclusions?
Well, I reviewed hospital records and pictures taken of him in the hospital, when he was in the hospital. I reviewed autopsy records, the autopsy report, and photographs taken during and before the autopsy. I reviewed. Let's see. I reviewed reviewed the grand jury testimony of the autopsy pathologist. I reviewed affidavit of Dr. Sheridan. I reviewed the town of Canton dog bite reports about regarding incidents.
Section, may we approach?
Yes.
They approached on, I reviewed the town of Canton dog bite reports. In the voir dire, this is why this is a problem. In the voir dire, she said she did not review that. So this is new, which is a problem because she might have reviewed it afterwards, which could become a problem. So let's see. Oh, yep. The jury's going out and they're going to voir dire on it, I would imagine, because she said specifically said she did not review it. So the jury is going to be excused. That's why everybody's standing up. And I think they're going to go to voir dire. Or a break is surprising to me. I thought they would just go straight into voir dire. They've gone right to only the fan.
Okay.
Hold on. All right. Let's back up because it looks like they took a very brief break. I was like, what are they doing? All right. So they're going to voir dire on this because she said she hadn't reviewed it. Let's see. Unless it's something completely else, because you never know. So the judge is back. I don't think the jury is back.
Good after this, I'll report back in session. Please be seated.
Yeah, court's back in session. I don't think the jury's back.
So the Commonwealth's objection is overruled. You can continue.
Oh. Maybe the jury is back. That was...
Doctor,
okay.
You've listed several items that you've reviewed and coming to your opinions and conclusions. Did you also review
I'm surprised they didn't voir dire on it. The Commonwealth's objection was overruled. It seems that the jury is back in, and here we go. It's so frustrating. It's just so frustrating. So some of you are asking, did she lie? I wonder if she went. I don't think so. I wonder if she went back and reviewed it afterwards, because Alan Jackson said he sent it all in a Dropbox. I wonder if she went and reviewed it later, and there's nothing wrong with it there's nothing wrong with that. Busy, I saw your question in the chat. It is a great question. I'm going to save it. The chat is jumping, but I'm going to save that for when we get to Q&A. So thank you for that.
Toxicological report?
Yes.
And a neurology report, neuropathology report?
Yes.
As well, from the Commonwealth?
Yes.
Based on your review of all
and
of those
again, we're
materials,
starting to see some
I don't want to know what your
consistency
opinion or conclusion
with
is
how
yet.
the judge
Were
treats
you able
cases
to come to an opinion or conclusion
when they're in the case in chief.
concerning
this is
the
consistent with how
injuries
she's ruled
specifically to John O'Keefe's arm?
in those
Yes.
state's
Or his
case in
right
chief.
arm.
She already said yes. The
Were
Commonwealth.
there any documents in furtherance of your review from UC Davis?
Yes.
Did you review those as well?
Objection.
Sustained.
With the court's permission, may we display Exhibit 19, please?
Okay.
Doctor, I want to show you a photograph and ask you very quickly.
I just dropped the
have you
nib
seen
out of
this
my.
before?
Yes.
Is this one
out of my
of a number of photographs that you reviewed in furtherance of your evaluation of this case?
Yes, it is.
I'd like to just focus your attention on this for just a quick second and ask you, does this accurately reflect the wounds or injuries that you saw on John O'Keefe's right arm in coming to your opinions and conclusions?
Yes, it reflects the injuries that I saw in photographs.
All right.
Right.
Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe for the jurors, please, on what you base that opinion?
Yes. Well, may I use the?
Sure.
Okay, thank you. There's a number of patterns here. There, on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of parallel marks. Again, probably most likely from teeth marks. And the reason I say that is, in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here.
And yes,
Little
Chad, I've
round,
seen a
little
number of
round
you
marks
asked when
right
the
there
image
that
gets taken down.
were
I'll let you know when
inflicted
the
by the
image
actual point of the
of the
tooth.
victim's arm comes
That was
down.
my question. What
It's going to be on the
relevance
screen
does
for a
that
minute.
have to your determination that this was likely caused by
But yes, I will.
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But going on with the picture first. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. And then there are some irregular wounds down just below the elbow. And these are all, by the way, on the exterior surface, or what we call what doctors would call the posterior surface of the arm, which is the part of the arm that would sustain defensive type wounds. So if someone were to protect themselves.
Objection.
So sustain. Next question.
That is expounded on what she said in voir dire, but I don't think it's beyond her scope, seeing that she worked with police dog bites.
Elbow, is it your opinion that both the top teeth and bottom teeth could have created some or all of the injuries on that elbow area?
Yes.
Okay, so in other words, instead of the
Jackson's away from the
mouth
microphone.
going all the way around the arm, it could have, the top and bottom jaw could have situated itself on this portion that we're seeing, the posterior part of the arm.
Yes, and in this case, the animal did not get a good enough contact.
Objection. Move to strike.
So I'm going to strike that, ask a different question.
What? Why?
Have you seen contact wounds where the animal, a dog for instance, gets a very solid purchase on the leg, arm?
Oh, versus like a bite versus
Okay. Is that
scrape.
this or is this something else?
Something else.
Describe that.
Well, when an animal inflicts injuries, the type of injury depends on, in part, on the actual type of contact and how much force is applied by that animal, in addition to any relative movement between the animal and the victim in this case. So, for instance, in the law enforcement dog bites, many of...
Objection.
So the nature, is it notice? Is it, what's one word?
She doesn't know what his objection is, and neither
May
does he.
reproach.
Okay.
The court was asking what is the nature of the objection, because the court didn't know what Lally was objecting to, and now we have seen them, approaching again. The court offered, is it notice? But that's not it. I saw a couple of you in the chat, Japes and others, asking what happened to my office. It is still in Tennessee. I am just not in Tennessee, so not in the office. We're gonna zoom past this sidebar. We are mobile streaming today, but I'm too invested to not at this point. We're just in it. Next week's gonna be a different hotel, so
You are unmuted.
we're gonna do a whole tour.
May I, Your Honor?
Yes.
Because this travel has
Without
been
getting into any
8
specifics
weeks.
about police canines.
Okay.
Does this appear, does the pattern of injuries that you see appear consistent with an animal or a large dog?
Yes.
Does the number of injuries that you see here relegated to just the right arm, is that also consistent with an animal or large dog?
Yes, it can be.
Is the direction of the injuries or the consistency of the direction of the injuries, or the parallel injuries, is that also consistent with an animal or large dog attack?
Yes.
Based on everything that we've discussed today, Doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog?
Yes.
Have a moment, Your Honor?
Yes.
I think he's probably done.
That's all I have at this time, Your Honor.
Okay.
Cross-examination.
May reproach.
Okay.
Because Lally's in a sticky spot, right? Lally has to decide if he's going to start asking, but could these also be from other things? Because the court shut that down and limited her testimony. So Lally can't really ask much of, but what else could they be? Because he limited that testimony. So we'll see what he does, or if he opens that up more by asking questions. What, if any, questions will he ask? I don't know.
Hey, John.
Sure.
Good afternoon, ma'am.
Good afternoon, sir.
Now, testified that you're certified in emergency medicine, is that correct?
That is correct.
And
You're not,
pathology.
nor were you ever certified in forensic medicine, is that correct?
That is correct.
Pathology.
Correct.
And when was the last time that you worked at a coroner's office?
Attacking her credentials is a real interesting play, Lally. We've seen your experts already, dude. Okay. Sure.
1995 in terms of doing autopsies. Yes.
Now, when was it that you first spoke to anyone from defense counsel in regard to your coming in here and testifying today?
May 17th.
Doctor, I am going to ask you to keep your voice up.
Oh, sorry.
Thank you.
May 17th, 2024.
May 17th of this year, is that right?
2024.
So about 6 weeks after this trial began?
2024 would, in fact, be this year, Lally. I wonder if he's trying to get into the fact that he seems to think she's an interested party, or that she chat. If Lally asks, are you just here for your 15 minutes of fame? I am going to lose my mind. Is that where he's trying to go with this?
I don't know when the trial began.
Now, as far as who reached out to who?
I reached out to a district attorney that I worked with with the LA coroner's office.
And then somehow that person put you in touch with Mr. Jackson, is that right?
Yes,
And was that also on May 17th?
17th and 18th, yes.
So I'm sorry, 17th or the 18th? Which one was it that you spoke with Mr. Jackson?
I didn't speak to him.
You did not speak to him?
Not speaking, not verbal. There was some email communication or text communication.
You communicated with him. Was that
Yes.
on the 17th or the 18th?
She's
both,
trying to be
I think.
precise, sir. It's kind of her
And,
thing.
when did you
as
render
an
this
expert.
opinion as far as what you've testified to here today?
Shortly after he sent me the files.
Now, in regard to those files, you testified in this court a couple days ago, correct?
I did.
And you were under oath at that point, is that correct?
Excuse me?
You were under oath at that point, is that correct?
Yes.
And when you were asked specifically what materials that you had reviewed, you included a number of items, but you did not include anything about a Dr. Sheridan affidavit, anything about a UC Davis report, or anything about any sort
Canton.
of bite history for a canine that lived or resided at 34 Fairview Road, correct?
That's true.
That's correct, because I hadn't reviewed them then.
And so since then, 2 days ago, now you've reviewed them, correct?
Yes, I became aware that those files exist.
Experts, by the way, are allowed to continue reviewing information if it becomes clear that that exists. Alan Jackson said, we sent her everything in a Dropbox. She might have just not seen it. Once she became aware they existed, she went and reviewed it. Guess what? Experts are allowed to do that. They're experts. They're not percipient witnesses. More information becomes available, I'm going to look at it. It's a juxtaposition of Lally's experts who are like, nah, we're not going to look at anything else.
Yes.
You became aware of those files?
It's not
Were they not sent
inappropriate.
to you previously?
No, I think there were technical difficulties regarding me and the computer and downloading from Dropbox. And so, yeah, so they were, I think they were sent to me, but
We
I think
feel you,
I
ma'am.
didn't open them.
Now, with reference to these technical difficulties, did you ever express any of those technical difficulties, or hey, I can't see the whole file, or there's other things in here that are listed that I can't?
Oh, shut up, Lally. How do you know if a file's not in the Dropbox if you don't see it in the Dropbox? Like if the Dropbox doesn't have a file, how do you know that there's a file missing if you can't fucking see it? Stop.
Okay.
No, I wasn't aware.
And so with regard
This is not a
to,
flex.
as far as your reaching out or contact in regard to this case, how did that come about?
Okay. I saw an article, I believe it was in the Boston Globe, regarding this case. And I didn't, initially I didn't think anything of it. Then I saw an article that indicated that there was some.
If I asking you anything about anything, any article in
Let her
you saw an
finish.
article in the Boston Globe
Yes.
about this case? Is
You
that right?
asked.
Yes,
And how did you come upon it? You have a subscription to the Boston Globe?
I did at the time. Yes,
Did at the time. What time was this?
in May.
May of 2024?
Yes,
And how long had you had a subscription to the Boston Globe at the time that you saw this?
it was either a 6-month subscription or a year. I don't remember.
And that was the first time that you had seen anything about that?
He's going to step in it because I don't think it's the first time she saw anything about the case. I think it's the first time she saw anything about a dog being involved in this case. I think he's going to step right the fuck into it because I think her looking at this case probably doesn't even spark her interest until somebody says that there is an animal involved. Then she's like, wait a second, that's my corner of nerdiness.
First time I paid attention to anything like that. Yes.
Now, again, you had testified here just a couple of days ago when I asked you questions about this. Is that right?
Yes.
It wasn't in your testimony just a couple of days ago that the subscription was actually for a year or 18 months. You
No.
remember, not 6 months a year.
So only one person can talk at a time. So was that your testimony, Doctor?
No, I don't believe so. I believe that I said it was a 6-month subscription or a 12-month subscription.
Do they even have an 18-month subscription? Because that's a weird length of time.
But in any event, you saw something. That's the first time that you recall?
I also don't
seeing
think it
anything in
fucking
the media
matters what
about
her
this case was
subscription
May
is to the Boston Globe.
2024?
It was the first time that I recall reading anything about it. Correct.
Probably because
Now, did you
That's
write a report in
when
regard to your
it was
opinions that
interesting.
you've testified here today?
No.
And I asked you that a couple days ago as well.
Yes.
Okay, so in the
Sir.
last couple of days, you've had time to review a UC Davis report, Dr. Sheridan's affidavit, and any sort of dog bite history, but you haven't had a chance to write a report?
Objection.
Sustain to that form.
You haven't written a report, correct?
That's correct.
Why not?
I haven't been asked to write a report, sir.
Did you ever look at anything related to Mr. O'Keefe's head injury?
This is also not her first rodeo, by the way.
Objection.
Sustained.
No, Jackson, let Lolly step in it. Let him just step in it. And then on redirect, be like, all right, if we're opening the door to all this shit, let's get into it. It's really, really hard to do that in the moment, though, because you just don't know. But I'm rooting for it.
You want to make an approach briefly?
Yes.
They're going to approach. It'll be interesting to see how this goes, because if the jury likes her, look, it's when she's just like, I think there was an issue between me and the computer. Who doesn't sit there and go, yes, I 100% believe that that's what the issue was, ma'am, and just empathize with her. Oh, Lally, this is a minute of a sidebar, isn't it? Let's see. We're going to catch up to real time, so I'm just going to jump to live because they're still up at sidebar and we're going to answer some questions. Oh, yay! There's no right answer in Zooming today, apparently. Sometimes the Zooms are good. Sometimes the Zooms are going to get you.
May I have a moment, John?
Yes.
Also, the photos are down off the screen. I realized I was going to say that out loud, and then I completely forgot. I apologize. Sienna in the super chat asked, is it normal for there to be such a discrepancy between the length of each side's case and trials? Yes, the state's case or the prosecution's case is normally substantially longer. The defense doesn't always present a case.
With areas of forensic science.
But this is probably one of the longest evidence presentations I've seen for this type of case. This case should not be a complex case. It's a complex case because of the fact pattern. We can talk about that later, but the defense doesn't always even bring witnesses. So
of that nature, is that
yes,
correct?
there's often discrepancy.
Yes.
And as a result of that, or any other work experience, are you familiar with a NAS report from 2008?
Not with that limited information, no.
You're not aware of a report issued by the National Association of Forensic Science in 2008, which specifically has a section dealing with...
So I'm going to see you both at sidebar again.
He is trying to cross-examine her with something. Is he trying to have a gotcha moment? It seems like it. I don't know how well that's going to go for him, but they are approaching at sidebar.
And that, I believe, has to do...
That is not...
I don't know why my zooming skills are off today.
Representation that is not from the NAS.
Hold on. He must have approached and shown it to her. I don't know why this jumped so weird. I need the camera to show the whole courtroom so I can find my spot.
So, ma'am, you're not familiar with that report, specifically as it applies to forensic odontology?
So could you say that again, Mr. Lally? What's the report?
The National Academy...
He just said forensic odontology. And often forensic odontology deals with people. Is there a subspecialty of forensic odontology that deals with animals, Lally? Because I got a big freaking question for you.
Science's 2008 report in relation to the section referring to forensic odontology.
I'm not familiar with that specific report, no.
Teeth, which
And then
generally
equally
deals with
unfamiliar,
humans.
The representation that is not
Said in-
from the NAS report.
said
that is not
confidently and
reliable
married to
science
dentist.
As far as bite marks are concerned.
There are certain aspects of bite marks that have been deemed not reliable. And that
But that's talking, oh my God, that's talking about fucking human bite marks though. And identifying, I'm going to let her school him. I'm not going to scream. No, I am going to scream. Where's the goat? Bring the goat. Just, it's going to be interesting to watch a bad cross-examination though. This is going to go badly.
of bite marks that have been deemed not reliable. And that I believe has to do with saying that this particular person or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of, that recommendation.
You're not aware of any.
Right. ID matching someone to a bite mark.
Findings in the NAS report that has led to questioning of the value and scientific objectivity of such evidence.
For specifically identifying a bite mark.
I'm going to... Lally, are you unironically saying scientific objectivity in this trial? You know those words? Oh my God, I'm going to back up and just let her school him. I'm going to shut up.
Or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of, that recommendation.
You're not aware of any findings in the NAS report that has led to questioning of the value and scientific objectivity of such evidence.
For specifically identifying a bite mark to an individual that might have inflicted the bite mark, I think that's what that applies to.
Okay, I'm not asking. Again, this is a report. Are you familiar with it, or are you not familiar?
She's
I'm familiar with
the
a
issue.
summary or a abstract of a report that indicates that forensic odontology is not is deemed not reliable when it comes to that particular narrow aspect of forensic odontology.
For identification purposes.
So you're not familiar with it. Also talking about
that's not what she said.
Analyses of these, interpretation and reporting of results. You're not familiar with those areas of the NAS report as well.
What specifically? Do you have a specific question about that, or?
My first question was whether or not you're familiar with the report. You indicated that you weren't.
I did not read the report.
From the report.
Mr. Lally, let the witness answer.
Ma'am,
one
it's not
question
you.
at a time, one speaker at a time.
You
Doctor,
know,
can you answer that?
in Ferris Bueller's Day Off, where he just hits all the buttons and makes like the vomit sound, I wish I could do that on my soundboard, but I can't.
Sure. I did not read that report.
Now, you had written some articles that you were asked about in reference to dog bites or canine dog bites in the emergency department. Is that correct?
Yes, co-authored.
Something that you published or authored or co-authored sometime in the late 1990s. Is that right?
Correct.
And in that instance, you talk about
co-authored all
law
my best
enforcement
work
dogs
in the late
and a
1990s.
bite and hold technique, correct?
Yes.
Now, part of the reason in writing that article had to do with sort of the applied forces and the unique spectrum of injuries from those kind of dog bites. Is that correct?
Yes.
And that spectrum of injuries would include deep puncture wounds. Is that right?
They can, yes.
Severe crush injuries. Is that right?
Correct.
Large tissue avulsions and lacerations.
Large
is that
tissue
right?
avulsions.
Yes.
Wounds necessitating surgical debridement. Is that right?
Yes.
Bony injuries ranging from cortical violations to displaced fractures. Is that right?
Mm-hmm.
Yes.
Neurovascular damage. Is that right?
Yes.
And other wounds at high risk for infection, correct?
Correct. But we also put a disclaimer in that article.
I'm not asking you about any disclaimer.
Okay.
I'm asking you about that's what the type of injuries that you were looking at. Is that correct?
She was looking at bite and hold injuries, yes.
Yes, but we saw a skewed population.
You skewed population in a study. Is that correct?
What we saw the worst of the worst.
Or no? Did you
Yes.
skew the population in the study?
That's
I'm sorry, I don't understand the
Did you
question.
skew the population?
We skew the, did we skew? No, we reported on all the ones that presented to the emergency room
But those
for
are the
care.
worst.
However, a lot of dog bites don't present to the emergency room.
And so from the different cases that you report on within that article, are there any of those cases in which there is injuries to just one aspect of one part of the human body for the victims of dog attacks or dog bites in those cases?
There may have been. That's a summary of the 700 cases, more than 700 cases.
nobody.
Is it normal in any kind of animal attack for injuries to occur on just one side of one arm of the person that's being attacked, clawed, or bitten?
There are many people who are bitten or scratched.
I'm asking
Only-
if it's normal, man. That's all I'm
Okay,
asking.
so hold on, Mr. Jackson. Mr. Lally, ask a question, wait for the answer, and then start a next question. Do not interrupt the witness.
I apologize, Your Honor. I don't
Yes.
mean to interrupt, but I'm asking for an answer response to the question.
She's not
So
asking you for
ask a
comment,
question.
Mr. Lally. She's asking you to wait. I think we're going to see Lally getting in the judge's crosshairs more now that he's on cross-examination.
And ask it in a manner that you get a responsive answer.
Dr. Russell, is it your testimony that it's normal in an animal attack for injuries to occur on just one side of one arm and nothing else, anywhere else on that person's body?
It can be, yes.
I'm not asking if it can be. I'm asking, is that
You said, is it normal?
I can't say.
Sustained. You have to ask the question differently.
So from your
Anyone else annoyed?
observations, you looked at various photographs of Mr. O'Keefe, is that right?
I did.
Did you observe any injuries on any other part of his body that you would attribute to an animal attack, whether they be claw marks or bite marks or anything else?
No,
So nothing on his left arm, correct?
nothing that identified as a dog bite or
Nothing
scratch.
on his legs, is that correct?
That's correct.
Nothing on his torso, is that correct?
That's correct.
Now, you say an animal attack, possibly a large dog, correct?
Yes.
Can you say what type of animal left these marks that you attribute to an animal attack?
Not with 100% certainty, no.
Can you say where physically Mr. O'Keefe was located when those the animal attack supposedly occurred?
What?
Can you say that?
No.
Okay.
Of
Can you
course
say
not.
when Mr. O'Keefe purportedly sustained these injuries from an
Close
animal
in
attack?
time to when he died.
Well, to a certain degree, yes. Before, it was before death, but not long enough to have a big inflammatory reaction. So yes. So
I didn't think he expected
minutes to
that.
hours before death.
Minutes to hours before death, but at some point before death, correct?
Yes.
Can you say anything about the breed of dog?
No.
Can you say anything about whether it occurred inside the house, outside of the house, anything like that?
No.
She's like, what
As
house?
far as you mentioned some of the different things that you reviewed over the course of your testimony, for the
Close in time to
preparation
death.
of your testimony, both prior to Tuesday and between Tuesday and today. Any of those things contain any forensic reports or phone examinations or anything else related to this case?
Could you repeat that? I didn't. What kind of examination?
Any
Phone?
of the materials that you reviewed, whether it be prior, sometime between May 17th and Tuesday, or anything that you reviewed between Tuesday and today, did any of those materials that you reviewed contain any sort of forensic reports or anything beyond the UC Davis?
Yes, I saw a photograph.
So you saw photographs. And to that point, you never actually saw Mr. O'Keefe's body, correct? You just saw photographs?
Correct.
That's true.
And with respect to the UC Davis report, as far as canine DNA, are you aware that the results of that were that there was no canine DNA on Mr. O'Keefe, on swabbings that were sent to the UC Davis lab?
I'm going to allow it.
Yes, but there was clothing in between.
Okay, but the swabbings came from the clothing with tears in
Okay.
the clothing in the same area as the injuries, correct?
Okay.
She doesn't
Do you
know
know
that.
that or no?
I couldn't tell if they came from the wound or the clothing. I thought that they came from the clothing, but
You couldn't tell by reviewing the report whether or not the swabbings came from clothing or from Mr. O'Keefe's body.
I know the clothing was sent to the laboratory.
You know the clothing was sent to what laboratory?
Not
to
UC
the
Davis.
DNA laboratory.
To UC Davis?
No, the clothes were not sent
Oh,
to
I don't know
Davis.
that. No, I'm sorry.
You are aware that that came back as far as negative for any canine DNA, correct?
That's correct.
Now, as far as the injuries that you observed, your testimony is that both the top teeth of whatever animal this is and the bottom teeth of whatever animal this is both made contact with only the top of Mr. O'Keefe's arm or the posterior of his arm?
Both sets of teeth made contact with certain of those wounds, yes, but not all of them.
But neither the top nor the bottom teeth made any contact that you observed, assuming your issue as far as an animal attack. There's no evidence of any animal attack on the bottom of Mr. O'Keefe's right arm, correct?
I'm not sure what you mean by bottom.
Anterior?
Interior? That's correct.
And nothing on the posterior or the anterior of his left arm?
That is correct.
And nothing on his legs?
That's correct.
Nothing on his torso?
Correct.
Nothing on his head, is that correct?
Correct.
Not from the animal.
Now, as far as the marks that you did observe that you do attribute to an animal attack, can you even say with certainty whether or not those marks you feel are bite marks versus scratch marks? Do you have any idea which are which?
There may be a combination.
So is that a no?
Well, no, I think that the ones that had the linear abrasions above the small round punctate abrasions, I believe that those are bite marks from upper and lower teeth.
Now, you indicated that part of what you had reviewed was a dog bite history for a dog from 34 Fairview Road named Chloe, is that right?
Yes.
And there were a couple different instances of that dog essentially getting in a fight with other dogs, correct?
Yes.
And at any point in time, did you see anything in there as far as a dog going after a human in which there was no other dog present?
No.
And there were actually photographs contained within that material of dog bites from that dog, from Chloe, correct?
There are?
Yes.
Did any of those dog bites that you saw in those photographs look anything like what you observed in the photos that you saw of Mr. O'Keefe's arm?
No, but, okay.
Oh, man.
Objection, Your Honor.
No, so the answer is no. You can get back up, Mr. Jackson, but the answer to that question is no. Next question.
On cross, you don't have to let people explain. It's for redirect. I don't doubt Alan Jackson will redirect this witness well. I'm going to zoom until Lally finds a
Your
question.
testimony that from reviewing what you reviewed, that what you observe on Mr. O'Keefe's arm is consistent with an animal attack to the exclusion of any other possibilities?
To a degree of reasonable medical certainty, yes.
So as far as any other sort of blunt impact injuries or other manifestations of how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
No, ma'am. What I'm asking you is,
All right.
Lally is trying to thread a needle here that he's not going to be able to thread with this witness, and she is not to be fucked with. This is an expert witness who has done this for a minute and knows what she's doing. So
how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
No, ma'am. What I'm asking you is,
All right. So, Mr. Lally, I'm going to let the witness answer.
go ahead, ma'am.
I've seen thousands of people with injuries to their skin, and from blunt, from sharp, from all different mechanisms. Those injuries did not look like blunt force injuries.
So it's your testimony that the injuries to his arm don't look anything like blunt force injuries that you've seen before. You wouldn't characterize them as that?
That's correct.
And that's based on some photographs and some other materials that you began reviewing sometime May 17th, 2024.
Yes, I'm an ER doctor. I need to make a diagnosis quickly
Right.
when I see something, and I'm trained to do that. That's my specialty.
Were you being asked as an ER doctor to come to a quick conclusion in this case?
No,
But you did anyway.
it's how I'm trained.
Nothing further.
Very briefly, Your Honor. Please report.
Go ahead.
Redirect.
Concerning the forensic odontology report, the NAS report that Mr. Lally asked you about, what is your understanding
How nice
about
must it be to
the
Google in
report
court?
as it pertains to identifying individuals who left a bite mark? Explain that to the jurors, please.
I believe the report says that that is not reliable as it once was thought to be.
Like a fingerprint identifying a human being, DNA identifying a person, or a bite mark identifying a person. NAS said, not the bite mark. Doesn't work that way.
That's correct.
Has nothing to do with the pattern of injuries that you've seen 1,000 times from animals, correct?
Correct.
You were asked several questions about the injuries that you saw and studied attendant to highly trained canines, police dogs, correct?
Yes.
Very different than just a domestic dog that somebody might have as a pet,
I didn't know
correct?
that.
Correct.
And the bite injuries are very, very different as well, aren't they?
That is correct.
You were asked whether or not you were aware, based on UC Davis's report, that there was no canine DNA found on the swabs that were sent to them, correct?
Yes,
Are you also aware that there was pig DNA?
I'm aware of that.
Did that have any impact did you analyze that at all, one way or the other?
Not to any degree of scientific certainty, no.
But you do know that dogs chew on pig ears sometimes, correct?
Objection.
Sustained.
It's leading.
You've reviewed at least a report, if not a series of reports, that indicate that a particular dog has an attack history, correct?
Yes,
You were asked specifically by Mr. Lally whether or not the wounds in a dog attack on another dog attack where a human stuck a hand in the middle look anything like these, correct?
Can you
Remember that
explain?
question?
I remember a question like
And
that.
you said no, but, and then you were cut off. Remember that?
Yes,
Can you finish that answer for us?
yes. So animals and dogs in particular can inflict a wide variety of injuries on the skin, from just individual puncture wounds to abrasions where there's a scratching of the skin, to where there's actually a pulling away pulling away of the skin from the underlying tissues, your ripping effect. And so there's a variety of wounds that or patterns that one can see from an animal attack. It depends a lot on the thickness of the skin, the movement of between the victim and the animal, and also the power of the animal and the training of the animal. Yes.
So in other words, not all wounds inflicted by a particular animal are going to look exactly the same.
Correct.
Very dynamic situation, isn't it?
Objection.
Sustained.
Doctor,
It is a dynamic situation.
having seen up to 1,000 bite and claw marks on the human body, and based on your review of the entirety of the case file that you reviewed, including the nature and the pattern and consistency of the injuries that you saw on Mr. O'Keefe's right arm, what is your opinion to a reasonable degree of scientific certainty about the nature of those injuries?
Objection.
Sustained.
What is your ultimate conclusion and opinion about the injuries that you saw and that you reviewed and that we saw today?
Objection.
Sustained.
You let Lally do it 100 million times, but the defense
Can you tell
doesn't
the jurors
object.
at the end of the day?
Let her restate her conclusion.
Objection.
Sustained.
Your Honor, can we approach?
It's asked and answered, and the defense hasn't been objecting. Lally has done it a million times, but the defense hasn't been objecting to it. Lally is objecting to it. It is asked and answered. However, I think there's room after the questioning to allow it, but we'll see what the judge does as we zoom past this hopefully quick sidebar.
You are unmuted.
Oh, no, she's not allowing it at all.
Thank you, Your Honor. No more questions.
You are
And-
unmuted.
Mr. Lally, you had no more questions?
No, yeah.
Okay. All right, doctor, you are all set.
Okay, thank you.
All right. Look how quickly the witnesses go. That was witness number 2. Who's going to be witness number 3 for the defense? Well, probably lunchtime, actually. No, what time is it? Maybe not. Oh, maybe. Yep.
All right, jurors, we will take our luncheon break.
Court, all rise for the jury.
That was anticipated. I'm going to answer some questions and then I will take a quick break as well. Because I have some work I have to finish that I'm late on. Also, if you do not have the Lawnard app, we will notify you when the court is back from lunch, when I am back from lunch. We are all caught up in real time now, but for like 3 minutes. So I'm going to let this roll. We're going to do a...
You may be seated.
We're going to do
I just want to know who you have this afternoon.
Just Richard Green, Your Honor.
their
All right,
tech expert.
Thank you.
So their tech expert is this afternoon. So that'll be defense witness 3. The court said, I want to know who you have this afternoon. He said, just Richard Green. So I think we will get to the other 2 experts probably on Monday and maybe closing arguments Tuesday. That seems actually like a real possibility. I was so despondent earlier. And now it seems that we might actually be on track because the judge extended the day today. So I am less annoyed that the judge extended the day today because this is absolutely necessary. Let us do a summary, shall we? I don't know if the prosecution will have rebuttal witnesses. I don't know if I don't know how many rebuttal witnesses they'll have, if any. Melissa said there's a Baldwin hearing going on. Yes, we are recording those. So I will put those up and have links to those for you guys if you want to watch them. I will be responding to them when we have a moment, or I will summarize them for the podcast. It just depends. So it really just depends. But yes, there are 2 Baldwin hearings today. I'm not going to switch over to those during lunch, but I will have a link for you guys. We are also saving those to we have a channel for just court hearings with no commentary. So we're saving those. So don't worry. We will have them. I'm just not doing them now. My brain is here. I just have no ability to switch gears right now because we're so in it. Let's try to do a summary of the morning. We are at the lunch break of day 29 of the Commonwealth versus Karen Reed from a mobile stream day for me. And we finished with the prosecution's case in chief. Hold on. Let's see if I can get it right again. Right? The Commonwealth has rested after the medical examiner, which we anticipated, and the defense has now called 3 witnesses. The snowplow operator, who was number 2? I have completely lost. It was the snowplow operator. There was somebody else. No, there wasn't. It was just the snowplow operator and Dr. Russell. And after lunch, we will be getting into the defense's 3rd expert, who will be their tech expert. And that will close out the day today. So interesting enough, from the medical examiner for the Commonwealth today, the testimony that blew my mind was that the medical examiner doesn't necessarily think that the injuries to John O'Keefe are consistent with a motor vehicle collision. They are not the classic indicia of a motor vehicle collision that you would see. And the Commonwealth's medical examiner really said there is a wide variety of possibilities for what those injuries could come from, but that they didn't match up in her opinion, with a motor vehicle accident. So she said this is a blunt force injury to the back of the head. She said with manner and mechanism. Again, I can't really testify to that. You would need like a biomechanical engineer, but that it is consistent with a fall and a hit to the back of the head, or a fall or a hit to the back of the head. So when there was cross-examination of the medical examiner, she said it could be consistent with, the injuries on his face could be consistent with a fight, could be consistent with an altercation, could be consistent with a fall. The thing is, when even the cause of death could be consistent with this or this or this or this, how does a jury determine that John O'Keefe was killed by being hit by a vehicle? He was killed by the injury to the back of his head and hypothermia. But how did he get the injury to the back of his head? And there isn't a ton of evidence pointing to the fact that it was a vehicle. Could there be a lot of scenarios? Yes. Do any of those scenarios matter at this point? No. What matters is, did it come from Karen Read? And if the jury can't get to that answer, then I don't know how they get to a verdict on any of it, because all three of the causes of action, all three of the charges here are centered around Karen Read hitting John O'Keefe with the car. Second degree injury means she meant to do it and did it. Like, just did the thing. Then the operating under the influence and did it. Driving drunk, did the thing. And then the hit and run, did the thing, know you did the thing, and left. But as the defense very well pointed out during their argument for a motion for directed verdict, Alan Jackson said, look, Your Honor, all of these causes of action center around, did Karen Read hit John O'Keefe with the car? And his argument was, no reasonable jury can come to that conclusion based on the evidence presented by the Commonwealth, even when taken in light most favorable to the Commonwealth. Lally got up and started to argue, Your Honor, I disagree. Surprisingly, I disagree with the defense, sort of, and then got cut off immediately by the court and said, surprisingly, we don't just get to the arguments. We are seeing the court cut off Lally quite a bit more today than we have. A lot more objections sustained against him in cross-examination, and her rulings seem to be fairly consistent with her rulings during the Commonwealth's case in chief, now that we are in the defense's case in chief. So with all of that, we are going to get to some questions. What an interesting morning. I did not expect the Commonwealth's medical examiner to have such strong opinions with regard to the motor vehicle accident, given that the Commonwealth chose to bring this case knowing what the medical examiner's opinions were. So again, how are we here? And when Lally argued against the motion for directed verdict, he pointed out what I think we're going to see in his closing argument. Your Honor, it's not just the accident reconstructionist. It's the one shoe. It's the debris near the victim. He said it's the microscopic pieces of taillight in the victim's clothing. It's the broken taillight. It's the defendant's statement saying, I hit him, I hit him, I hit him. It is all of these things together, and that totality leans to John O'Keefe being hit by Karen Read. We will see at the end of this case if the jury agrees, and if the end of these witnesses, the jury agrees. But we just finished with Dr. Russell, who said the injuries to John O'Keefe's arm are consistent with a animal attack, specifically a large dog. So let's get to your questions, shall we? You've got questions. I've got questions. We've got questions. We've all got questions. Like we've all got questions. Allison in the chat said, oh, it wasn't pulling up. The chat there's a lot of us in here today. But she didn't say that. Why does he keep saying she said that? There is an amount of testimony. I think it's in dispute, but when you're taking things in the light most favorable to the Commonwealth, there is testimony that Karen Read said, I hit him. It's evidence that's in controversy. So the jury's going to have to decide if that's a fact or not. whether she said, I hit him, or whether she said, could I have hit him? Did I hit him? Because it is not clear. It's not clear. It is in controversy. I don't really know a better way to say it. It's in controversy, but those words have come out of witnesses' mouths saying Karen Read said, I hit him. Other witnesses said, Karen Read said, could I have hit him? For me, in all of the controversy regarding those statements, I found Carrie Roberts' testimony to be very persuasive. So that's kind of where I leaned into on all of that testimony. I leaned into Carrie Roberts' testimony. I found it to be clear. I found it to be, she didn't seem to have an agenda. She didn't seem to be pushing one side or the other. She wasn't selling her testimony. She was just saying, this is what I saw. This is what I heard. This is what I did. It was very solid testimony. So that's what I took away from that. So when I look at the statements, I leaned to what Carrie Roberts said. LP said, do you think Karen Read will testify? I'm guessing not. I don't think she should at this point. If I see something else that changes my mind, I don't think I should. I don't think she should. I don't think she has anything to gain by testifying other than wanting to be heard. I don't think this is the form for that in this trial, because it will shift the focus from what has or hasn't the Commonwealth proved to what is her demeanor, what are her facial expressions, what is her tone. She will be confronted with those voicemails that honestly the Commonwealth didn't make much of. I'm surprised with the things said by Karen Read to John O'Keefe in those voicemails that the prosecution did not use them more. We didn't hear them till the very end. We didn't hear any of them in opening. That could have been played. The voicemail of Karen Read screaming at John O'Keefe could have been played in opening. But I think, like everything in this case, there is two interpretations of those voicemails, because they sound like somebody who's fucking pissed, but they also sound like somebody who's pissed that they expect their partner to come home and their partner's not coming home and they think their partner's out cheating. I don't think that's fake. I don't think that's fake at all. So, you know, where are we left with that then? We're left with her saying, you know, where the fuck are you? Fuck you if you're with somebody else. That's what we're left with. So anyway, what was I saying? So no, I don't think Karen Read should testify. I think it shifts all the attention to her, and I think that puts her at more risk, and I don't think there's benefit. I don't think there's anything at all that Karen Read needs to answer for at this point. You know, everyone was drinking in this case. Everyone was drinking. I don't think she needs to get into that at all. And I think actually the defense can probably argue the state's evidence and their retrograde extrapolation without making it more. If you put her on the stand, then you're going to be asking her about her drinks under oath, and there's video, so that could get worse. You're going to ask about the nature of the relationship. That can get worse given the text messages and voicemails. You're going to ask about her making out with Higgins. You're going to ask about all this stuff that the jury's probably half forgot about. So no, I don't think Karen Read should testify. I don't think she will. And given the court's enthusiasm for getting this case to the jury next week, I think if Karen Read testified, it would be not just a day. So I think it would be a fairly long testimony. And thank you so much for the super chat. I'm thinking it's who is to say that he didn't get beaten up, but by a dog and hit by a car. The evidence and testimony has been over here writing the next version of the movie, Very Bad Things. The testimony is all over the place. And that's the thing with the testimony being all over the place. I don't think there's much you can do with it. Jazz Fitness said 1236 connection to Wi-Fi is alibi, excited for the tech. And again, that came in the state's case in chief, in the Commonwealth's case in chief. The Commonwealth in their opening, I keep referencing the movie Titanic in this trial. It just fits. But you've got the tech evidence in your hand, in your file. You know that Karen Reed connects back to the Wi-Fi at John O'Keefe's home at 12:36 a.m. and you stand up in opening and say that the witness testimony and that her car shows that she hit him at 12:45 a.m. in your opening, even though you have it in your hand that she connects back to the Wi-Fi. And I have never seen the state try to distance themselves from tech evidence as much as I've seen this prosecution try to distance themselves. If you are the prosecutor and you have to, I got out of sync real quick. Sorry about that. If you are the prosecutor and you have to distance yourself from that much, maybe you shouldn't bring the case. Kit said, did Bev call the MD by her first name, the audacity? I did not catch that. She very well might have. Anyone else? Team Jen mentioning Karen Reed hitting John O'Keefe before Karen Reed started asking if she could have hit him. Power of suggestion. What I took away from particularly Carrie Roberts' testimony is that it wasn't until Jen McCabe said, oh, we saw you at Fairview, that Karen thought she was at Fairview. Before that, Karen thought that she had left John at the waterfall. So there is some of that there. Lally trying to solicit the bite didn't match Chloe after arguing that the report that says bite ID isn't eligible or reliable. Yeah. Katie said, I agree. Dr. Badass needs a screenplay or like a book. I don't know. Jen and Troy Travel said Dr. Russell, in addition to her professional resume, also raised her niece and nephew following a family tragedy. I didn't know that. That could be why she was interested in the case. I really think it was the dog evidence that dragged her into the case, and then we will see. The real question, are your lashes and your slides ready for VidCon? My lashes, Shalene, are ready. Look, the lashes are mostly ready. We've got the lashes going. My slides are not ready, but I don't need slides. I'm moderating a panel. But the lashes are good. Good to see you, Shalene. Hope travels are going well. I've got some, I will send you a text. I've got some others that are getting added on after this weekend for VidCon. So the lashes are lashing. And I have to take a quick break from lunch to turn in my cards for the panel I'm moderating, which is late. Are we surprised? Well, no. Elena said, did the ME ever testify? Yes, yesterday and today. Kira says, for those who saw my super chat yesterday about the tornado warning, I'm good. It passed. Kira, I'm so glad to hear that you're good. Glad that it passed and glad that you followed up with the chat. Thank you. That's incredibly considerate. Tanny said, who offered Chloe was a police dog? Do we know? I don't know anything about that. I imagine if there was evidence of that, then it would have come in with the defense. I have not seen any evidence of that. It's not before the jury. So, I'm not going to assume anything about a dog just because it's a German Shepherd. So Ashley said this trial is not Dr. Russell's 15 minutes of fame. Ashley, I just want to be clear. I didn't think it was. I was making a joke about the Depp Heard trial because of the fantastic cross-examination for Elaine Bredehoff that went so sideways when she accused Morgan Knight of just being there for his 15 minutes of fame, because it seemed that direction was the direction Lally was going in. I very much think that Dr. Russell saw an area where her particular and unique and exceedingly unique expertise might help. And she mentioned it to a DA who is friends with Alan Jackson. So I don't think she was seeking a 15 minutes of fame. I just thought Lally might step in it by going there. The LA Times has already written a full article about her awesome career. I wish I could post the link here, but Google is our friend. Yes. And if the LA Times profiled her, that's absolutely incredible. And I'm not surprised. I'm not surprised. I was surprised when the LA Times wrote about me, honestly. I'm not surprised they wrote about her. She's fantastic. Shelly says, Dr. Russell is a rock star, 40 plus year RN here. Today is my birthday, staying home to watch. Happy birthday, Shelly. You've gotten all of my travel madness. I think I've figured out how to travel stream again. Busy the Gamer Mom question. Thank you for sending this. It's a really interesting and insightful question. How is it both innocent until proven guilty, but light most favorable to the Commonwealth? That makes no sense to me. Different stages of the trial. So we'll see this in civil and we'll see this in criminal. it is innocent till proven guilty, but when we are looking at dismissing a case before it gets to the jury, the standard for reviewing whether or not the jury gets to hear the case is taking all of the evidence in the light most favorable to the prosecution. The prosecution bears the burden. The defense is saying they haven't met their burden. The jury can't even hear the case. And the court looks at everything in that most favorable light to determine if that's true or not. So innocent until proven guilty is the presumption of innocence the defendant walks into court with. It is the prosecution's job to move that burden past beyond a reasonable doubt to beyond a reasonable doubt, and then the jury gets to decide it. The defense is saying fundamentally the prosecution has failed. No jury can hear this case. And again, it's very rare that that gets granted. Most judges prefer a jury get to decide. And even if the evidence is challenging or thin, could a jury say, she said I hit him, he got hit by a car and fell backwards? There is an expert that says he got hit by a car. Do we believe that expert? Does the jury believe that expert? Not necessarily, but it doesn't mean that the jury can't rely on that. So that's how that works. I hope that makes sense. Phoenix said, question, do lawyers intentionally do leading questions to get it out there for the jury? In cross-examination, that's exactly the game. Sometimes in direct, it's for the jury. Sometimes in direct, it's to wink, wink at the witness. We've seen Lally do that a couple times where he's like, could it have been February 2nd? When somebody didn't know like the date of a photograph or whatever. But that is the game of cross-examination. The jurors are told that the lawyer's questions are not evidence, just the answers. But in cross-examination, it's yes, no answers. So the questions are what give context to the answers. Riley said, Emily, it's my amazing mom Jane's birthday today, and I was hoping you could give her a birthday shout out. Riley Jade's mom, Jane, happy birthday. And I hope it's a great one. Karen told cameras she wants to testify to fill in the holes, all a ploy for her PR campaign, because she also said that's up to my lawyers. It's not up to her lawyers. It is definitely up to Karen Reed. I imagine that after this trial, we will see her strategically picking which media outlets she talks to. I imagine that that's what we will see. Let me take a look at the time. I think we probably have about 20 minutes before court comes back. So I'm going to take a break to make sure that I get the things done I must get done over the lunch break. And then when court is back, I will be back. And so I will be keeping an eye on that. I'm going to leave you guys with some of the Streamyard music. I'm going to take a moment to eat and get that sent out and done. We will send out an app notification when court is back. It is my intention to stay in real time as much as we can this afternoon, Zoom, and then go Dave Day. So those are my personal goals for today. So thank you all for being along with me. Thank you for being a Law Nerd and making this the #1 place to watch live trials. Also, don't forget, if you want to go download the app, go join our over 50,000 Law Nerds in the app. We can send you app notifications. It is something we have worked with and worked on quite hard, but we are also working with them to make sure the speed of those notifications stays consistent across, devices and operating systems and all the rest of it, because we want to make sure that Jury Watch is dialed in. So the more of you that hit the app, the better the experience will be, because it gives us more information, and more information allows us to make better decisions. So here's what I think is going to happen. We are going to see the tech person for the defense the rest of the day. I don't even know if we'll get to cross-examination on that because there's a lot to cover. We'll see. And then we will have their tech guy, and then the two federal biomechanical engineers. And I think that's probably it. I don't think the defendant will testify. I think that that is not a legally sound decision, and that the defendant can have her say later and in other ways. So that's what I think we'll see. Also, Joe Mama said she's already done interviews. If she's already done interviews, her testifying becomes an even more terrible idea, because all of that comes in. So if she's already done interviews, her testifying opens up all of that. And that is a terrible plan. So I don't think it's a good idea. But again, she gets to decide, right? Not her lawyers, her. I think she probably wants to. I think she'll probably listen to her attorneys when they tell her why it's a terrible idea. And we'll see if she agrees. I did that to myself. I did that. Look, this is what today deserves this. Speaking of today deserves this, I sat next to a delightful gentleman on the plane yesterday, and his shirt was a very like punk rock styled shirt, and it said "Have the day you deserve." And he sat down, and I was like, it's one of my favorite sayings. I absolutely love your shirt. He's like, as I was coming through the airport, somebody asked, is that an insult? And he's like, well, not necessarily. It just depends on the day you deserve as to whether it's an insult or not. And the person he was talking to was like, but that's kind of insulting. It's like, no, it's have the day you deserve. If you deserve to have a brilliant and blessed day, have a brilliant and blessed day. If you deserve the day that you deserve and that day is less than that, then that's on you. It was hilarious that people had such different wide ranges of reactions. And now I kind of want a have the day you deserve shirt. Anyway, so the day that we deserve today is definitely our we are professionals here type of day. I am going to pop on our beloved Streamyard background music, and I will let you know when I am back. Look, when the music changes, I'm going to just do some chimes and bring us all back to court, right? We'll just be like, and come on back. So I will see you. Don't forget to hydrate. Thanks for being a Leonard. Let's roll. Law nerds. Hello, welcome back from lunch. Court is just resuming, and we're going to be resuming with the defense tech expert. And well, we're not going to have much room to zoom, but those of you that are not back from lunch yet will get a app notification shortly if you have not already. And we're going to just roll back into court as Yannetti brings on his tech expert. So let us roll back to court. Good to see everybody. Did you have a good lunch? Were you chatting? Why did my court feed got kicked out of my own window? So here we are. Now we can go back to court. Hopefully that works. Oh, I need to change the background back to our gavels. Our OG gavels. All right, are we ready? I'm ready, you're ready, we're all ready. I think we're ready. Let's swoop a dupe and head back to court, shall we? Yay, afternoon. Woo, tech. I'm excited to see the defense tech expert. We've heard much about his report. We've heard about his conclusions. We're going to hear more about Jen McCabe, I'm sure. We're going to hear about the data. I hope we hear more about the data on Karen Reed's phone. I didn't mean to pause that, but isn't it odd how much data we heard about Jen McCabe's phone and how little data we heard about Karen Reed's phone? I'm interested to see what else it shows.
Defense calls Richard Green.
All right, Richard Green. We're curious to see what you have to say, sir. Very, very curious. Not so much lunch. I hadn't had a chance to eat breakfast yet, so we're finishing that up. I have some egg bites here that I need to eat. Allison said 775. Did I miss a Bing celebration? I didn't realize we had hit 775. Yay. We'll do that before we wrap for the day.
Good afternoon.
Hello, sir.
Proceed, Your Honor?
Yes.
Sir, if you pull that microphone as close to your face.
We're very interested to hear what you have to
voice will
say.
be kept up, and I'd ask you to state your name and spell
Third witness
your
for
last
the
name.
defense.
Sure. Richard Green. That's Green.
And where do you live, sir?
I now reside in Coldwater, Michigan.
What do you do?
I own and operate a company called United States Forensics.
And
Please
what
don't
is
breathe into the mic.
United States Forensics.
Sure. We're a digital investigation firm. We have we're licensed in Florida and Michigan, but we do cases across the country.
All right. And again, I'd ask you to keep your voice up only because we have an air conditioner there and we have jurors behind me that
Okay,
Apparently it's the loudest thing.
I'll do my best, sir.
Yeah, as best you can. Now, you are president of that company, sir?
I am.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
Right.
Do you work in conjunction with others?
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. Prefer to take cases from attorneys. So we've also worked with numerous public defenders. We've worked with federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it at about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit and it was just improper for them to use their own experts. So that's where we've provided assistance.
So like when government agencies get sued.
How long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics and been full-time in the industry since that point.
All right. Yeah, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
How long
Yes,
ago
sir.
was that?
In order to have been
I
qualified as an
apologize.
expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking, we actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Did you all notice
said
how
you
much
formed
more
a company
engaging
in
presenting the
2007.
expert's background, training, and experience this way is? You kind of go in and out of their background, training, and experience and have a conversation. It's a different way to engage an expert, right?
Correct.
And do you work full-time, part-time? What's your schedule?
Oh, it's been full time ever since.
Would you describe for the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training that you've received.
Sure. So that would have to do with Associates of Digital Forensics.
Well, that would more be your education, right? You received an associate's
degree.
in digital forensics?
Correct.
Okay, so why don't we start with education, since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the
defense was
certification
giving
training would be the
prosecution a hard time about only having
CCE, which is
certifications.
certified computer examiner from
Expecting
the
something different from
International
their
Association
expert, honestly.
Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis, we'll target some training seminar. I found in this business, even if you took like 6 months off, you would start to get behind in this business. It changes that rapidly, and you really need to do continual training.
Okay, and again, your voice trailed off a little bit at the end, so.
I'm sorry.
I'm sorry to keep reminding you, but I just want to make sure everybody hears. With regard to the amount, your caseload at USA Forensics, can you give the jury some idea of how many cases you handle on a yearly basis or have handled historically?
Yeah, we average, I'd say between 100 and 120 cases a year. We probably get inquiries to about 3 times that amount.
Okay, and have you testified as an expert witness in the area of computer forensics since that 1996 first
Yeah,
appearance?
we testified about 24 times in various state and federal courts.
Okay, and when you say various states and courts, is that state court, federal court, both?
Both.
Now, directing your attention to September of 2022.
It's
were you
interesting they didn't go
contacted by
back
somebody
to
become
education
involved in this matter?
more.
Yes, sir.
But okay.
I believe it was Miss Little.
What were you asked to do?
Well, there was 3 cell phones related to this case, and to provide relevance with the data on those phones as related to the incident on January 29th, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that phone, if you remember?
Yeah, we received what's called an image file, and that's a forensic term that we use. Essentially, it's a copy of the data that's encapsulated into a single file. In this case, it was a zip file.
Did you examine that data?
I did.
What were your goals during your examination of John O'Keefe's phone? What were you looking for?
Well, initially what was supported was the location data. We wanted to get an idea of when he had arrived and anything else that we could tell from that as far as location.
And when you say when he arrived, do you remember the location that you were asked to learn when he arrived?
Yeah, 34 Fairview.
In Canton?
Yes, sir.
All right. Were you able to determine as a result of your examination approximately when his phone arrived at 34 Fairview Road according to the location data?
Yes, sir.
And how did you do it?
Sure. Well, I say we, so that's proverbial we. I extracted the.
I do that too. Do you see how he got into the what are we talking about and then how did you do it? It's very helpful. But with the way the defense banged on about some of the Commonwealth's witnesses, I'm interested that they didn't go into their expertise as to experts' background. He has an incredible amount of experience. So that is why I comment, because it is a different, it's interesting and different. And I was expecting something different when we got into the way that they were cross-examining other experts, but his experience is quite extensive, obviously.
The location cache data, which is stored in the on your phone, and it's in the certain location. We exported that out, and then we use a tool called CellHawk, and we import it in there, so it can take literally, thousands of data points and automate that process to specific GPS locations, and just as importantly, the range of accuracy that that location is reporting.
Okay. So according to the process that you underwent, what time did the location data indicate that John O'Keefe's phone arrived at 34 Fairview on January 29th, 2022?
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28 seconds.
Correct.
Now, if I asked you to filter John O'Keefe's location data within an accuracy of 3 feet using CellHawk, could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Last night.
Who asked you to do that?
You did, sir.
I may approach, Your Honor?
Yes.
Because it's responsive to what the Commonwealth showed. So I'm not surprised they tried to narrow it down to 3 feet.
So I placed that document before you. Could you familiarize yourself with that and look up at me when you're done?
All right.
Recognize that?
I do.
What is it?
Sorry, y'all. My browser crashed. Apologies. Mobile streaming is always an adventure. We're going to get back to court. Just give me one moment to make sure we've got our court feed back up. Sorry about that. it is, again, it's an adventure, and I appreciate you for being on the journey with me because it's not always a smooth journey. So thank God it's Friday. Let's get back to the tech expert. So he's going through his experiment from last night.
So this is a screenshot from the CellHawk program. It has a kind of a central box here that says database settings, and this is where we apply a certain filter.
And what filter did you apply?
This was for the accuracy of less than or equal to 3 feet.
With regard to what?
Oh,
My
John
ears and my hair are fighting.
Oakey's location data.
Is that an exact? Is the data on that document exactly what you received when you used the CellHawk program to filter the data?
Yes, sir.
I would offer that, Your Honor.
No objection.
No objections.
Oh, I'm sorry. I thought he said objection.
So you need to give it to Madam Court Reporter?
I'm all flustered. Sorry.
See, even when in court, he has a moment. He's like, I thought we said objection.
And if the witness could have that again.
There's still comments, which is why the court is like, you can't make comments, but it's clearly in his nature to just be like, it happens. He's just like, ah.
Okay, so, Mr. Green, what are we looking at?
Okay, so that is the screenshot from the CellHawk.
And what can you tell us about what you learned from that exhibit?
Well, I'll just use the pointer here, might help. You can see up in this part here, where this is where we apply the filter for 3 feet or less. That'd be the accuracy. And then it actually returns 0 results, meaning all of the data within there had an accuracy rating higher than that 3 foot. It could be 5 meters or 10 meters, but none of it was granular enough at a 3 foot or less accuracy level.
Okay, and if you had inputted accuracy within, say, 500 feet, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be
I was trying to look on my external monitor.
What's really important to understand, though, is you don't want to look at just the middle of the circle. That accuracy indicates it could be anywhere in the circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. Also, the accuracy, this is Apple's best guess what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
Okay, so we've talked about the location cache data and where it put John O'Keefe's phone in terms of arriving at 34 Fairview, but was there also Apple Health data on John O'Keefe's phone during that time?
Certainly, yes.
Is Apple Health data generally accepted within the forensic science community as being reliable?
Well, the Apple Health data comes from something called HealthKit, but it's integral to the iOS system. So anyone that has an iPhone probably seen Apple Health data, and it's known to have extremely valuable data that the forensic tools work with and present to us. The degree of accuracy, it depends on the type of data that's being pulled out on the artifacts. For example, steps are known to have an accuracy of around 98% on the actual steps occurring.
So if the Apple Health data returns, for instance, steps, 20 steps.
Yeah, the steps are relied heavily on
98% of the time
in Murdoch, right? The phone steps.
That's what studies have shown.
All right. May I approach the witness, Your Honor?
Yes.
Do you want this back? Okay.
Mr. Green, I've placed another document before you. Do you recognize what?
Yes, I do. This is this lists out Apple Health data
I do have a
for
humidifier near my computer.
that
So,
was from John O'Keefe's phone
there is a
on
humidifier.
January
If you
29th,
see
2022.
All right, that
the
came
mist.
from the data that you received.
That's for me.
The image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
Mr. Lally?
No objection.
The whole thing? Sure.
And with the court's permission, may I publish that, Your Honor?
Okay.
Specifically, I'd like to start with page 2, record 2. Okay, Mr. Green, are you
Zoe in
wearing
the chat asked, did they
right
prove he was
glasses
wearing an
to
Apple
see?
Watch? No, I don't think John O'Keefe was wearing an Apple Watch. We haven't seen any evidence of that.
Or if it's easier, you can look on your document in front of you. It's page 2, record 2.
Yeah, you know, I think I'm going to have to do that. I can probably still see good enough to do the laser one. I'm sorry, which record is this you're looking at?
Page 2, record number 2.
This is the health
Okay,
data
yes, I have that in front
extraction
of
of
me.
John O'Keefe.
What does record number 2 show on page 2 of John's Apple Health data?
Sure. So this is the number of meters. It's listed as 87.74, and the time is listed between 12:21 and 10 seconds. And there's
There we go.
milliseconds after that, but I'll just round it off to the second if you don't mind. So 12:21 and 10 seconds to 12:24 and 22 seconds.
Okay. And you said that it showed 87 meters traveled during that time period?
Correct.
And with regard to that same time period, 12:21 and 10 seconds and 12:24
And the Commonwealth has said that's when he's in the car.
Please turn to page 5. And Mr. Bates, if you would zoom in on record number 2.
Sure.
I have that.
Okay. What does record number 2 reflect?
Again, it's the same time period, and the steps taken is recorded as 80 steps.
Okay, and you said
80
the same
steps
time
and
period, so again,
87 meters?
12:21:10 to 12:24:22, correct?
Correct.
All right, now I'd like to direct your attention to page 4, record number 1. And Mr. Bates, if you could post that. When you're ready, Mr. Green, if you could tell the jury what that reflects.
Sure.
Same
So
period
this
of time.
indicates 3 sets of floors. That represents elevation change. So it doesn't indicate to us up or down, but 3 steps. And the time period for that is 12:22:14 to 12:24:37.
Okay, did you say 12:21:14 to 12:22?
No,
I'm sorry,
12:22:14.
12:24:37?
Yeah, 12:22:14 to
12:22:14.
12:47:37.
I see.
To
And with
12:24:37.
regard to all of this data, the 80 steps and
He
the 3
transposed
flights of
numbers.
stairs that you mentioned, is it possible to pinpoint where within the time frame that's given those steps or flights of stairs were ascended or descended?
No, the most granular we can get is the time period, and it doesn't it doesn't signify it's any
Yes.
more likely at the beginning of the time period than at the end of the time period than at some time in the middle. And if you think logically, like distance traveled, that doesn't happen at a split moment. It happens over a period of time. So it's time is a factor in that equation, and this is how the Apple records that data. You got to look at the time overall.
Okay, so you don't know if the steps are bunched up toward the beginning or toward the end or more evenly spread out?
No, I would not be able to tell you that.
Elizabeth asked
Now-
if this
now,
is before
we
the arrival
discussed
of
the Apple
34
Health data. I wanna go back for
Fairview.
a second to talk about the location data on the
They're
iPhone.
challenging that.
Does that data that you've already talked about in terms of the arrival time that it gave for John O'Keefe's phone at 34 Fairview, does that arrival time fall within or outside the range of 12:21 and 10 seconds, or 12:20 12:21 in 10 seconds and 12:24 in 37 seconds.
Well, that certainly indicates an overlap, but the health data is ending after the arrival, and we can.
Now, I'd like to discuss with you.
I don't know what happened to that sentence. It
concept
just kind of stopped.
Used by apps on an iPhone.
Sure.
Are you aware of the 3 different clocks that are used by iPhone apps?
I am.
What are they?
I bet Yanetti's aware of them because of him.
3 separate internal clocks. You have a monotonic clock, a baseband clock, and a wall clock.
Okay, and is the wall clock also called the display clock?
Yeah, that would be also a common name for that.
And what is the significance of the existence of 3 clocks regarding, different times that may show up within these records?
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
Okay. Now, in your investigation and examination of this case, did you find examples on this phone of different clocks being used?
So in this particular case, I had reprocessed the data with the newest version of the Axiom forensic program. It's similar to Cellbrite. There are competitors to Cellbrite, and we use both programs. And this newest version had a feature in there where you can filter for the Waze application. And again, just following up and seeing how this functioned, we filtered for the Waze application. And for the first time, we saw this monotonic timestamp being related to the Waze application.
Okay. I want to show you Exhibit 640, if I may approach, Your Honor.
I want to see how he filters for
Exhibit 640 before you, sir. Do you recognize what that is?
the Waze
Yes, sir.
time data.
What is it?
So this is a screenshot from the Magnet Axiom program I was referring to. It's the 8.1, actually it looks like 4287, but
Keep your voice up, sir.
I'm sorry, yeah.
The
So
Axiom
it's the
program?
newest version of the program, and we have it filtered for the Waze app, and it's giving us the timestamps associated with it.
With the court's permission, may I publish that?
There we go.
And first of all, are you? Now that writing is probably too small. I can't read it.
Okay, thank you. I'll go off of this one.
Oh, what is over my head down there? I don't know, but
with regard to
hopefully
what
the
we are
AC unit
looking
isn't
at
kicking
there
out condensation.
On that part of the screen, what are we looking at, Mr. Green?
Okay, so this is listing details of this particular artifact, and you can see that this is bundled. The com.waze.iphone, that's a
monotonic
standard
time, baseband time, display time.
bundle type name where it always starts with com dot and then the application reference.
And what does that mean? When it says, it's highlighted on the screen, com.waze.iphone. What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right, go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the three of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that I think it's 3 minutes and
Behind.
1 second, give or take a little. So,
Oh no, ahead.
you know, in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to. Objection. We'll strike.
Sustained. I'm willing to strike that. Next
Okay.
question.
Does Waze
I
use the
apologize.
monotonic time?
So you can hand that back to Madam Court Reporter.
Certainly. Thank
And
you.
I'd like to go back to the Apple Health data, Mr. Bates, if you can put that back up. And this would be page 2, record number 3. And you don't still have that in front of you, do you?
Actually, I do.
You do.
I do.
Page 2, record number 3, sir.
He's like,
Yes,
I
sir.
do still have it. I do.
What does that show?
All right.
Stephanie asked, why can't he say that it's important?
Okay, so
the jury
this
gets to decide the
is
relevance.
another entry
It was
from
important to him.
John O'Keefe's data, cell phone data. And this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, if you could tell the jury what that shows, and if we could have that displayed as well, Mr. Vince.
Certainly. So this is directly related to the distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay. So we have 36 steps being taken according to Apple Health data on John O'Keefe's phone for a time period that ends at 12:32:16.
Objection.
Sustained. Ask it differently, Mr. Irini.
With regard to those 36 steps, do we know where within that time frame they were taken?
Sure. Let me reread that here. We January 29th, 2022, 12:31:56 a.m. It's actually 12:31:56.109 a.m. and 12:32:16.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was how long to die in cold.
We know what the search was.
And it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So that the artifact on that was called a Safari Suspended Tabs artifact.
DB.
And there's a database associated with that called the Browser DB database. And in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the write ahead log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. It's integral. It's part of the way
tab artifact.
SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that wall file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db wall file?
Sure. So the wall file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column, it was a time column. That'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long to die in cold, found in the browser state DB wall file.
We're all saying
what was the date and time for that artifact?
At this point.
Sure. So that's recorded in what's called an Apicocoa time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, but that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27 in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
2:27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah, so
Massachusetts.
the specific artifact, it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say.
Really?
And
You couldn't
I'm
find
sorry, go
Hockenbach
ahead.
Sports?
Well, no, so we definitely got the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer in it. Sanderson Forensics, which is known to specialize in this type of work, and
ArtX?
He's like, and other stuff?
I'm sorry.
ArtX?
You saved me. Yes, ArtX, which is a
not what's supposed to happen.
program known in the community for research.
But okay.
And how did
Nobody
you
objected.
sort of cross-reference the three of those together? How'd you use
He
that?
should have said you need
So
to review
all
your
three of those
report,
tools, along with Axiom and Cellbrite, which I did, they do have a low-level SQL viewer as well. So I looked at the data with all 5 of those tools, and I found it to be consistent amongst all the tools.
And in addition to using those tools, what else did you do?
So I wanted to get a little more context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So in this particular case, I wanted to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so what do you compare the 2:27 a.m. search to in order to gain more information?
I think it's misleading that he calls it the
Exactly.
2:27 a.m. search.
I'm sorry.
What the information was. So what
there's
we
no objection
found
to it,
is
and that's
that
their theory
when
of
we
the
looked
case.
at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called Knowledge C that records the user's activity, but the browser state is the very last entry
Yeah, that's what the other.
on the items that we observed.
And did you find other examples of that you can speak to?
All of the
before
experts have
jury?
said that.
Yes, I believe we have one printed out there.
Okay. May I approach, Your Honor?
Yes.
Okay.
I placed the document before you, sir. If you could familiarize yourself with that and look up at me when you're done.
I have it.
What is it?
Okay, so this is another screenshot from the Axiom program. And it is showing a search that we conducted for raining men. And then it takes that search, and we have a couple different items on there. We set the date to begin in 1970 and ending in 2100. In other words, we only wanted to see artifacts that had dates associated with them. And then we listed them from the newest date to the oldest date. And this particular one, again, it ends up with the Safari suspended tabs artifact being the very last in the series of dates and times.
All right, I'd like to go through that, but first I'd offer it into evidence, Your Honor.
Any objection?
No, Your Honor. There you go.
Some of what's hard for this witness, or at least for me for this witness, is that we have heard so much about Jen McCabe's Google search. And honestly, after the coroner's testimony this morning,
Yes.
the coroner's testimony this morning I can't tell you this was consistent with the vehicle collision. I'm kind of like, why are we still talking about Jen McCabe? So I don't know if you're there with me,
so
but
I'm gonna switch glasses.
I know the
back here,
defense
forgive me,
promised in their opening,
Do you
we're
need
going to
the
show
light
you
on,
this
sir?
cover
Or are
up.
you okay?
No, I'm fine.
But-
Your Honor.
Okay.
Thank you much. I can certainly do this. So we are looking at here web-related history, and also
At this point, I think it's
I
like
have the filter turned on for application
right, but how did
usage
John
because there's
O'Keefe
some
die?
log files, sort files that the iPhone keeps track of to record user interactions, and that can give us a idea of the history as well. And then, as I mentioned, we have it filtered so that it's only showing dates that dates existed, and we took the earliest possible date to a
So I'm
date
not,
way in the future.
I'm not over this witness. I'm
and
over
then
this topic
it's listed,
at this
and
point.
next to the date and time, you'll see a little arrow, and it's skinny at the top and big at the bottom. That tells you it's going from smallest, earliest time to latest time. And this particular view is showing us the last of that series, because what's
I will
relevant and really important here is that
the defense has done this much better than the Commonwealth at this point, which is as experts are talking through things, they're at least showing what they're talking through. So it's easier to comprehend the information. And that is, I think, tremendously helpful. I would just really like to get on to what other tech information we're going to glean.
Safari suspended state tabs ends up being the last of the entries related to that, not one of the beginning of the entries related to that.
And what is the significance of the Safari state tab being the last entry? What does that tell you?
Yeah, well, so it tells us the internet history happened before that, and
the display,
the purpose of this tab
the
on
displays in court aren't blurry. The data that they put up looked natively blurry. It was very hard for me to see too. I can't imagine that the jury can.
at least this particular iPhone with this very specific iOS version is to record the state of that tab when the user left that. And the whole purpose of that is if you're on Safari, you're on a website and say you have to take a phone call or answer a text message and you navigate away from the Safari app, when you come back, it remembers where you were and allows you to pick off from there. It also allows you to hit the tab button and see what other tabs you might have open and navigate to one of those tabs.
All right, so as I see the last...
There are times I do not find this witness easier to understand than the Commonwealth's witness, but the presentation of evidence is better, which helps tremendously. It's just being presented in a way that's easier to follow. I think. Though I did like the Commonwealth's tech experts as well. They were just harder to follow. Oh, Jesus, that's blurry. Oh my God, that's going to give me a headache, Yannetti.
I'm definitely getting a pair of bifocals.
No,
I
that's not you,
apologize
sir.
here. I feel a little silly.
No, sir, don't apologize. That's not you. None of us
Yes,
can
on
see
this particular one. So that is just moments before the Google search artifact.
I feel like I'm on a Zoom call. Like,
It's long to die in the code, yes.
But all the other history of this particular artifact was before that time, correct?
Correct.
So with regard to what that tells you about...
it's not your computer. It's not your internet. It's not you. It's them.
Was that at, after, or before 2:27 and 38 seconds?
I'm sorry, can you...
Sustained.
So what this shows, okay, I'm gonna lean in. What this shows is a last interaction daytime 1:29:22 at 2:27:38 a.m. It says web related. It says Safari suspended state tabs. It says title, The Weather Girls, It's Raining Men, and then it has the URL for that YouTube video.
Okay, well, if you say it one more time.
So that's the tab state.
Try and put it a different way. Given the timestamp of 2:27 and 38 seconds on January 29th for that Safari suspended state tab with the It's Raining Men, what did that tell you about the timing of when It's Raining Men was accessed by the user?
Yeah, well,
Was that
so
also
the
searched at
indications would be
2:27?
that tab was brought up and then went away from to do another tab. So it can happen less than a second. It doesn't take long to open up a tab and start a new tab. Can be done very quickly.
I'm not really phrasing this the right way to get what I want. What I want is the timing of the interaction with its rating and by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of that timestamp.
And that's what the Commonwealth kept saying. It's showing interactions that were prior. That is just showing when the tab was brought up. That's what the Commonwealth is saying, and that's what he seems to be saying too.
Phrasing this the right way to get what I want. What I want is the timing of the interaction with its rating and by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of that timestamp in the browser state.
All right. Now, with regard to this particular example where the browser state DB is the last entry, so the activity happened before, was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this iPhone with this iOS, do you have an opinion to a reasonable degree of scientific certainty as the
I saw the judge smiling too.
Of that search for how
Do you think she likes this
Objection.
Sustained.
Or do you think
Do you have an
chat? I don't normally do polls during criminal trials, but I'm gonna let you guys throw it in the chat. Do you think Bev is smiling because we're almost done? Do you think she's smiling because she likes this witness? Or do you think she's smiling because Yannetti has not said what, if anything, and his questioning is just easier to listen to? Why do we think Bev is smiling? Or is she thinking about what she's doing this evening once trial is done?
opinion to a reasonable degree of scientific certainty as to when Huslong to Dying Cold was searched?
Objection.
Sustained. I can see you at sidebar.
Thank you.
Oh, I should have just waited for them to go to sidebar. Bad streamer, bad. Emily, keep reading. You guys are like all of the above. How's long to finish on a Friday is what Bev is thinking at the moment. But it's interesting because her demeanor has stayed pretty much the same.
You are unmuted.
Towards the party on cross-examination, whether it was the defense or the Commonwealth.
Do you have an opinion as to the timing of that first search for Huslong to Dying Cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time.
And
that didn't explain anything.
What opinions or conclusions did you reach regarding
how did you determine it? And then he said
2:27 a.m. search
nothing.
was deleted.
Well, we know that that's in a deleted state. And importantly on that phone is I keep using the proverbial we, I found a lot of other that would have been used or deleted artifacts between midnight and the early mornings on January 29th, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know of no mechanism that would have done that.
All right. And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. Sure. MMM for identification. Do you recognize what I've placed before you, sir?
Yes, sir.
What is it?
Okay, this is from Cellbrite. It's a program, again, like the Axiom that processes data. And this is this lists out a 623. This lists out a deleted call record.
Okay. Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe. But through searching for that, the number, I was able to see that it went to, you want me to say the name?
Sure.
Yeah. Uncle Brian A.
Is that how he was saved in the phone
I
then?
would offer that into evidence, Your Honor.
Same objection as before, Your Honor. As when this was, may we approach?
Okay.
Okay, and they are approaching again regarding a deleted call to Uncle Brian A. From Jen McCabe's phone. And whether that call, here's what frustrates me. I'm going to keep zooming. Here's what frustrates me so much is that I know that this evidence can be presented more clearly based on not just my own background, but on other trials we've watched and how they've presented it. Most bring in the records from the carrier, the call logs, and then juxtapose the call logs with the download of the phone. And they're like, your Verizon record says this, but where's that call in your phone call log? Why aren't they there? Because on your phone call log, you can just swipe and delete those past calls, but you can't do that on your cell record. And then they juxtapose them. That hasn't happened here. And it is so frustrating. And I don't know why. And I don't know if they don't have.
We're trying to
oh, is she going to let the jury go? I don't know if they don't have Jen McCabe's carrier records, which might be the issue here, but it's frustrating. Are they going to give the jury a... It's only $250.
So, folks, we're trying to streamline the exhibit numbers. It looks like this may already be in evidence. It's one of 4 different numbers, so I sort of wanted to keep it with that. We are so far removed from where it was that this will just come in as the next exhibit.
The judge is
So
like,
you
this
will
has been
technically
admitted
have it in
117
evidence twice.
times. We don't know what number it is anymore. Who cares? That's fine.
Thank you. May
I
approach
rather
again, Your Honor?
have them
Yes.
have duplicates than not. I rather have them have duplicates than not.
Final document before you, if you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with a number of deleted items and number of live items.
I would offer that, Your Honor.
Meaning?
If I get to see.
Sure.
Fine, Your Honor. I think it's already in evidence as well, but.
So
Actually, it's, I confirmed it's not. It's not yet in evidence. We looked at the exhibits that were specified. So.
They're
Thank you. If you could hand that to the witnesses, if I could have.
And when you let everybody pre-mark exhibits, then they can have full, like, what are those things called? Tables of contents of the exhibits. And then we all know because they can just flip to their table of contents. Yannetti's walked away from the mic. But if you pre-mark the exhibits, ideally you then have a list that says what the pre-marked number is. So then you just flip to the list and go, yes, this was pre-marked as number this. But she told them to change it all like at the end of week 1 or beginning of week 2. So that's part of the clusterfuck with the numbers. That's not on the attorneys at all. All right. This is the Celebrate report we've seen lots and lots of. Lots of me.
Objection.
Lots of me.
sustained. Ask it differently, Mr. Yannetti.
Yes. What did you find of note?
Certainly. What was the time frame of the deleted records? Now, I'll just talk about this particular report here. It starts at 5:33:47 in the morning, and on the second page we see it ends at 8:50 and 15 seconds, again a.m. And then the normal calls we would call live.
Because I know some of you listen without looking at the chat, and chat is Bay. I lost it because there are quite a lot of you here, but Whoever said, so this is how Santa always knows where you are, accurate. This is also how Santa knows if you've been naughty or if you've been nice. So
Data
10 out of 10.
Begins at
Comment, chat.
8:59 and 34 seconds and goes on throughout the day with no additional deletions.
And am I right that that's the call log, those are all phone calls?
Correct, yeah, this is the call log.
And what was the difference between the calls that were at 8:59 and after on January 29th, 2022, and the calls that were before 8:50 a.m. on January 29th, 2022?
Yeah, well, it's the state they were found in, deleted versus live data.
I'm sorry?
Deleted data at the earlier time and live data after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please.
Yes.
I have to see counsel.
Heather, I want full Doofenshmirtz. We have watched a lot of Phineas and Ferb at my house. I don't know what's happening right now. This is not a very smooth direct examination for sure. I don't know why the judge spontaneous was like, I have to just see counsel right now. I can't. You're going to ask, what is the judge doing? I don't fucking know. I don't know.
So, Mr. Green, I'm not sure if that question was clear, or if you understood it. If it's not, please let me know. But I had asked you from the first recorded call there that was listed as deleted until 8:50 a.m. or so, what percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
Now, are you aware of the term spontaneous deletion?
No, sir. I know what the individual words mean, but in relation to digital forensics, I'm not familiar with that term.
And do you have an opinion as to how those calls would have been deleted from that phone?
Those would have been user deleted.
I may have a moment.
Sure.
Notice the Commonwealth didn't spend any time arguing about this. Or not much.
Questions. Thank you, sir.
That's it? I really thought there was going to be more. Did any of you think there was going to be more? I thought there was going to be more. User deleted calls. And the Commonwealth really didn't spend much time on the calls. They seemed to be deleted out of the phone's call log. And we saw them on the call records.
Good afternoon, sir.
Because they talked about Brian Albert's call records. And Brian Albert's call records showed the calls. And then Jen McCabe's phone didn't. I think that's how they pulled that together. But
do you know who Miss Jessica Hyde is?
I do.
Are you aware that she wrote a report in relation to this case?
Yes.
Specifically in regard to the Google searches for Ms. McCabe's phone that you were just talking about?
Yes, sir. It was very specific about that search.
And have you had a chance to review that report?
I have.
You also know who Ian Whiffen is?
Certainly, yes.
And are you aware that he wrote several reports or submitted several items in relation to, again, the exact topic that you're testifying about in relation to the Google searches on Ms. McCabe's phone?
Yes, sir. I understand that.
And have you had a chance to review those materials as well?
Yes, sir.
You understand that they both disagree with what your opinion is in relation to those searches?
I absolutely understand that, sir.
Sorry. We're trying to begin. There we go.
Now, just as far as your qualifications and certifications go, I'm just having a difficult time. From the certifications that you have, at what point were you, or what, if any, certifications do you have with reference to Cellbrite as a tool, as far as your use and interpretation of data from Cellbrite?
Certainly. So my certifications are much more broad. They have to do with a lot of the fundamentals and how we conduct the investigations and what tools we should know and when we need to know we need to do more work and such like that. Cellbrite, I do not have any specific Cellbrite certifications. They offer many of them. However, I have participated in, God, I can't even count, hundreds of their training events that they offer, both Cellbrite, Axiom, Belkasoff. They all provide the community with fantastic support as far as that. And although certainly a class can be very good, but you really need to
do it
to stay up to speed. You got to participate in the most recent understanding being put out there. Even in the changes of their tools will change from one version to another.
And so, to the point, as far as you have no certifications in regard to Cellbrite as a tool and how to use it, those kind of things.
That's correct, sir.
And in this specific instance, at any
Haley,
point,
we use them synonymously here. It's fine.
go
I'll take
over
it.
sort of your findings or your opinions in relation to this search?
I did.
And who, if anyone, did you speak with from Cellbrite?
As close as I can remember, I know it was Leo, and I believe it was Santos.
And do you know what part of Cellbrite they work in or what they do?
Well, he was in the technical support, and contacted him. He had informed me that they had elevated this up to some higher level technical
because there was
support
confusion
when they came back. His comments to me, if you want to hear them, was that this. Okay.
That's for his comments, but at some point,
I understand.
you talked to technical support. Is that correct?
Absolutely.
And they indicated that they would refer you to actually Mr. Whiffin's team.
No, sir, they did not.
And
So you weren't told that you were referred to Mr. Whiffin's team.
What's most notable to me about all of this is that Cellbrite changed their program afterwards. So these artifacts did not still reflect a time on the reports the way that they did in this case. I think of all of the tech information, that was my biggest takeaway from all of the tech witnesses.
And you weren't contacted by anyone from Mr. Whiffin's team?
No, and I forget the exact date. A couple weeks ago, maybe a month ago, out of the blue, I got an email from Ms. Whiffin saying, and I can't, I don't want to misquote them, but certainly I got an email from
I'm not asking
him.
you about any specific conversation
Okay.
that you had. What I'm asking, and I'm asking about a time period more back in 2022.
I'm sorry, I couldn't quite hear you.
Back in 2022, did you reach out to Cellbrite in relation to this search and your opinions related to it?
Yes, sir.
And at that point, was that the point that you spoke to someone from technical support?
Yes, sir.
And at that point, did someone from technical support actually refer you or tell you that they were referring you to Mr. Whiffin's team?
No, sir, I had absolutely no idea about that.
So no one from no one from Mr. Whiffin's team reached out to you, and then you just never called them back? That didn't happen?
Not that I'm aware.
Now, you were asked to look at a couple different phones, and I'm assuming by counsel for the defendant, correct?
Can you say that once again? I'm sorry.
You were asked to look at 3 different phones is what your testimony was. And I'm assuming
Correct.
that was by some counsel for the defendant, correct? No one else asked you to look at these phones,
Oh,
correct?
correct. Yes, it was from the defense asked me to. Yes.
And so the phones that you were asked to look at were Mr. O'Keefe's
Well,
phone,
when your
the
questions
defendant's
are
phone,
unclear on
and Mr.
cross,
K's
my
phone,
guy.
correct?
Correct.
Now, as far as Kerry Roberts' phone, were you ever asked to look at that?
No.
And with respect to the defendant's phone, was there any GPS location information or data that you observed in her phone?
So we had an indication that location had been using. There was something called Apple Map tiles, and those probably, when you use the Apple Map app, that it in order for it to work, it will create these little tiles or little pieces of pictures, and they get stitched together to give you the view that you see on your phone. Now, for that had to be working, we know location data had to be working. This particular location data, the location data cache, is known to only be present on the phone for a couple weeks. Now, what I don't know, and Mr. Lally, if I'm going too far, just please stop me. What I don't know is what measures were taken to preserve that data, whether it was put in airplane mode, where the location services were turned off, whether it was put in a Faraday bag. And quite frankly, Mr. Lowry, I don't know if they did all that, if the location data would have remained or not. I've never tested that, but all indications, it would have had location data on the day that it was seized, because we received the Apple Map tile. But when I got the full extraction, there was no location data there. Now, I did observe
So there was no
Okay.
GPS location data on the defendant's phone, correct?
Sorry, I was confused.
From what you observed.
And again, if I'm,
He's saying it wasn't
there was,
preserved.
I did find deleted location data from April of 2022.
Now, with respect to the defendant's phone, did you also find deleted web history data from the afternoon of
So
January
deleted
29th,
location
2022?
data.
No, I'm sorry, I didn't observe that.
Didn't observe it, or didn't look for it?
You know, I really don't have a recollection if I specifically looked for deleted data. I don't believe I did. I don't know if I would have had to have a cause to.
Now, with reference to, you were asked some question about location accuracy within 3 feet. You did.
Just for clarity on the deleted location data, he is saying he does not know if the defendant's phone had location data on, but he thinks that it would have because it had populated some of those Apple Map tiles. But if the phone was not preserved, depending on the state the phone was preserved in, it could have automatically deleted or overwritten because the defendant's phone was seized and then it had to go out. Well, then it had to be cracked with the gray key, and then it had to go out for the taint evaluation or the attorney-client privilege evaluation from the AG. So there was quite a lot of time of things that happened. And so the data would have could have overwritten and been deleted. So I don't think anyone's suggesting it was user deleted. I think it's suggested that it wasn't there, but not through some nefarious reason that it wasn't there. And nobody's really suggested that it was deleted. So that he said, based on the way it was preserved, he could not tell. But it looked like as of April 2022 that had been deleted off the phone. So
some sort of thing last night on CellHawk using that tool. Is that correct?
And that's when he got
and you were
the
asked to
report,
do
it
that
seems.
after Trooper Guarino testified yesterday. Is that correct?
I understand he testified yesterday.
And so with relation to you creating sort of that document, and that's now been marked as an exhibit, was that something that Mr. Yannetti asked you to do in relation to Trooper Guarino's testimony yesterday?
Well, in all fairness, you need to ask Mr. Yannetti. I could make an assumption here. I mean, if
I'm not.
I don't know quite. I'm not trying not to answer you, you know, but I was asked by Mr. Yannetti to perform that search.
So, Mr. Lally, please be cautious of that.
Yes, sir. So, Mr. Green, with respect to that 3 feet of accuracy, are you aware that what Trooper Guarino was testifying to in regard to that had absolutely nothing to do with phone applications or anything to do with data from phone or CellHawk or a tool or anything like that?
Now, I don't know the full extent of what Mr. Guarino would have been testifying to.
He could have been provided that information.
And so you're
by
not
the way.
aware
He's
that
an
his
expert.
testimony was actually in regard to reviewing.
They're getting into that 3 feet of accuracy. He could have come and sat in the courtroom and watched the testimony from the state's experts to rebut it and then have taken additional steps to rebut it. He could have done all of that. The thing that the court is telling Lally to be cautious of is getting into what they might have been told more about the defense conversation. So right now they're getting into why he was trying to narrow down that location, the 3 feet, which is what the state's expert said, or the Commonwealth's expert said. And I'm surprised there wasn't more of that from the defense talking about where John O'Keefe's phone was. I'm really shocked when they finished their direct that we didn't get into more of that. We didn't get into Life 360. Like the things that we didn't get into with this expert actually has surprised me. So let's continue on. But this is what did Yannetti tell you to look at, or tell you what the expert said about the 3 feet of accuracy?
Cruiser camera video from the Canton Police Department and photographs of where Mr. O'Keefe's body was, and then mapping that using GPS latitude and longitude. Objection. Based on that within a 3 feet accuracy.
The objection sustained. Ask it differently.
Are you aware of any of what Trooper Guarino testified to yesterday?
What you're mentioning, I may vaguely be remembered, and again, I'm not trying to not answer your question exactly. My conversation with Mr. Yannetti is 3 foot when it comes to GPS data. Can you tell 3 feet from GPS data? And
so that's
no, it's not known to be that reliable, and particularly Apple location services. How that applies to the trooper's testimony, I can't say with specificity.
So Yannetti asked this expert, hey, can you get down to 3 feet? Can you get down to within 3 feet of accuracy? And that's based on the testimony from the state's expert. So that's what they're trying to nail down, is what he was told by Yannetti. And so what
I'm
he
happy
was
to
basing
opine
that
on location data, though.
There's no question.
Okay.
Oh, snappy. That was real snappy. There's no question pending. He's just trying to answer the question, man. I don't think this expert's trying to offer more. Some experts do. Some experts try to throw everything in. Some of your witnesses, Lally, have tried to throw everything in the freaking kitchen sink in. I think this witness is trying to answer.
Now, sir, with reference to Safari and deleted tabs, isn't it true that there is no way for a user to delete a tab, only to close it? Do you agree with that?
Yeah, well, when you close a tab, all right, you're taking it out of the active state, and it's going to an inactive state that some people could call deleted. Now, the Safari history allows you to go in and delete history by certain date ranges, but you can also go into specific websites that you visited and delete those. Now, if you want me to continue, the WAL file itself, you can't open up a WAL file and say, I want to delete that record. But functioning the phone through the user interfaces will have an effect of deleting data within that WAL file.
Isn't it also true that Cellebrite uses that red X to annotate that the record is no longer active and has been recovered? Which would then make it incumbent upon the examiner, being you in this instance, to determine if it was actually deleted, correct?
Yes, sir. Thank you for asking. It's yes.
That's all I'm asking, sir.
Okay. All right.
Thanks for asking. I'd love to tell you, this again is cross-examination, so it's not a chance to explain more. That's what redirect is for. But this witness has been very genuine, and Lally is just like, which is frustrating to watch. This witness is like, okay. But notice he's not mad,
in your affidavit,
right? The witness isn't mad on direct. He's like, well, all right, bro.
SQLite or SQLite Forensic Explorer to examine the Safari tabs DB associated with the WAL file log. Is that correct?
Yes, sir.
Now, in your analysis using that Sanderson Forensic Explorer, was there an indication that House Long to Die in Cold was found in the WAL file?
Yes, sir.
Now, with regard to that, did you independently verify the cause of that timestamp that you observed there?
Yes, sir.
Now, is it your interpretation that the timestamp means the search appeared at that time solely based on the naming of the field in the database?
No, sir.
Now, can a WAL file contain items that are so new that they're not yet committed to the database?
Yes, sir. That's the purpose of it.
So the WAL file holds the newest information until it's merged to the
That's what he
database,
said.
including additions, deletions, changes, all of those items, correct?
That is correct.
Now, according to your affidavit, the device was in active use between 2:23 a.m. and 2:31 a.m. And just to be clear, I'm talking about Ms. McCabe's device, correct?
Correct.
And what other searches did you see at that time, and where were they performed?
I'm sorry. Can you repeat that? I couldn't quite hear you.
Searches did you observe in that time frame, and where were they performed?
Well, there were a number of websites, including the Rainy Men exhibit that we did.
Why have
there
we
was
not heard about Hockomock?
Ozone
Yes, there it
basketball, I
is.
believe. There, Hockermont, Smith. I can tell you that those similarly, the last entry with those there is the browser state DB file. It's not
For
at the
all
beginning.
of those searches.
It's not at the end. And I have a couple thoughts on why that may be in regards to Ms. Hyde and Ms. Whiffen. I'm happy to share those with you.
He doesn't want to know.
I'm not asking you anything about that.
That's
Very
correct.
good.
No, he's not.
Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
I want to answer your question as well as I can. So can you repeat that one more time?
He can't hear you, Wally.
Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
So I'm having a little trouble answering this. So if I'm understanding correctly, when the wall file gets written to the database, and could that have made the change ending with this deleted record? Is that the question? I'm sorry. I want to answer you.
He's trying to understand what you're asking.
And the question?
Sorry?
Do you not understand the question?
Yeah, he doesn't understand you.
Why don't you move on, Mr. Mallory?
So is it possible that the URL field, which has the website name, was updated to the newest search while the timestamp retained the original search? Is that possible?
No, not the way on this particular phone in this particular iOS, and also with the user interacted with it, that it would have been at the 227 or before. The way this very specific iOS was happening, that is consistent with all the other ones that I observed out there on the phone related to specific web searches and activity.
Is it possible that the search for How Long to Die in the Cold at 6:24 a.m. was the most recent search completed in the tab?
Oh, well, not in that tab, but I certainly agree with you that there was a second search done at around that time.
Now, is it also possible that the search that you assert took place at 2:27 and 40 seconds in the morning is the same as the search that took place at 6:24:51 a.m. for that same search?
Yeah, that's inconsistent with the actual data I'm seeing on this actual phone with this precise iOS version.
Now, as far as the search in Safari with the string, as far as the smotot.apple.com included, is it, you recall that search as far as being a suggestion from Apple, from the iOS, as far as the search with how long to digest food?
Okay, I didn't hear your whole question, but I heard the last part about how long to digest food. So I can opine on that. So my feeling on that is when the how long to die code was put in, that was most likely a Apple suggestion. And I've done some testing. Now, the time period I'm doing my testing, is after the fact that this would have actually occurred. But as I tested that on a live phone and using a Google search, I could see that how long to digest food would come up. I also noticed the specific phrase, how long does it take to die from hypothermia? So as you do this Google search, you try to repeat what's being done. Those are two suggestions that actually came up.
And so that was something that was a suggestion and not something that was actually searched, correct?
Yeah, no, and I know that it's different from my affidavit from about a year and a half ago, in all fairness, but
that's entirely different.
One person, Mr. Lally.
I'm sorry.
One person at a time.
Yes.
Okay. So yeah, in fairness, I want to give you my best knowledge as I understand it saying here today, including after my review of Mr. Whiffen and Ms. Hyde's report. So I want to do everything I can to shine as much light and clarity on this as possible. So as I repeated, since that time and did the search, I would notice that is one of the things that would come up, and it would have a little picture of like a dinner plate or something like that. And there was actually a similar, if not the same picture found in the artifacts of that phone.
And so just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on that day, that is what my true and proper belief was. Okay, since further testing, I have found that I now believe that was probably an automatic one, and if I've caused you any distress, I apologize.
Haven't caused me any distress.
Interesting.
What I'm asking, sir, is that that's what you filed. Because
Interesting.
that's what you thought at the time, correct?
Yes, sir.
And that opinion
Subsequently,
changed.
you've done further testing, and that's shown that you were wrong, correct?
That is correct.
Now, according to your
Interesting.
affidavit, there was a search for how long to digest food at 6:23:49 a.m. that precedes the search for how long to die, and the misspelling here would be the key CLKD at 6:23:51 a.m. Is that correct?
Yes, sir.
Now, is it possible that the how long to digest food was a predictive suggestion from Apple rather than a search entered by the user? Is that also correct?
Yeah, I don't know. I don't know the answer to that. I believe that it was, if it had picked up a earlier search from 227 of how long to die in the cold, and then you went to retype it in, it may have then tried to give you something similar at the 6:23 and 6:24 timelines. So hopefully that answers your question.
You're agreeing.
Going to Mr.
He's
O'Keefe's
agreeing with
affidavit.
the Commonwealth's witness on that without specifically agreeing with the Commonwealth's witness on that is how I take that answer, which is if you had searched the how's long to die in the snow, the predictive search at 6:23 would have been closer to that, but this predictive text at 6:23 was how long to digest food, and the state's expert used the fact that the predictive search had nothing to do with cold or die to back up her opinion that the house long to die in the cold search did not happen earlier because of the predictive test. But I don't know if that matters to anyone, because if you're still stuck on the corner being like, this is inconsistent with a vehicle collision, you're probably just sitting there going, why are we even here? It doesn't matter to me anymore. So that's this witness agreeing with the state's witness about the predictive text, which goes to indicate again that that search happened at 6 a.m., not happening at 2 a.m. And he agrees with that.
Steps
Well, agrees with the predictive
doesn't necessarily
search.
mean that someone is physically taking steps, correct?
Again, the research that's done for this is steps tend to be a very accurate artifact.
So steps could not also be coincided with, say, movement in a car or other sort of movement of the phone as far as the health data is concerned?
Sure. Well, I did, geez, quite some time ago, do some testing with an actual iPhone 11, the same make and model.
Did you throw it around
and
your
took
office?
a drive and tried to see if it would register steps. It did not. I sat in a chair and tried to duplicate how I thought I would walk to see if it recorded steps. It did not. I took the phone from the floor to the ceiling to see if it would record a flight of stairs.
Did you put it on a
did
fan?
Not. The only, with that iPhone 11, same make and model that I got, it was very consistent with me actually doing walking steps, and that was whether I had it in my shirt pocket, my pants pocket, or clipped onto my belt.
Okay.
Testimony?
That is my testimony, yes, sir.
Now, are you familiar with GPS native locations?
He's like, that
Yes,
is
sir.
my testimony.
And GPS
I
native
tried it.
locations takes its data as far as defining latitude and longitude from a number of different sources, correct?
Well, true GPS, okay, is going to take it from the GPS network. What you
I
may be
haven't
thinking
do
of
it,
is assisted
but that's why I
GPS,
mentioned
which
the
the
fan.
iPhone uses, and that assisted GPS will try to, it kind of does a crowdsourcing. So it'll look at cell towers, what's in range as far as like Wi-Fi's and a number of other devices to try to get you an enhanced GPS location and give you the best data possible.
So it takes the GPS native locations within an Apple iOS device takes from 4 different sources. Isn't that correct?
Speaking of which, I'm going to check my Pokemon eggs at the moment.
It tries to get from a variety of sources, like I just mentioned. Not all would be available.
Now, with regard, did you look at any GPS native location data with regard to Mr. O'Keefe's phone?
Yes, sir.
And would you agree then that the GPS native locations didn't record any movement of that phone after 12:25 a.m.?
12:25. You know, I would have to look at the
report
exhibit to see what the time of that last entry was. I don't want to misstate something to you, sir.
Now, you were asked about sort of the elevation change in 3 floors, ascending, descending, and saying that you couldn't pinpoint a time period or within that 12:21 to 12:24 time period from the health data. Is that correct?
Correct. It happened somewhere within that time.
Could you pinpoint more specifically if you looked at the GPS native location data?
No, well, we're talking Apple Health and GPS location.
No,
So
he said native. No, that's not what he said.
I'm sorry. Which one are you asking about? Please.
What I'm asking is, you said you couldn't pinpoint it within the GPS health data. What I'm asking is, if you had looked at the GPS native location data, could you have
pinpointed it?
Specific pinpoint as to where Mr. O'Keefe's phone was?
That's a fair question.
I'm going to allow that.
Maybe we can see briefly here.
Okay.
All right, and they're going to sidebar. So again, for the jurors, if the jurors think that the Jen McCabe Google search is highly relevant, they may still be engaged. If the jurors no longer give any of the flying fucks about Jen McCabe's Google search, then they're probably sitting there going, how long to get to the biomechanical engineers, which again, to me, after the coroner's testimony, are becoming more and more relevant after the coroner said this is not consistent with what I commonly see in a vehicle collision. So the timing of the witnesses might just be hard with this expert. I was expecting more from the Life 360 data. I was expecting that we would see more about whether
clear,
John
sir,
O'Keefe was in the house, more
you
about the step
indicated
data. Honestly, I was surprised at how short, now I'm repeating myself, the defense's direct was. So I feel like we're on a side quest that I hate.
Elevation change from 12:21 to 12:24. You could not pinpoint where in that time period, or specifically where in that time period the elevation change occurred, correct?
That's correct. It's a time range. Yes, sir.
So what I'm asking is, had you looked at that in the GPS native location data, would you have been able to more accurately or specifically pinpoint when that occurred?
Okay. So the location, are you looking for a yes or no? I'm sorry.
Yes or no?
I try. There was, yes, there was location data within that time period. Okay.
And are you aware that Mr. O'Keefe's phone from the GPS native location data was actually a half-mile away from 34 Fairview Road at the time that it made those recordings in the GPS Apple Health data?
Right. Yes, I understand he was using Waze, and it had made that recording. I understand that. That's why the finding that 3 minute and 1 second offset brings into serious doubt if that time was accurate. And when you apply that to the location offset, then the Apple Health data and the GPS all aligns. Now, I have not decoded Waze and found out what functions they were calling and all that. And I don't mean to indicate that I have, but I mean that the latest version of Axiom is bringing that up as an artifact and a timestamp related to Waze. And in the case of here, where minutes are important, I thought it proper that I bring this to the attention of the case as a possible explanation.
As a possible explanation?
As a possible explanation, sir, yes.
The 3 different clocks that you were talking about, are you aware that those are actually associated to power usage and not applications?
Right, that power usage was directly related to the Waze application.
So it's your testimony that those 3 clocks apply to the times in Waze? Is that your testimony?
No.
I'm saying that the timestamps were directly related to Waze. It was reported by Axiom when you applied the filter and say, show me all the artifacts related to Waze. These were artifacts that came up related to the Waze
Good to see you,
bundle.
JB.
So I guess you need to give it the weight it deserves.
No time.
Like I said, I've not decoded Waze. That's
Right.
Not something that has been done, but I think we need to consider the 3-minute offset as it applies to giving significance to the Apple Health data and the Waze GPS.
And again, the defense, this testimony from a Commonwealth expert would frustrate me. This is the job of a defense expert. Hey, we need to consider other possibilities, because the job of the defense is to say, yo, did the Commonwealth prove this to you beyond a reasonable doubt, or are there other reasonable explanations? So what this witness is saying to the defense, to the defense's case is, are these other reasonable explanations? This explanation, that explanation, this explanation. We need to consider these possibilities, that there is a timing offset. And that's, again, the defense's job is to poke holes. The prosecution is trying to say, no, definitively, you can't say that Waze tags its time to this clock versus that clock, which is why they are fighting so granularly in the weeds over that step data and whether it took place while John O'Keefe was in the car operating Waze a half mile from 34 Fairview or when he was closer to 34 Fairview. But it is the defense's job to say, look at the possibilities. And it is the prosecution's job to say, no, all of those possibilities aren't actually reasonable. There's but one thing. And I don't know if the prosecution has done their job in saying none of these other possibilities are reasonable. There's just the one thing. So as we hop back into finishing the rest of this testimony, I'm going to take a quick second. It was good. It's good to see our friend Hey JB in the chat and say thank you for this super chat that just got, how did it get lost in my feed from April Dawn? I'm trying to pull this up and it got, somehow, Megalina, it got unstarred from, there it is. Sorry. April said, thank you, Emily, for your excellent commentary. I'm taking you into the pool with me now. Okay, well, how's long for your phone to stop working in the pool? I'm teasing. P.S. I adore this witness. P.S.S. Have fun tonight. You deserve it. I'll tell you guys at the end maybe what songs I'm looking forward to and to seeing some friends I have not seen at shows in a while. So, community in real life. Tonight I'm with my Dave community in real life. I always love being with the Lawnard community in real life. There will be some crossover, I
Turning
suspect.
to Ms. McCabe's phone again, as far as the search.
So thank you,
which
April.
indicated as last view time. Are you aware that that is actually related to a time that it was actually focused on the screen as opposed to your interpretation of it?
This is back to Jen McCabe.
I'm aware that that it appears to be the last time and date it was focused, and when it was no longer was focused, that's when the timestamp was written. That's what's consistent with the other data on this particular phone.
That's exactly what all the other experts have said. Hold on. I'm backing it up because this is exactly what the other experts have said. So not exactly what the defense has said, but what the other experts have said. So I'm going to back this up real quick.
It deserves, like I said, I've not decoded Waze.
Lally is making some headway with this witness.
Not something that has been done, but I think we need to consider the 3-minute offset as it applies to giving significance to the Apple Health data and the Waze GPS.
Now,
I backed that up
Ms. McCabe's phone again,
because this
as far
is
as the
interesting.
search, what you indicated as last view time. Are you aware that that is actually related to a time that it was actually focused on the screen as opposed to your interpretation of it?
I'm aware that that it appears to be the last time and date it was focused, and when it was no longer was focused, that's when the timestamp was written. That's what's consistent with the other data on this particular phone on this very specific iOS.
Now, with regard to looking at this search, you mentioned that you used something called an ArtX tool. Is that
So
correct?
Yes, sir.
that's actually different than what I thought it was. I'm really glad I backed it up because what he's saying is the 2:27 timestamp is the last time that tab was focused to that iOS, which is different than what I thought he was saying, which is why I backed that up to hear it again, because he is saying the last time and date it was focused and that's when it was written, which is not consistent with what the other experts are saying. The problem is I am having such a hard time parsing it out. I imagine the jury is just glazed over, but that's why I wanted to back it up. It is different than what they were saying. He's saying that's the last time, and that's when it was written. The state has said that's the last time that the tab was moved, but other things were pulled into focus later, and that's when the time was written. So no, the way Lally asked the question means he answered it in a way that said what he was saying earlier, which is that the last time that was focused was 227, and that's when it was written, that indicating that Jen McCabe's search would have been before, not after, which is different than what the prosecution's witnesses said. But I wanted to make that clear because I don't want to be misleading as I am trying to parse all of this testimony as well. So I apologize if I caused any confusion. It is confusing. It's not you.
And are you aware that's a tool that was actually created by Mr. Ian Whiffen?
Yeah, absolutely.
So that is confusing.
And with regards to this specific issue, as far as how this data is being interpreted from the browser state DB versus the knowledge C database and the wall file and all of those, the P list and all of those other kinds of things, as far as the misinterpretation of the data has then caused Mr. Whiffen in further versions of Cellbrite to revise that so that this kind of error can't occur.
Sure, happy to answer that. So Mr. Whiffen's testing was not done with this specific version of the iOS. The iOS has been known to be changing the way this artifact works. To do proper analysis, the researcher that he is, he would need to work with that same iOS. Now, in regards to the Cellbrite question, they have two versions of the Cellbrite Physical Analyzer. One is the standard physical analyzer that's been out for several years now, probably is majority use in the community. It's a tool that takes that raw data and it puts it into human terms that we can look at and understand and write reports like you've been seeing here. So they have the Cellbrite Physical Analyzer that's out there. I believe it's 7.68, but don't quote me on that. And then they have a new version that's come out called Insights, and this operates more on a where you can put multiple cases in and that. It's only the Insight versions that they have bothered updating and no longer reporting on that time. Their current physical analyzer program, and I tested this a few days ago, still reports on that search occurring, and that timestamp. So currently Cellbrite is providing examiners, law enforcement, and people worldwide with two different versions giving two different results. That I can't speak to more than that, other than I've tested that, and I see how those programs are working now.
So my question, sir, yes or no, is are you aware that Cellbrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with the asterisk, they updated one of two programs.
Nothing further.
No further questions.
All right, Mr. Green, you are all set.
Thank you, Judge.
They're done. So they're going to be done for the day, I would imagine. Be done for the day. 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 Be done for the day.
All right, George, that's it for today.
Woo!
All right, so juries, we are going to send you home. For the weekend, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case,
End of week 8.
disregard it. We are on track. You will get this case next week for your deliberations.
You will get this case next week
All rise for the jury.
for your deliberations. Friday. What a Friday. All right. As they let the jury out, we are going to wrap up, answer a few questions, and then we're gonna
All right, why don't I see counsel regarding scheduling?
we're gonna roll. We're not gonna roll yet. I want to see if they put anything else on the record. So let me see if they do. I don't know if they will. We're gonna zoom. She has a lot of scheduling sidebars. I think she's trying to figure out when they're gonna get to closing arguments, and it looks like they are done for the day. So the jury is gonna get this case next week. It's going to be an interesting and dynamic VidCon for me. It's going to be fun. That's what we've got the app for. We're going to figure it out when this goes to the jury. So don't worry. They're going to get this case next week. How long they deliberate for is up to them. This has been a long case. It's really going to depend how much the jury wants to talk with each other about this case. So it could be a very fast deliberation or not. But it's been a long case.
Jimmy, I'll see you in there.
All right. And the judge is out. The jury's out. It's Friday and we can all go home. Just kidding. I'm not home, but we can all, well, you don't have to go home, but you can't stay here. It is the end of a Friday. So let's see if we can give a summary as best we can. Let me make sure we're not getting that crackling audio from the court. All right. Let's swoop real quick. At the end of trial day 29, the court is very confident that the jurors are going to get this case to deliberate next week. I think the defense probably only has 2, if maybe 3 more witnesses, because what we've seen today is Dr. Russell, who testified about the injuries on John O'Keefe's arm. We saw the driver of the snowplow who saw a Ford Focus parked outside of 34 Fairview, and it caught their attention because it was odd as they were plows were out and there shouldn't be a car on the side of the road, but they didn't call it in because they were giving deference and consideration to the Alberts. And then we heard from the defense tech expert. I was actually surprised that we didn't get into the weeds more. I thought that we would. I don't know if I think I'm kind of glad about that. I don't know. I'll let you know my feelings next week, but I think I'm glad. They didn't get too much into John O'Keefe's location. They did get into what steps meant and going, the 3 flights of stairs meant. And they talked a lot about the difference in time from those internal clocks that, again, we heard the Commonwealth's experts talk about, whether there was a 3-minute offset between those clocks. And for this expert's point, it was, this has to be considered, right? This expert is not trying to nail down things with certainty unless it's placing John O'Keefe clearly where the Commonwealth says he is, which he did not do. But this expert's purpose is to say we have to consider these possibilities, right? Raise the possibilities, raise the doubt of we can't rely on it being exactly what they said, because the Commonwealth has said this data is really reliable. John O'Keefe's exactly here, but also it's showing him, well, it's also showing him in the car. So is there any solid information within that? Is he a half a mile away? Is the phone going up and downstairs? Is the step data reliable? And there, again, is doubt. So with that, the jury will get to decide what witnesses they believe. If they decide that one of the cell experts makes more sense, then that's what they'll do. If they find that this expert makes them more sense, that's what they'll do. That's what they'll do. But I don't know if the jury's going to start their considerations around the house long to die in the snow Google search, or if they're going to start their deliberations with the coroner's testimony. And as we ended with that testimony this morning, the coroner said that they couldn't relate back to these injuries being consistent with what they've seen in vehicle collisions with pedestrian. And I wonder if that's going to be the sticking point for the jury more than any of the rest of this. The jury doesn't have to decide if the defense's theory is accurate. They have to decide if the Commonwealth proved their case. That is the focus and the question. It is the defense's job to raise doubts and questions. And I think throughout today, they've some done that, but the more they go into Jen McCabe, the more I see it in the chat. And I even see it for myself that I'm like, do we have to talk about Jen McCabe anymore? Because can you please tell me how John O'Keefe got hit with this car? Because I still don't understand. Can you just make that clear for me? Because it's still not clear. And at the end of the state's case, that should be clear. How did Jen McCabe, not Jen McCabe, damn it, see? This is the problem. How did John O'Keefe get hit by Karen Reed's car? How did that happen? And I don't think that question has been well answered. Do you? So that head injury, the coroner testified, could be a fall, could be a punch. The coroner testified, it could be this, it could be this, it could be this. And that's why the coroner's report came back undetermined, because the coroner couldn't say to reasonable certainty. So all of that. We will see what happens next week. On Monday, I believe we'll be getting into the 2 biomechanical experts. That will be quite interesting. The court also denied the motion for directed verdict. I wasn't surprised by that. I don't know if anybody was surprised by that. Maybe some were. Those are very rarely granted. In this case, is going to go to the jury next week. I'm excited for it. Let's answer a few questions and then let's roll. It's Friday, y'all. All right. So a lot of you have said, oh, we did not celebrate. We need to do that. Hillary in the chat said 100%. I still don't know how John O'Keefe was hit by Karen Reed's card. Yeah. And I think I don't know if I think the conversation outside this jury around whose behavior did what is different than this jury's consideration, but the jury's consideration has to start with, what did Karen Reed do? And was it proven to me? And that question still remains. I don't think the Commonwealth has made it clear. So that's where I'm at. I don't know where I sit with the defense's theory. Yes, is there behavior that raises an eyebrow? Absolutely. Am I convinced that this is beyond incompetence? Not yet. But my mind is open to that. We will see. And I'm going to keep watching. But as we dive into this case in the federal investigation after this case, maybe my opinion will change. But on this trial, what I am looking for is the Commonwealth to prove it to me. And we're at the end of their case. And their coroner, I think, was very truthful in their testimony. But the coroner has been very consistent on, this is a head injury to the back of the head. And there's many ways that could have been caused. So with that coroner testimony, what do you do if you're a juror? Do we know if the juror with early weekend plans excused themselves from the case? They didn't, or can we assume they altered their plans? We can assume they altered their plans because we did not hear, and it was not placed on the record that a juror, or at least publicly, that a juror was lost. And I haven't been online other than streaming with y'all, so I haven't seen if any of the reporters have stated that they're down to 14 jurors. But even with 14 jurors, I think they have enough to get through deliberations next week. What date is the Baldwin trial scheduled for? July 10th. Yeah. So enjoy 4th of July, y'all, and then we'll be right back for trial. Have a great time with Dave tonight. I absolutely will. I'm ready. I want to hear Drunken Soldier. That's kind of the vibe. I would love to hear Crush. It's been a minute, and it's got that like kind of dirty bass line from Stefan. I love it. Emily, are you going to go on and on about how you love bass players? No, not at the moment. I'm going to restrain myself because I'm on the internet. Amber said, you can't confuse us. They're already confused. I think we're all already confused. I'm confused. Shane says, I need to tell you about the time I accidentally had front row tickets to DMB. Didn't know they were even playing. Shane, we'll have that conversation later for sure. I have been on the rail for a few Dave shows. That's not the vibe tonight, but it takes a lot. It's work at this age to be on the rail for a show. Lori said, Zoom has entered my chat at home. Thanks for all you do. There are times Dr. B and I have different processing styles sometimes, and there are times he's talking and I'm just like, can we zoom this conversation? Or can you start with what you need to tell me and then back up to why you need to tell me so we can just do it that way? Sarah said, I don't think they understand. Yes, I don't think they understand either. That is a very good point. Silently Me said bass players are bae. Right. I mean, that's where we're at. Right now, jury members are Googling how long to end this trial. They shouldn't be Googling anything, but yes, they're probably looking at the judge being like, are we there yet? Excuse me, Your Honor. Hear ye, Your Honor. Are we there yet? Is there a time limit for closing arguments? I think both sides will have a lot to say. We have not heard what the court will do. Generally, the courts will ask the parties how much time they need and then make that determination together and try to give them equal time. And then the prosecution will divide that up because remember, for closing arguments, it is the prosecution, then the defense, then the prosecution. So they normally break that up. It was always a hard question. They're like, Emily, how much time do you need? I'm like, I don't know how much time it takes. Time is a construct. What do you mean, how much time do I need? I don't know. But I didn't have closing arguments that lasted hours and hours and hours. A jury doesn't need that. They need you to make it simple. And I find it simple to say, I would like to see a closing argument from the Commonwealth that says, how do we know that Karen Read hit John O'Keefe with her car? And then they go through what they think shows that. And then they go through the elements of the crime. And then that's it. Stephen said the nerve for him to bring up nefarious intentions and perjury when your very own witness, in my Kim Richards voice, let's not talk about what you don't want out. I'm heated. Yeah, for Lally to be like, sir, isn't that what you put in your report filed under penalty of perjury? He was trying to have a gotcha moment that I don't think gotcha'd, because you put Proctor on the stand. So we've all seen the see you next Tuesday of it all. So this witness saying, yeah, and then I did more testing and changed my mind after that was filed. And you know what Lally didn't follow up with? Did you file an updated report? Because I wonder if he did. But the witness said, if that caused you any trouble, I apologize, but I did further research based on what your experts said, which is what experts do. I say this, they say that. Oh, they say that? That's interesting. Let me find out that. And let me go take a look at this. That's their job. Courtney said Lally had implied that it was improper for Dr. Russell to review the other records. We have you to tell us that it's totally fine. Is there anything the defense can do to make that, make sure that is clear to the jury? I don't know if it even needs to be at this point. So Lally is trying, look, the job on cross-examination is to try to, as Alan Jackson said early in this trial, do the damage you need to do. Because Alan earlier said, I've done the damage I need to do to Jen McCabe. So that's the job on cross. I just don't know if they care at this point. Let's see. Casey Cat said, can you imagine being so cold-hearted that you would take a dying man and leave him to die in the cold? And what your moments are like when that's happening and his. I can't imagine that. And I don't, again, that, Casey Cat, to your point, goes against the responses of Karen Read. The clearly distraught responses of Karen Read. It just, that behavior goes against how she responded to it. Does it go against dropping somebody off drunk at somebody's house and not knowing what happened to them afterwards? No. But it goes against the fuck you stay there then. I think it does. I think it absolutely goes against that. But the prosecution's not trying to prove that she backed up her car and he jumped out of the way and slipped and she left. That's not what they're trying to prove. They're trying to prove that she said, I'm going to hit you with my car and then I'm going to leave you in the snow. That's what they're trying to prove. That's their main case. Level of distraught doesn't seem to square with that for every case I have seen. Mama Cat said, is Dave expecting you? Probably not. Not personally, though some of the members of the band do follow me on a social media app that I don't use very much anymore. And the reason I haven't deleted it is because of my delight that they follow me on that app. Niffer, thank you for the gifted memberships. Luna, question, could they not recreate the search time scenario to demonstrate and prove one way or the other? Luna, the prosecution's expert did that. He demonstrated it in court. And the way he demonstrated it made sense to me. He did a live, the Celebrate guy, Whiffen, did a live demonstration in court about how the tab files work. I think the prosecution was very effective with showing that search time. But at the end of the day, I don't know if it matters for the jury. I just don't know if it matters for the jury with the other evidence. So I don't know. I don't know if it matters. You guys tell me if you think it matters. I just want to know how much it matters to you, because the main focus for me is still, I can't wrap my head around how this happened the way the Commonwealth said it happened. Jenny said, I'm right there with you. I feel like this gentleman has so much knowledge, but I'm having a hard time keeping up. I love him, though. He's adorable and has a sweet smile. And I think generally the takeaway is, oh, I liked that expert. Can we move on now? Can he say when and where the Google search took place? No, nobody has said where. There is much fight over when. And part of the reason there's so much fight over when is because the phone wasn't, Jen McCabe's phone wasn't downloaded till later. So Anyway, all right. If I did not get to your super chat, I apologize. I will be in a different space on Monday. All of you have a Casey Cat said no, I mean the Alberts, McCabe's, and Hagans leaving him outside. I don't know if I don't know if that makes sense to me either. Really, I want to see the rest of the case because my focus has been, and my thought process has been, how did Karen Read do this? Because that's what we're on trial for. So I haven't spent a lot of time pondering what else could happen because I am trying to focus on how did this happen the way they said it did. But I will, as we get into the investigations into this case, I don't know if the defense theory of the case is correct. I don't know if the prosecution has proved their theory of the case. I think it's not easily reached, the prosecution, especially given the coroner testimony. I just don't know how you get there. The coroner testimony is really tough for the Commonwealth to overcome. But I also can see a reasonable, when the coroner is like, this could have been somebody who slipped and hit their head. I think there's a reasonable middle ground. And I think that's the problem for the prosecution. There are multiple reasonable explanations for what could have happened to John O'Keefe. And that leaves the jury with questions. And questions in this scenario equal doubt. So I owe all of you a celebration. We reached 775. That's exciting. That road to $1 million is very, very exciting. Even though, it's, for me, it's not the road to $1 million. It is the fact that we have like 40,000 law nerds here with us every day watching trial and having a conversation about the facts of this case and the questions and the questioning styles that annoy us without name calling people, and being able to have conversations, even when we don't all see this case the same way, to be able to say, but could it be this and could it be that? And how is the jury going to decide? And I appreciate that. Law nerds, you're the best. Let's celebrate real quick.
Binged.
Move your head. And with that, y'all have a great weekend. Thank you for being here. Thank you for being a law nerd. If you are at Alpine tonight and you see me running around in my black fax hat, please just yell EDB at me so I can give you a hug, and I will see you.
You can stay up to date with everything.
Bye. It's a Friday.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.